Yes.
My lord, may I have a lordship and leave to mention one matter. Item number 79. Under extreme compulsion, I am mentioning before your lordship. My lord, matter not raised last 3 weeks, my lord. My lord's honorable single judge has been directed. Please
Why
to
could you
direct.
break the serial? Others are also waiting.
My
Why
lord,
should you break the serial and do how at
penalty
least your
has been
client
imposed
patient?
10 lakhs
No,
without
in other
giving.
matters also several similar things have happened. So we
My lord,
can't really, we
any
won't
day.
jump the queue. Sorry, no. Yes.
Yes, my lord, may I have your lordship's kind leave to mention one application arising out of an
Yeah.
WPL article?
Yeah.
Upon
May we permit to mention a matter? It's an application in connection
Please.
to first step.
An application in case of first step.
May I be permitted to mention,
Yes.
Your Lordship, one restoration application?
Yes. Hand over.
I'm grateful, Your Lordship.
Look. In view of the above discussions, FMA 1329 of 2024 is allowed on contest, thereby setting aside the impugned judgment dated February 23, 2024, passed in WPA such and directing the state authorities to proceed on the basis of the vacancy notification dated July 17, 2019, from the stage where it had reached at the time of passing of the impugned judgment. COT accordingly dismissed on contest. Can 1 of 2024 stands accordingly disposed of. No orders to cause urgency. Sorry. Yes, thank you. In view of the above, MAT 835 of 2025 is allowed on contest, thereby setting aside the impugned judgment dated April 2, 2025, passed in WPA 7296 of 2025, and restoring the decision of the revocation of the FPS dealership license of the respondent by the SDO, video memo number such and such. Can is consequentially disposed of as well. No orders to cause urgency. It is a bad day.
Bad day for his client, not for him.
No, he understands. Grateful. Anyway, come to better question. Assignment of tradition. Yes.
I for the appellate. Application under Order 22 Rule 10 has been allowed without, my lord, being raised the objection. What is the terms here? That somebody filed a suit for a declaration that he is the sole trustee.
And may I intervene for a moment, my lord? But this is a very old matter, my lord. But all the papers are not available.
No, Mr. Banerjee, at this
But I understand, my lord.
No, at this stage we won't.
But this is the first time I saw the
No,
paper.
no, this is appearing for quite a long time. We can't reach these matters, so we put it in the list from yesterday that Tuesday these matters will be taken up. No further time. Yes.
But at least, my lord, I
No,
could
Mr.
have-
No, Mr. Banerjee, no.
I will rely on plaint only and the application.
Yeah, the suit was filed for?
Suit was filed for declaration that the plaintiff is the trustee of a trust. The trust deed, plaintiff, defendant, all are relying on the same trust deed. An application has been filed under Order 22 Rule 10, claiming that he has been appointed by the trustee by the plaintiff, who is not, whose declaration is also pending. He has been
claiming through the
plaintiff that he is the trustee, and that has been allowed.
He claims that he has been appointed during the pendency of the suit, or
during the pendency of the suit, which he, my humble submission, he cannot appoint. Even if I admit the everybody's case, then also in terms of the trust deed, existing trustees will appoint the trust. Kindly come to the 4, 5. Oh, we are for the 5.
It's all right. Arising out of the same suit. Item 4, my lord, it's my learned friend's appeal where I am appearing for the same client, my lord. But it's but arising out of the same suit.
Both are challenging.
No, my lord. One, my lord, injunction order refused where my learned friend had appealed. That is item number 4.
Right.
And my lord, thereafter, Order 20 Rule 10, my lord, where my learned senior.
That is item
I'm
number sorry, man.
That is item number 5 arising out of the same suit, but since they same my learned senior friend, my lord, makes up.
Parboti Charan Rokit is your client.
Yes.
So you are challenging an injunction order.
Yes.
case.
Refusal of injunction.
Refusal. What is the matter? What is your matter?
এইটাই ভালো আগে ওটা।
No paper books were prepared in this matter.
So far, 5 is concerned paper book prepared.
Paper book koi?
And a supplementary paper book also, my lord.
Hearing matter paper book আসে না।
তুই চলে আয়।
Ha, memo of appeal. Well, the order impugned in item number 4 is dated. My lord, is dated 31st March 2005.
4 is Bhagavati Charan Rokit suit, appeal.
My lord,
Bhagavati.
Bhagavati Charan Rokit is the father of Parvati. Bhagavati died during the pendency of the suit.
Well, that's order is 31st of March 2005. Civil Court's order where
No,
injunction is-
you are Parvati Charan.
I am Parvati Charan now. Initially, I was appearing for Bhagavati.
Understood. Well,
Yes.
not Devi Charan Rokit's appeal.
No. Devi Charan are the other trustees.
Very well.
Only thing, my lord, if my learned friend has filed a paper book, there's no paper book with us. We have also got the brief after some.
So we'll follow the impugned order and the annexures to
The
the.
impugned order is there
Yes.
in the memo of appeal.
Yes, what is the suit for? The same suit.
Same suit. Same suit.
My lord, same suit. My lord, this is a suit for a declaration that the original plaintiff Bhagavati was a trustee.
Right.
He is the principal trustee, number 1, to the trust estate of Durga Charan Rokit. My lord, and he is entitled to participate in the day-to-day proceedings of the trust. It had a charitable angle also. My lord, they had properties in Kolkata and in Chandanagar. My lord, all the properties were guided by the provisions of the will of Durga Charan Rokit. There was a specific scheme given in the will of Durga Charan Rokit how trustees are to be appointed. Regarding that, there were several proceedings, there were several suits and all. Ultimately, there was one order from the Honorable Supreme Court where the scheme as provided in the will that was approved of Durga Charan Rokit. What had happened is this gentleman Bhagavati Charan Rokit had grown old. He was more than 90 years and they were not allowing the other trustees, Devi Charan and another, his name is Amiyo Charan Rokit, they were not allowing him to participate in the proceedings of the trust. What the Bhagavati Charan did, as per the clauses given in the will, he appointed one of his sons. He had 4 sons. Parvati to be a trustee in his place, exercising his powers, and he retired from his trusteeship.
So did he have the power to do that?
Yes,
According to you,
yes.
must
Malad, I will show that, Malad.
He appointed you trustee regarding his part of the trust, or he was
Yes.
not the sole trustee.
No, not the sole trustee.
Didn't the scheme provide that all the trustees have to be unanimous on appointment? There is no such thing.
No.
According to
Malad, the
this.
retiring trustee had the power to appoint the new trustee. Village scheme ta ekটু বার করে দে না।
So you have been substituted in the suit after his demise.
Order 22, Rule 10 has been allowed.
So they are challenging that Order 22 Rule 10 only.
No, Malad,
Some
what
other Order 22.
yes, Malad kindly appreciates what has happened. Bhagavati appointed Parvati.
Yes.
That Order 22, Rule 10 was allowed.
Huh.
Along with that, Malad, the other 2 trustees, they came up with another application saying that we have appointed another person in place of Bhagavati Charan Rokit. That was a subsequent document. The learned trial court, Malad, allowed both the Order 22 Rule 10 applications. Malad, this is the impugned order before your lordship, Malad. Both have been allowed.
So you are challenging the other order rule 10s and they are challenging your.
Yes, but that's the same order. The same order by which both were allowed.
So at least one should go because both cannot reconcile with each other. If Bhagavati was removed, then you don't.
Bhagavati had retired.
No, they say that Bhagavati was removed and to others.
Removed.
No, you said.
But no. Bhagavati had retired.
No, you say that the other. What is the other's case regarding the other order to rule 10? What is their case?
They say that they have appointed somebody else of
So
the
nothing to do
family.
with Bhagavati.
Nothing to do with Bhagavati. They say that we have appointed somebody, but he did not retire. His name was Pranab Charan Rokhi. I mean, namta bhul bollo, ekটু bolo please.
Pranav was the person who
Was appointed by the other two trustees. That
so
is,
if Bhagavati could appoint you, why couldn't they appoint somebody?
Malad, that is the question to be, Malad,
What is your answer to that?
Malad, because Bhagavati during his lifetime exercised his powers, Malad, by retiring from the trust.
So without retiring, you say that if
Malad, my submission would be without that retirement.
So they remain at the same time,
They
they appoint
remain
somebody else.
And they appointed somebody else, saying that Bhagavati has grown old, Bhagavati cannot perform the duties of the trust.
Is there a provision for removal in the trust?
Milord, I am very sorry, Milord. I have everything, Milord. These are in a very scattered condition.
Trust deed you should have at least.
Trust deed I
If
have.
the matter is appearing
Milord,
in the list.
Yes, the trust deed
Where
is
is the
there.
trust deed? Let us see the
Milord, it
trust
is
deed.
a part, Milord. It is, Milord.
Let us see the trust deed. It's
Yes, Malad,
part
it
of the
is-
injunction application.
Milord, it is.
Can I hand over a copy?
No, he requires also because he has to find out.
কোনো অসুবিধা নেই।
You can hand over the copies for us and he'll find out his own copy.
But these points, my lord, in the improved order has
Eh?
not been touched at all. Mechanically, my lord, both the application has been awarded. Which now, my lord, really, this is the query of the court.
আমাকে একটা copy
It has
দিন।
to be. But that point never touched. Can you see the order input once? One application, this application, both are allowed. That's all.
Imperial order.
So Mr. Banerjee, then we should see the impugned order first and then go back. That
Lordship.
will be easier for all of us.
Lordship. But I am not prepared with these documents. This is my predicament, my lord, for this day.
No, we cannot grant it.
But I am ready with the facts of the matter.
Appearing for sufficiently long, these matters have been added in the list. These are appearing in the
But
list.
I
We
would
cannot
have,
add other matters every
But
day.
I-
We are refusing.
but I would have
First
required,
matter in the list, specially fixed.
but
We
I would
indicated
have,
yesterday.
I would have required, my lord, only 1 day's time, my lord,
No.
just to assimilate what I have.
You have had that time.
No,
The moment the matter is appearing, Mr. Banerjee, you know you are in the matter. You must be prepared.
my lord, there was
Must be prepared.
difficulty, my lord.
And you are
Otherwise,
the appellant. So all the more so.
Dr.
31st of March 2005 is the impugned order.
It is my order number 12, July 10.
In item 4, that is the impugned order, 31st of March 2005. That's the injunction. Order 20 rule 10 টা হচ্ছে 2000.
I think 5 should be hard fast.
Item 5 should be.
Mr. Banerjee, sort out your papers. Let us hear Mr. Basu first because the basically same order is challenged. So Mr. Basu, you start.
না, না, আমি
But kindly see the impugned order. I will not place nothing else. This order cannot sustain, my lord, even for a single moment.
They are challenging the same order.
Yes, second part. So both the application as well out.
Where-
Without, my lord,
Whereas second, the one-page order.
yes, only one page.
Let us see the
My lord has the paper book, page 35.
No paper book you don't have,
Don't have.
unfortunately.
Kindly come to order dated 12 July 2010.
Yes, we are there.
So kindly read this. Application under order 22 rule 10, filed such and such Parvati Charan. Another petition is filed by another party or such and such. Both are taken up for consideration. Heard the land lawyer. Fact remains that the original plaintiff appointed a trustee by a registered deed of appointing Parvati Charan Rakshit, where Pranab Charan Rakshit being appointed as a trustee by the defendant 1 and 2. In both the cases, there is appointment of trustee by 2 separate deeds. One by plaintiff number 1 in favor of Parvati, and second is Pranab. But considering the status of the 2 trust deed, one of the plaintiff and another the defendant, in the circumstances, the status of the present applicant shall be accordingly as plaintiff and defendant, and both are allowed. The contest has no, it as if there is no contest.
What was your contention against
My
their
contention
addition?
is that kindly come to the plaint. What is the suit for? I'm just placing for my lord. Page 15 is the prayer. The prayer in the plaint is a decree for declaration that the plaintiff is the principal trustee in respect of the trust estate of Durgacharan Rakshit and is entitled to act. This is his prayer in the plaint. If today his right to appoint a trustee is given a sanction to the court, then suit decreed. Because it's order 20 rule 10, not thereafter he died. Normal.
But Mr. Banerjee's client claims through Bhagavati. Now, whatever right Bhagavati had, one cannot give more than that. If Bhagavati had no right, because
He is saying so.
the suit will then fail because somebody has to be.
No,
Now Bhagavati is no longer there.
Thereafter he died, so normal representative he can be added, but not under 2210. Am I clear to my lord?
Yes, but suppose I create an interest in favor of somebody.
Yes.
There may be some defect in the creation of interest.
My lord knows in this 2210 sale during the pendency of the proceeding, sale affected.
Primarily
The court
transfer.
see the sale deed
Yes.
and then say yes, your right to transfer to.
But Order 20 Rule 5 is also there, but that pertains to mostly Order 20 Rule 9.
Right.
But there has to be a prima facie adjudication.
Adjudication has to be there. As if, my lord, if this is allowed.
But that Mr. Basu would tantamount to deciding the main suit because that is the subject matter of adjudication. Then the court has to adjudicate the rights of Bhagavati and declare the title of Bhagavati before adding them.
Today, my lord, situation has been changed because of the death of Bhagavati.
This, yes.
Bhagavati died now, so
automatically Parvati comes in as son.
Can be substituted.
But then one thing can be done that he can be
substituted, normal course,
not substituted as Order 20 Rule 9 and his rights vis-a-vis the trusteeship will be decided in the suit.
But 2210 is allowed, then his right to be.
Now, then we have to modify the order and say that.
Yes, can be done.
Because in any event, he has to come in now.
Now he has to come now. When the
we can say that
10 was filed,
yes.
then he was alive.
And you can end up because there is no adjudication. Did you file a written objection to
yes.
2210?
Yes.
There you took this point.
Nothing, well,
and also regarding their objection, which they are saying, they must have taken that also in their objection. Did they take this objection to the other appointment?
Yes.
Defendant numbers 1 and 2 also
saying that you have no right to appoint.
No, if you don't retire, you don't have any right. So what is your
my contention is he, for rightly or wrongly, he was prevented from participating in the trust, as the case made out in the plaint. He is claiming his right to be established in the suit as a trustee.
No, suppose Bhagavati does not have the right even then. But independently, your right also has to be considered. Defendant numbers 1 and 2. You are for defendant numbers 1 and 2. Now, their right also has to be considered whether, while remaining themselves, they can add other persons as trustees.
That is they are defendant there. It is a plaintiff suit. He has to succeed on his own footing.
No, but you are the one who is wanting to add the other person. We are on the
the defendants.
The defendants also made an application on Order 20 Rule 10.
My lord.
So you have to independently stand on your case regarding that Order 20 Rule 10. Plaintiff will consider. But you also have to show us that the trustee permits you to appoint trustees while you are still there.
Yes.
You can appoint in your place.
I start with this, that this order cannot be sustained because no adjudication is at all there. At least prima facie court has to come to a conclusion that yes, there is a transfer of right. There was a right and that has been transferred.
Mr. Banerjee, then we can set aside this order on that ground. We'll record your objection to their application and vice versa. And we'll send it because there is not a single line of adjudication on this.
Yes.
But regarding his addition, Mr. Basu, we can do it right now.
He can be added.
We can do it right now. We can say that his impleachment will be deemed to be under Order 20 Rule 4. And his rights regarding.
Would you lordship do that here and now, or you will send back?
He gets a remedy in a different way.
Court will have to file an application for substitution.
No, but in any event, we'll treat that application as we can treat that because
now
otherwise
delayed.
Now there's a delay.
So that
now there's a delay. He has to overcome that. Order 20 Rule 9. But delay is not due to his fault because he has been added by the impugned order. He is now a party. All along, he has been a party after this order.
This order, my lord, is well aware. 2210 and 2229 is absolutely different footing.
So we can say that regarding your, so you will be in a disadvantage. We'll say that their addition, we deem it to be under Order 20 Rule 4. And their rights, regarding their rights, it will be open for you to argue whether Bhagavati had the right to appoint them. But regarding your addition, we have to remand it to the trial court.
In that event, both can be sent.
But
If
both are not on the same footing in the sense, yes, you have absolutely, you are justified in arguing that this was not
Bhakti
considered.
was also no right. He
But in
cannot
any event,
transfer.
he has to
He-
be a
no,
party now.
now he accrued a right to be impleaded in the suit as a plaintiff.
And his rights will be decided whether he has a locus standi or Bhagavati had a locus
I
standi.
have no problem. Yeah, give me 1 minute time. Kire,
But I would invite your lordship's
ওইটাই করে
attention
দাও, এটা চলে
to
যাবে।
page number one.
So the order is
I
sufficient.
understand the
There
order.
is no adjudication.
Absolutely.
Ideally, your adjudication
Not
should also be
absolutely.
there.
My lord, absolutely. But for a moment, my lord, kindly comes to page 151 of the document that has been handed up to your lordship, my lord, by Mr. Basu. And that is
151.
the that
Oh,
is
there is
the
numbering there. Some other document is taken. That's why.
Acha.
there was a book from this. My lord, kindly see fourth line. My lord, this is the scheme. If anybody dies or anybody retires, how subsequent trustee is to be appointed.
But this question has not been adjudicated at all by the trial court. That is a difficulty.
Yes,
Mr. Banerjee.
my plea.
We will become the first forum which is adjudicating that, which
Malad-
will take away one forum from
Malad-
them or
Malad-
you.
Malad, absolutely, my lord.
That is the only difficulty we are finding.
But then the order, my lord, has to be set aside and
Set aside and send back.
yes.
And ideally, your addition was also to be scrutinized by the trial court but we can do that because you are in any event you are entitled under Order 20 Rule 4. We'll say that your addition is deemed to be under Order 20 Rule 4. We will set aside this impugned order, but rather we'll modify the impugned order to the extent that we say that your addition is under Order 20 Rule 4 and your entitlement to
Continue.
continue, not to continue even, your entitlement to have been appointed as a trustee in the first place, that will be considered at the time of trial by the trial.
No, in that event, he will be stepping into suit of the plaintiff. What the plaintiff will
As his
prove-
heir.
Yes.
We'll say that.
Right.
As his heir, he is
So
stepping
that's
into
why
the shoes.
he has to substantiate his case as a plaintiff. Whatever
Yes, yes.
prayer he has made.
Exactly.
No, I have no problem. Only thing, my lord, whether lordship will here now add him or the proper course has to be taken. Because now it is
He's
died in 2008.
then we have to set, if we set aside the order, then we will have to say that in the event, but that will
No,
be
I
a
don't judge
futile
the
exercise.
fact is up to my lord.
That will be a
If-
futile exercise.
if
Mr.
they
Basu. As
died
far
in
as he is
2008.
concerned. Must be after his addition as a party. His addition as a party.
No, addition
Must be after that.
Can you see the impugned order?
During his lifetime, he was appointed.
Yes, that's why 20 to 10.
That's why it 20. So therefore, we'll say that this addition we constitute now. In any event, he has to bear the flag of the plaintiff.
Yes.
No, the order was passed in 2010.
Maybe, but the transfer must have taken place during his
Exactly.
lifetime, and he
That's
must have
why
applied
2010.
also during his lifetime because the plaintiff applied.
Plaintiff applied.
Therefore, he was alive.
Yes.
Must
Certainly.
have been alive to apply.
Otherwise, 20 to
Couldn't have
10
applied.
will not come.
Dead person cannot apply.
20 to 10 will not come.
Exactly. So therefore, we'll say that we deem his addition to be under Order 20 Rule 4, and the question of his entitlement. He now canvasses the case of the
Well, my
plaintiff.
lord is thinking of if today the order is set aside and my lord suit abated.
Not yes, exactly. There will be nobody to contest this.
That's what I'm saying.
That is the
Suit
difficulty.
abated. But he has the
The
remedy.
peculiar situation.
He has a remedy to file an application for setting aside amendment because
He's already on records. He did not have that option till now.
that my lord is thinking of setting aside this order.
We'll set aside we were thinking about that, but we have to, because he in any event has to canvass the case of the plaintiff now.
So then procedures are
There will be
there.
nobody to oppose this.
Procedure is there. How he has to do it?
No, your
He has not
application
done that.
cannot be opposed. There is no plaintiff. If there is no plaintiff, nobody can oppose your application technically, because unless who will oppose your application?
No,
He's not the plaintiff.
No. What I'm saying,
Propose that it,
what
but
I
you
am
cannot
submitting,
oppose.
my lord, kindly consider that. If you will set aside this order, then this suit will be there. Suit will be there. Abated suit. He has to file an
There will
application.
be no suit then in the IOP.
Abated suit. Suit abated.
What is the meaning of that? Abatement is automatic.
Coma, not dead.
Automatic.
Right.
Not
That's
coma,
why he can.
automatic. It terminates unless.
A person can apply for setting aside amendment.
Why go into that complexity?
Very good.
I mean, it will delay matters
Very
for
good.
all of you.
No one.
Trust property will suffer.
No problem.
Trust property will suffer.
No problem. But kindly pass that.
But
We'll do
this
that.
would be disposal of one appeal.
Both the appeals.
No, the other appeal is in respect of the injunction matter.
Now, Malad, this issue as to whether at all when his substitution as Order 22 rule 4, whether that appeal will have possibly some bearing, because their injunction was refused. when
Here you are challenging what?
Injunction.
Injunction order.
Refusal of injunction order.
Refusal.
Then you have not challenged this order of 2210.
Yes. That is by no.
Then
Oh, I have been told, my lord, they
Yes.
filed a divisional application that has been dismissed. Not rightly dismissed.
so therefore they have not preferred in
No,
challenging is
I have preferred this. And they have challenged the refusal to grant the injunction.
That's
If
the-
this order goes, there is application for
But
injunction.
on
also
order
goes.
14 rule 33 we can look into it.
My lord,
On order 14 rule 33 Mr.
if
Vasmi.
my lord's hands are long enough, lordship can do.
Even not if not challenged by the respondent, then also we can
Yeah.
pass a decree in favor of the
No, I've been
applying
told,
the same
can you
clause.
consider this? I've been told that has been challenged unsuccessfully. I am
That-
not,
Unsuccessful means because the revision was not maintained.
I don't know what is the order there. I have not seen that.
Must have been. If you say that there is an order, you have to show that order. Also.
Yes. I have not seen personally. How can I see?
So let him show it.
Achhe.
You cannot
So
act on
if
thin air.
this order goes, then my lord, his application cannot be there for getting injunction.
was filed by the original.
No, but still, if he steps into the shoes of the plaintiff, that issue is alive. Walkover is a thing, Mr. Basu, which courts are allergic to. You know that.
Problem with the judge.
All courts have been traditionally allergic to walkovers.
So I know that. I know that.
Now we
At
are
least
changing.
who are this side?
Yes, obviously. No, now the days are changing because people are no longer allergic to walkovers. Has he got a copy of
Other
the?
Justice Bhattacharya is not saying anything, but he is on the same view.
Has not taken a view.
And normally he even dare to smile even. I don't know why.
Yes. If rejected on merit, we will say that Divisional
it.
Court did not have jurisdiction.
Oh yes. Liberty is given to the present petitioner to take appropriate steps. In that case, period of limitation should be considered favorably, not challenged. So this right which was there by the court,
There is no challenge by him to this.
not taken steps.
Then we will resort to order 4130.
That your lordship can. I am not. I cannot stand in the way. But this is the fact situation where my lord, he cannot do anything, and there is no waste, nothing. In that even I could say there is a waste by the trustees. Then court is the guardian.
Now, so we are we were hearing till now Parvati Devi Charan Rokhit's
My
FMA 565.
yes.
What is the can to?
কি করেছিলি কেন করেছিলি
ক্যান্টুতে হচ্ছে সামুদ্রিক 5 আর 6 টেনেন্ট ওরা বাড়ি ছেড়ে চলে গেছে।
Oh, that is for some other purpose. There are tenants, they leave the premises that should not be encumbered on this. That may not be German now. When your mercy
That
is
was an
proposed-
interlocutory application. We will dispose it of
when
consequence.
my lord is proposing to
Yes, yes.
set aside this order, this may not be German.
তোমাদের অ্যাপ্লিকেশন না আমাদের
আমাদের application.
আছে, তোমার কাছে কপি আছে?
So you are deciding the first. আচ্ছা FMA 565 of 2011 তার সঙ্গে আচ্ছা ঠিক আছে তুমি ওই
পরেরটা।
একসঙ্গেই তো হচ্ছে তো FMA 565 of 2011 is taken up first for hearing. So next para, the present appeal arises at the instance of a defendant in a suit filed by one Bhagavati Charan Rokit বানানটা দেখে করে দিও ROQEYTTE
চরণ
Hand over the plaint.
চরণটাও হ্যাঁ
Necessary. Plaint is necessary.
yes you can hand over, you just quote the declaration.
My note is there, my lord.
Thank you. For declaration that the plaintiff within bracket Bhagavati is the principal trustee in respect of the trust estate of Durga, Dourga, Choron, CHORONE, Rocket, ROQUITTE, TTEE, and is entitled to participate in the management of the trust properties, including the said premises, comma, including collection of rent, comma, induction of tenants, comma, accepting surrender of tenancies, etc., comma, for a declaration that defendant number 7 is not the recorded tenant in the said premises and is not entitled to occupy any portion of the premises, and for permanent injunction in aid of the said primary reliefs. Full during pendency of the said suit, comma, the said Bhagavati Charan Rocket, within bracket since deceased, bracket closed, allegedly appointed one Parvati Charan Rocket, PARBOTI, comma, his son, comma, as trustee in his place, upon himself retiring as a trustee. Full stop. Next para. On the strength of such appointment, comma, an application was filed by the plaintiff for substitution of the said Parvati Charan Rocket under Order 22, Rule 10 of the Code of Civil Procedure. Full stop. Next para. By the impugned next para, simultaneously, comma, defendant numbers 1 and 2 had also allegedly appointed strangers to the suit as trustees and had filed an application for substitution of the said appointed trustees, comma, also under Order 22, Rule 10 of the Code. Full stop. Next para. By the impugned order, comma, both the said applications were allowed, comma, thereby directing substitution of Parvati Charan Rocket as well as the appointees of defendant numbers 1 and 2. Full stop. Next para. Learned senior counsel appearing for the appellant in FMA 565 of 2011, comma, that is defendant number 1 in the suit, comma, argues that the impugned order is devoid of a single line of reasoning. Full stop. The learned trial judge mechanically allowed both the applications without adjudicating the specific objections taken by the defendants. Full stop. Next para. It is argued that since Bhagavati Charan Rocket himself had filed the suit for declaration of his trusteeship, comma, the said trusteeship was itself in a cloud, and as such, comma, the said plaintiff could not have appointed a further trustee in his place. Full stop. Next para. Also, comma, on merits, comma, it is argued that the said Bhagavati Charan Rocket did not have any power under the deed of trust, under the settlement deed, to appoint trustees. Full stop. However, comma, these points were never considered by the learned trial judge while mechanically passing the impugned order. Full stop. On such ground, comma, it is contended that the impugned order ought to be set aside. So next para, learned counsel appearing for the for Parvati Charan Rocket, comma, the respondent, comma, submits that in the meantime, comma, the said Bhagavati Charan Rocket has met his demise, comma, leaving behind Parvati Charan Rocket as his, you are the only heir, Mr. Banerjee,
No, other legal heirs are there.
as one of his heirs and legal representatives. Full stop. Next para. Thus, comma, in any event, comma, it is submitted that the said Parvati Charan Rocket is entitled to step into the shoes of Bhagavati Charan Rocket, comma, as his son, comma, apart from the appointee of the said Bhagavati as a trustee. Full stop. Next para. We find from the impugned order, secondly, comma, learned counsel for Parvati Charan Rocket submits that the defendant numbers 1 and 2 made appointments of trustees without themselves retiring, comma, which was not contemplated in the Orponnama / deed of settlement. Full stop. Next para. It is submitted that as per the said deed, comma, only a retiring trustee could appoint a trustee in his place. Full stop. Thus, comma, having themselves retained their trusteeships, comma, the defendant numbers 1 and 2 were not entitled to appoint further trustees, and, comma, as such, comma, the application filed under Order 22 Rule 10 of the Code by the said defendants ought to have been set aside, ought to have been dismissed by the learned trial judge. Push up next para. However, such contentions are controverted by learned senior counsel appearing for the appellant. Push up next para. However, comma, on a perusal of the impugned order, comma, we find that none of the arguments made before us as well as before the learned trial judge are reflected in the order. Full stop. By the impugned order, comma, the learned single judge mechanically allowed both the applications without undertaking any exercise in the nature of Order 22 Rule 5 of the Code of Civil Procedure, or even otherwise took any effort whatsoever to adjudicate on the respective objections taken by the parties to the others applications under Order 22 Rule 10 of the Code. Full stop. Thus, comma, the impugned order is devoid of reason and ought to be set aside on such ground alone. Full stop. Next para, we are conscious of the fact that the parties have argued on the merits of the matter before us as well. Full stop. However, comma, we choose not to deal with the same at this stage, comma, since the learned trial judge did not advert to any of the contentions of the parties, and in the event we enter into such questions, comma, it will be the first adjudication, and this court, comma, sitting in appeal would be acting in the capacity of the first forum, which would usurp, which would deprive both the parties of a forum of challenge. Full stop. Thus, comma, an appropriate course of action would be to set aside the impugned order and send the matter back to the learned trial judge for re-adjudication. Full stop. Next para. However, comma, at this juncture, we take note of the fact that insofar as Parvati is concerned, comma, he is entitled in any event within the contemplation of Order 22 Rule 4 to be impleaded in the capacity of the heir of Parvati of Bhagavati Charan Rokhit. Full stop. Next para. Does the trust deed contemplate heirs coming in after death? Trust deed contemplates heirs coming in after death.
No.
Or then we
Existing trustee will.
then we cannot. Then we have to set aside the entire thing and send it back.
That's why he cannot be. He may be plenty, but no
Next
right.
para. However, comma,
One thing, other heirs is also there, as he has been said.
no, that he can solely be added and the others may apply later
May
on.
apply.
That would be irregular. But even then, however, comma, it has been contended by us before learned senior counsel appearing for the appellant that in terms of the trust deed, comma, there cannot be any automatic appointment of the heir of a trustee on the demise, on his demise. Full stop. Next para. As such, comma, it has been argued that the mechanism, now, as such, comma, it is arguable as to whether the mechanism contemplated in the trust deed at all permits Parvati Charan to step into the shoes of Bhagavati Charan Rokhit automatically as his heir. Full stop. Next para. Hence, comma, the default provision of Order 22 Rule 4 cannot be invoked at this stage. Full stop. Moreover, comma, as rightly pointed out by the appellant, by the parties, comma, the other heirs of Bhagavati Charan have not been impleaded in the suit. Full stop. As such, comma, taking into consideration the entire aspects as discussed above, comma, we are of the opinion that the impugned order ought to be set aside and the matter be relegated to the learned trial judge for the purpose of re-adjudication of all the applications under Order 20 Rule 10 of the Code on merits. Full stop. In the event the application for substitution of Parvati Charan Rokhit under Order 22 Rule 10 of the Code of Civil Procedure is turned down, comma, the said Parvati Charan, comma, in any event, comma, along with the other heirs of Bhagavati Charan Rokhit would might be entitled to seek impleadment within the contemplation of Order 22 Rule 9 of the Code of Civil Procedure, in which case the same will be decided by the learned trial judge appropriately in accordance with law. Full stop. However, comma, it would be premature for this court to consider such situation, comma, since it is still unknown as to which way the outcome of the application for substitution of Parvati Charan under Order 20 Rule 10 would go after the re-adjudication. Full stop. In such view of the matter, comma, FMA 565 of 2011 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 72 dated July 12, 2010, passed
Entitled suit numbers.
by the learned judge, comma, third bench, comma, City Civil Court at Calcutta, entitled suit number 988 of 2004, and remanding the matter to the trial court for a fresh adjudication on all the applications under Order 22, Rule 10 of the Code of Civil Procedure, which were decided by the impugned order afresh in accordance with law. First of, while doing so, comma, the learned trial judge shall give a fresh opportunity of hearing to both sides and adjudicate the applications on merits upon consideration of the objections taken by the respective parties and by adverting to the governing law in that regard. Full stop. It is expected that such adjudication shall be completed as expeditiously as possible, comma, keeping in view the long pendency of the suit, comma, preferably within 2 months from the date of communication of this order to the learned trial judge. Can 2 of 2022
application for substituted service. 2 persons has been added who was the tenant, never appeared in the court below nor.
Acha, in view
fact,
of the order passed by us not substantially affected the unserved parties, comma, can 2 of 2022 is disposed of in the light of the above observations. There will be no orders to cause.
But only one thing I forgot to point out. But there are, while dictating, Lordship has said deed of settlement. It should be will. And my lord has said.
If it is a will, then
But it
the
is written-
trusteeship concept cannot come in.
but it
Whether
is-
it's a deed of settlement or will, we don't.
It is boldly written will.
Boldly written, many things are boldly written, which are
Nomenclature is
not.
nothing, but
Nomenclature is nothing.
My lord has
My lord is
said
perfectly
order
right, what I
22
did
rule 4, as this is the
Three.
plaintiff side, it would be order 22 rule 3.
4 তো
Oh.
আছে না না ডিপেন্ডেন্ট তো আছে
No, no. See, একটা জায়গায় 4 বলেছি, order to rule
Three
4
হবে।
বলেছি, সেখানে 3 হবে।
But
Right.
only one thing I forgot to point out, my lord. My lord, in the other
একটা
appeal,
জায়গাতে order to rule 4 বলেছি, যেখানে সেখানে 3 হবে।
3 হবে
ওটা এখনো করিনি, ওটা এবার হবে। এটা একটা হলো।
but in the other appeal, an application for addition of party, my lord, that has been allowed by the division bench of this court. My lord, admitting my client to be one of the parties. That was an application under order 22 rule 10 in the other appeal. That has been allowed. My lord, it was
But
allowed.
there was no adjudication by the learned trial judge.
That is true, my lord.
Anyway, now we have decided the appeal. Now you cannot reopen that. You move your appeal, Mr. Banerjee.
Yes.
পেপার বুকটা পেন পেপারগুলো যা একটা দিই
আসলে এবার এটা ফেরত দিই। Nobody has a copy, then there cannot be. So let us follow the papers which are there.
Yes.
I may leave my
You are not there in the next matter. Mr. Bhattacharya, you are there?
Yes.
Yes.
Yes. Yes, sir.
Lordship would kindly see. Lordship has already considered the plaint. On the basis of that, we had prayed for an ad interim order of injunction. My lord, that ad interim,
But means Bhagavati had prayed.
Bhagavati had prayed. It was refused. Appeal was preferred. My lord, there is an order from this court, my lord, an ad interim order was granted. My lord, that order,
Injunction was refused. Why, Mr. Banerjee? On what
injunction,
ground? By the trial court? You have challenged an order refusing injunction.
yes,
Ad interim or
ad interim,
I think it's interim of contested hearing.
contested here.
let us just check up once.
Yes, 31st March 2005 is contested hearing, subject to correction.
We'll just check up the memo. মেমোটা কোথায়?
The copy one.
বিয়ের মেমো।
বিলটা দিয়ে এখান থেকে 861 861 মেমো
মেমো পেয়েছেন? মেমো কি ওটা? হ্যাঁ, ঠিক আছে, পেয়েছি। Yes, dismissal contest.
Yes. But we failed to make out a prima facie case to go for trial. And the balance of convenience and inconvenience does not lie.
What was the injunction you sought, Mr. Banerjee?
But at the ad interim that was sought for, the injunction, but from letting out, transferring any portion, and illegally removing articles from the said property. They were antique articles. There were, I mean, made of stone, lions and all those things. What are antiques in the old property?
Literally lion's share. So your injunction application must be annexed with your application here also.
Yes.
So let us just check that.
It is CAN 6896.
Yes, 6896 report.
Yes.
The injunction application.
But it starts at page number.
Yes.
To CAN 68.
At page 32.
Acha, we are looking at the prayer at page 48 for the time being. Then we'll come.
Lots.
There is, as you said, letting out, transferring any portion, illegally articles. And depriving you from participating in day-to-day management may be difficult. That would be in the nature of a positive direction.
That was also allowed.
That
By
was
this
refused.
By this court.
Ad interim.
Yes.
Not binding at this stage.
Not at all. Kindly see the annexures those were given to the injunction application.
Yes.
We had given all the counterpart of the rent receipts in order to show that there are tenants.
Yes.
These tenancies are being unilaterally changed by the other trustees. That we have stated in our
How can they
application.
change without evicting? Tenants would keep mum.
But tenants are surrendering, they are giving it to new tenants, accepting the salamis and depriving me of everything. This was stated in our injunction application. Lordship would kindly see page number 24. In the accounts, those were not shown. This was a notice for
24.
the 55.
Yes, that
Inner page
in a
20.
number.
sorry.
Yes.
But
These
this
are
was a
notice given.
notice to all the trustees, my lord.
Who gave it?
Devi Charan gave it,
Acha.
respondent number 1.
All right.
The annual reports and everything were being passed without permitting me to participate there.
You are given a notice also.
But I was just given a notice, but my averments are when I went there,
You are not
I
permitted.
had to be accompanied by my son
Hmm.
because at this point of time in 2004, I was aged 94 years.
All right.
I died at the age of 98 in 2008.
Right.
But they did not allow my son. They were doing things in such a way. I raised an objection to that. That is at page 56.
Let us see the impugned order first, Mr. Banerjee. How the court dealt with it.
Lodge. যে অর্ডারটা এক্ষুনি ইমপ্লিমেন্ট অর্ডার তোমাকে ফেরত দিলাম ইমপ্লিমেন্ট অর্ডার কপিটা
That was his ground actually, the court's ground. That since he was a nonagenarian, octogenarian, yes,
Yes.
he cannot do anything. He doesn't
He could
understand,
not
and,
understand anything.
and you are governing him and all these
Yes.
things.
But
So
there are certain things, my lord, which should be taken into account. But an application under Order 19, Rule 2 was filed in the trial court. My lord, on the date of hearing of that Order 19, Rule 2,
yes,
this gentleman personally appeared in court in the dock. The court inquired whether you have filed the suit. Are you acquainted with the facts and circumstances? Who is your lawyer? He identified everything. He answered these all the queries. Court got satisfied. Thereafter, challenging that order, dismissing the Order 19, Rule 2, the plaintiffs here, I mean the respondents here, they had moved the High Court. There is a direction, malad, judgment of Justice Jyotirmoy Bhattacharya, malad, dismissing their revisional application, that this gentleman was competent to manage his own affairs. Those are all there.
and the court, it is also recorded at page 7 of the impugned order, as he did not take any part in that, those things. Accounts of the trust estate are regularly maintained. This is about the 10th line from the top.
Yes.
Accounts of the trust estate are regularly maintained and duly audited by a chartered accountant, and it is open to all the trustees to have inspection.
But Millard, till date, they have not filed those before the court.
Now, Mr. Banerjee, why can't your relief be granted by way of asking them to file accounts in trial court regularly? Because they will be, because you can always come up, if you are implemented ultimately, you can always come up and ask for accounts, and also maybe recovery.
Absolutely.
So audited accounts, because they say that duly audited chartered accountant accounts are being maintained.
Yes.
So we'll direct them to modify this order and direct them to file the account.
But only one more thing, my lord.
This person is in any event not there, Bhagavati.
Yes.
So
But-
now it's all the more difficult
but
to
only
permit you.
That is the my lord, open situation that they are facing. They are getting a walkover.
Yes,
my
they'll
lord,
take advantage of that. They'll get advantage of that.
they have taken, my lord, that is expressed. My lord, kindly see page number 4 of the impugned order. My lord, they have inducted a new tenant, Speed Inc., selling cars.
Now, Mr. Banerjee, now they are the trustees there, unless your dispute is resolved. Your dispute and the persons they have inducted.
But the condition that is now
The
continuing,
defendants are the only remaining trustees now,
but that
living
should be
trustees.
preserved at least.
Accounts will direct.
Not only that, my lord, the possession that is now existing in the property, that should be preserved. My lord, rent whatsoever that is
Mr.
being,
Banerjee, the difficulty is the court does not pass any order which it cannot implement. That's settled. Now, an injunction without knowing what is there, tomorrow you will come up and say they have violated, they have transferred whatever is there, and they'll say, and on the other hand, they can now take advantage of the status quo injunction order. They'll
let them,
do whatever they like to do, and they say these were never there.
and let them give a list of the tenants in the property who
No.
are in occupation, my lord. My lord, we have given the list.
They are entitled to induct tenants, and why not?
My lord, we have given the
But only relief you can have is, Mr. Banerjee, that accounts may be directed to be given, filed by them regularly, audited accounts.
my lord, the mischief that is being done is regarding induction of new tenants. My lord, taking,
That's not a mischief. They are as
my lord, the
trustees are
areas,
entitled.
but this is a heritage property. It's a very old property.
There are already there were
Yes.
tenants.
Yes. My lord,
Inducting
those
tenants does not
tenants-
take away the
those
character of a
tenants-
heritage property.
But those tenants are no more. Those tenants are no more. Now
Change
new,
of tenancy does not change the character of the building as a heritage structure.
my lord,
And if it's a heritage structure, you don't have a right. Give it to the archaeological survey.
my lord, my lord, these tenants, they have surrendered. Some of them. My lord, it has
They are
been given
entitled to induct tenants
but
as
that is
trustees.
not being reflected in the accounts. That is what the suit is
We are
for.
boiling down to the same thing, Mr. Banerjee. Then we cannot restrain them from
Lordship-
inducting, but we
Lordship
can direct them to file accounts regarding everything.
kindly protects my client or my lord,
The
in
estate.
such a way, but in such a way so that the income of the estate is not being wasted.
That can be done by directing them to
There
file
is a
accounts.
charitable angle to this. They have a charitable dispensary in Chandannagar.
Maybe they are operating that now. They are operating.
They
Bhagavati
are
is no
not
longer
doing
there.
anything. My lord, they are not doing anything. Those are my averments in the plaint.
That after Bhagavati's death, probably it is difficult for you to canvass that at this stage.
My lord, these are all on records. My lord, we'll kindly see in the injunction application, we have stated all this. My lord,
And court has observed that due to his age, maybe he is mentally sound, But he's not regularly coming, which you also admitted. That was the premise of your letter to them.
Yes, yes, but I do not deny that. A gentleman of 98
So
years
then
age.
you must be controlling the affairs at the helm of affairs
No,
on his behalf.
They did not allow.
So if he is no longer there now, and he was sold that he could not come regularly, it was they who were operating the trust property.
Well, they had
Why can't they induct tenants?
schemed everything that is there in the trust.
Maybe.
My lord will kindly see we had given my lord, page 59 onwards to the injunction application, letters to the tenants. My lord, whatever could have been done, we have done it. My lord, they had ensured, my lord, they had.
This is one of the plausible views, Mr. Banerjee. We won't interfere, but we may modify subject to hearing Mr. Bhattacharya regarding accounts.
My lord, only one more thing, my lord, I should point out, my lord, there were 2 or 3 orders. My lord, the first order is by Justice Subhrakamol Mukherjee in a division bench dated.
In this appeal,
Yes.
ad interim orders don't bind at the final
My lord,
hearing.
this is there, but I should point out to your lordship, my lord. My lord, they were restrained from transferring, alienating, or encumbering the property in suit
In favor of third parties.
in favor of third party. This was there. My lord, the second order, my lord, there was an application under Order 22, Rule 10. My lord, that was disposed of on 13th May 2010,
Yes.
along with a restoration application. My lord, in that the appeal was restored. একটা order কোথায় গেল? My lord, Order 22, Rule 10, that was allowed.
Because it's a trust property. Now, Mr. Bhattacharya, what do you say to these two things? One, accounts will direct you definitely. Regarding transfer of the creating third party interest, we won't restrain you. But you cannot transfer the property.
Well, today, if
You cannot
today-
sell out the property or transfer the
no,
property.
if today the trustee prohibits me to sell the property, then my lord, I can't sell the property without my lord taking recourse to
It
law.
does.
My lord, that is something, my lord, I'll have to check because this trustee, my lord,
No, we'll make it an order of the, you cannot, because the
Now, my lord,
property is in
yeah, my
lieu.
lord, kindly considers the situation.
Yes.
Today, the plaintiff, when he filed the suit, he has sought for a declaration that he's the senior most trustee. That is the principal declaration that he has claimed in the suit. Now, this person in the year 1998 goes missing. There's a missing report. In fact, we have given an advertisement in the newspaper, which is there on record in the affidavit in opposition, that this person is no longer there to be found. In 2004, from one of his letters he sends, we get to know his address that he has.
Till his
gone
order
somewhere.
20, his order 20 rule 10 is not decided.
Yes.
And even if decided against him, his order 20 impending order 20 rule 9 application does not come. We cannot say that the suit is no longer there. So therefore, Mr. Bhattacharya, due to pendency of the suit, if you transfer the property or alter the nature and character of the property, then this will not inure to the benefit of the trust.
My lord, that
They have asked for regarding transfer, they have asked, and also from making construction, they have stated. So we'll restrain you from transferring the property, from selling the property, but you will be entitled to induct or in other manner you can induct tenants. Regarding induction of tenants, we will permit you, but you will have to furnish accounts regularly, and you will not change the nature and character.
will furnish accounts regularly. Now, this trust property, we are the only we are maintaining they performed nothing. They did nothing. He went missing. Ultimately, he was under the grasp of the sun. And when one of the trustees he goes missing and he
Yes,
doesn't
but
participate.
Don't sell out the property. If you sell out the trust itself, then the
No,
tree is gone.
If the
You are
trust,
cutting the branch on which you are sitting.
if the trust property, my lord, today we can't deal with the trust property as per the trust deed, my lord. That's my lord the difficulty we
To
are
deal
facing.
with the trust property will restrain you from inducting tenants also.
That
We
is
won't
my
say
lord.
deal with the property.
So we will
We
be
say
inducting
not
tenants,
sell out the property.
and we will not act in any manner which is my lord
So
which
that will be vague. We also won't do that to you. We'll say that you cannot sell the property, you cannot change the nature and character of the property, and you will furnish regularly accounts regularly, audited accounts.
regarding the nature and character, my lord, I have to know exactly take instruction. What is the present nature
Very
and
well.
character
Cannot change the nature and character without the leave of the trial court.
without leave of the trial?
Yes. We'll permit that much. And sale also without the leave of the trial court.
In fact, my lord, the present stage I've been instructed is in a very dilapidated condition. The whole building, it needs repair work and everything.
Nature character as well as sale of the property, both will be without leave of court. So we
Yes.
give you a leeway there.
Yes,
You can
with-
apply before the
yes,
court
yes.
so that they'll also have a right to contest
And
that
my lord, that will not prevent us from carrying out regular repair works and all, because in a very dilapidated condition. Because
without
some-
permission of court. We'll
Will do, my lord,
will not
kindly
say that.
puts it, because
No, you cannot. Will injunct you only from selling out the property. One, secondly, from changing the nature and character, both without the leave of the trial.
without the leave of the trial court, my
Yeah.
lord. And my lord, then kindly, my lord, let the trial court decide the whole thing, my lord, within a particular time period.
We have already granted in the
In the earlier,
order. We have said
yes,
to
because
within
he
2
has to
months.
possibly also establish
20
his
to
right.
10 applications. If those are decided, everything is
Everything,
done.
everything is decided. within 2
Everything.
months.
Yes.
Very well, my lord.
But only one thing, my lord. But kindly keep some check, my lord, if possible, my lord, subject to my lord's
Check
pleasure,
is
my
that
lord.
they'll have to approach the trial court for
No,
permission.
But a tenancy, my lord.
No.
My lord, this is on Chourungi Road, my lord, and lordship can.
You don't have a
verify,
right
my
now.
lord, what is
In
the,
any event, the injunction, we are doubtful whether the injunction application is maintainable at
But,
your behest now.
my lord,
Because whether the
10,000
appeal
rupee would be rent and 10 crore rupee would be the giving of the tenancy.
audited account should suffice.
But that won't come in the, my lord,
No.
accounts.
The present challenge had been preferred originally by one Bhagavati Charan Rokhit, comma, না বানানগুলো দেখে করতে হবে এখানে কসেট এখানে সব আছে রক্ষিত ফকিত চরণ সব পুরোনো দিনের বানান one Bhagavati Charan Rokhit within bracket since deceased bracket close the father of the present appellant comma the latter having been substituted under order 20 rule 10 of the code of civil procedure during pendency of the appeal. Full stop next para. The suit was primarily for declaration that Bhagavati Charan Rokhit is the principal trustee in respect of the suit property and for consequential reliefs. For sub next para, learned counsel appearing for the appellant argues that the learned trial judge dismissed the temporary injunction application of Bhagavati Charan Rokhit on an erroneous consideration of the law and the facts of the case. First up, by placing reliance on the annexures to the injunction application filed before this court, which, comma, it is submitted, comma, were also a part of the injunction application in the trial court, comma, it is argued that the respondents have been inducting third parties as tenants to the suit property at huge rents and depriving the appellant from the fruits of the trust. First up, next para. It is further submitted that in the event the respondents are permitted to transfer the suit property or encumber the same in any manner and or make constructions on the property, comma, which is a heritage building, comma, the trust itself would itself suffer. Full stop. It is submitted that in such event, comma, the suit will be rendered infructuous before being heard finally. Full stop next para. Learned counsel for the appellant further points out that at ad interim stages of the present appeal, comma, injunction orders, restraint orders by way of ad interim injunction was passed by coordinate benches. Full stop next para. It is also contended that since the appellant was substituted under order 22 rule 10 of the code of civil procedure, comma, the respondents cannot now raise objection to the locus standi of the present appellant to pursue the cause of the original plaintiff. Full stop next para. Learned counsel appearing for the respondent controverts such allegations and submits that the original plaintiff, namely late Bhagavati Charan Rokhit, comma, during his lifetime, comma, had attained a mature age and was a nonagenarian at the juncture when the injunction application was moved. Full stop. As such, comma, the learned trial judge took note of the fact that Bhagavati Charan could not personally come to attend the meetings of the trustees and or to participate in the business and affairs of the trust. Full stop. Thus, comma, he was entirely dependent on the present appellant, comma, his son and his other children, comma, who used to run the show on behalf of Bhagavati without being empowered to do so under the deed of trust. Full stop next para. it is further argued by learned counsel for the respondents that as the remaining trustees on the demise of Bhagavati, the respondents, in any event, are entitled to administer the trust property, and as such, the learned trial judge was justified in refusing to grant any injunction. Next para. Upon a consideration of the impugned order, we find that the primary premise on which the learned trial judge proceeded was that Bhagavati Charan was of mature years and was not capable of participating in the day-to-day affairs of the trust and was controlled fully by his children, including Parvati Charan, the present substituted appellant. Next para. However, we find that the learned trial judge omitted to take into consideration that the suit was ultimately for the benefit of the trust property. As such, in a suit of such a nature, one of the duties of the court is to ensure that the trust property is protected, at least till disposal of the LIS. Next para. From such perspective, although the living trustees, being the respondents, are entitled to induct tenants or otherwise encumber the property to a limited extent, in the event the respondents are permitted to sell out the property irrevocably in favor, sell out the property or transfer irrevocably the property or any part of it in favor of third parties, the suit might be rendered infructuous and the trust estate may also suffer. Even otherwise, till disposal of the suit, although the respondents ought not to be restrained from inducting tenants or earning rent from them, since the matter is sub judice before the trial court till now, the ends of justice would demand that quarterly audited accounts should be filed by the defendants / respondents before the trial court. Next para. Since learned counsel for the respondent submits that the property may be in a dilapidated condition, requiring repair, we intend to make the change in nature and character of the property conditional to permission being obtained from the trial court. However, otherwise at this juncture, if the respondents are permitted, if the respondents are given a blanket charter to alter the nature and character of the property, the ultimate outcome of the suit may be adversely prejudiced. In such view of the matter, FMA 861 of 2005 is partially allowed, thereby modifying the impugned order bearing order number being order dated bearing order number 24 dated March 31, 2005, passed by the learned judge, fifth bench of the City Civil Court at Calcutta, entitled suit number 988 of 2004, to the extent that the present defendant / respondents shall remain restrained by an order of injunction from selling out and / or transferring irrevocably the suit property in favor of third parties and / or from altering the nature and character of the suit property in any manner, both without the leave of the trial court. Next para. If an application for leave is filed in either regard, the learned trial judge shall decide the same in accordance with law upon giving opportunity of hearing to all parties. Next para. That apart, the defendant / respondents shall file quarterly audited accounts, the first of which shall be filed for the first quarter of the year 2026 and thereafter each quarter of the year before the trial court. Next para. It is also made clear that the income and expenditure in respect of the suit property, subject property, shall abide by the outcome of the suit. Full stop. Next para. Is there any can in connection with this pending?
Yes, some, ma'am. But all these can be disposed
All
of.
these are disposed. Can 1 of 2005 within bracket old number can 6896 of 2005, comma, can 4 of 2010 bracket old number can 4786 of 2010, and can 5 of 2010 bracket old number can 7901 of 2010 are disposed of consequentially. So there will be no orders to cause urgent settlement.
One point, my lord. Everything, my lord, is in case of regular repair work, because if every time if I have to approach the court for carrying out regular repair work without changing the nature and character, and they object to it because of the delay,
Yeah, you have to.
the trust property will be under, my lord.
Repair work always, whenever a suit is pending, all the parties approach the court with a repair application. That's what a repair application is meant for.
But then they should
Why
not.
should you approach every day for repair?
But they should not unnecessarily object to, because otherwise, because the trust property will be in limbo if today is not repaired. It's in a dilapidated
Permission of the trial court.
Yes,
Trial
but
court will consider
every
that.
time if they put a spanner in the wheel by
Why every time? Why every day? Nobody is required to repair a premises every day.
in
In
case
one
my lord, it's
repair
dilapidated.
application, you can take.
We'll cover everything, my lord.
We hope before the next repair, the suit is over.
Yes, that is
The way it's going, we don't know.
Great.
Thank you. Next.
I am applying the applicant.
Yes. Yes, Mr. Das.
Yes, Lord.
Who is for the respondent?
Mr. Topon, Senior Advocate Topon Mukherjee, just now he present this court.
You start.
Lord.
If he does not come, we will hear it expertly.
Lord, I am the lead petitioner appellant, Lord.
Yes.
Fact is that, Lord, the school for the blind and mentally retarded children run by the NGO, initial NGO, namely Vivekananda Lokosikha Niketan. That was run by the private NGO. Subsequently, they appointed the petitioner as a principal in the year of 1998. Thereafter,
It was only for the visually challenged,
Lossi,
only for the blind people.
Lossi, blind and mentally retarded.
Sorry. Yes, please continue.
The petitioner appointed as a principal of that school on 24th April 1998. He joined the school on 2nd May 1998 as a principal. Thereafter, the NGO wrote a letter to the government for taking sponsorship. After considering the application, government took over this school and granted the sponsorship.
Consortium means exactly what? Who are the members of the consortium? Government and this NGO only.
Government
Consortium means
all the
collaboration
all,
and conglomeration of.
no, all affairs controlled by the regarding salary, others. Lossi, I will place this
State control. Now state control.
state control. Lossi, kindly come to page 70.
No, what is? Please complete your factual submission and then.
The
What was the writ petition for? You are removed.
no, I am appointed as the assistant teacher. Government, Lossi, kindly come to page 70.
You are the principal. You were taken off from the principal position and made an assistant teacher.
Assistant teacher. Lossi, page 70. Lossi.
You should have told the line of the government. That would have solved your problem.
Lossi, kindly page 70. Lossi.
70, yes.
English Lossi. Government take over this institution. Lossi 1.
State the other side. Yes.
1 Lossi.
1.
Lossi.
What is this? What is this document?
Government take over this institution on the basis of that. Lossi, kindly see the 1. The existing teaching and non-teaching regular staff of the institution will be absorbed against the respective post as sanctioned herein and will be placed in the respective scale of pay. The scale of pay will allow to the teacher primary and pre-primary preparatory grade as the case may be in terms of notification number such and such. The organizing staff having requisite qualification and training will be absorbed in the teaching post.
will be absorbed against the respective posts as sanctioned herein.
Lordship, existing teacher and non-teaching regular staff of the institution will be absorbed against the respective post.
Don't
As-
stop there. It continues.
Yes, as sanctioned herein, and will be placed in respective scale of pay.
Where is it sanctioned? The post of principal here.
Lordship, my appointment letter, Lordship, page 56.
No, what is the meaning of this? As sanctioned herein, and the scale of pay will be allowed such and such as the case may be in terms of notification number such and such.
Yeah, page 72, Lordship, annexure.
The organizing staff having requisite qualification and training will be absorbed in the teaching posts. Wait, 72.
72. Lordship, serial number 1, post principal,
Hmm.
Lordship,
Mhm.
then assistant teacher, then other staff, total staff is 23
This
What-
was the previous position before this takeover.
to take over.
On the date of that. Yes.
Yes,
Yes, right.
total
Yes,
number
sir.
23.
Right, right. So what is that government order? The government order is the one you showed to us.
Government order, Lordship, page 70,
That is the government order.
Government
Referred to here. Referred to in page 72.
same post, respective post,
Very good.
same page 73. Serial number 1, Gautam Kumar Saswal,
You are Gautam.
yes, as assistant teacher,
So there is no post of principal now.
no post till now. Thereafter, Lordship, authority asked that I am initially my degree is MA in history. Thereafter, authority asked
In English.
MA history.
History.
Asked that the in that institution MA history cannot be as a principal. Thereafter, Lordship, with leave of this
Why
institution,
history is not taught there?
I do not know, Lordship. That was
You have taken instruction.
thereafter, Lordship,
That follows some board. Which board? The West Bengal board.
West Bengal
It's affiliated to the to the
Mass education.
mass education
Mass
under the
education
mass
for
education.
physically challenged students.
there's a separate category for that.
Category is not at a department of mass education.
Acha.
And principal post is not a promotional post.
I came
Came to my
this-
opposition to the stay application.
Please, we are taking up the main appeal. Yes, Mr. Das, continue.
Thereafter, Lordship, with permission, petitioner in the year of 2010 taking admission in the master degree of psychology and completed the said degree. Thereafter, made an application before the authority concerned. Kindly absorb my client as a principal because page 70, as per the page 70, when the institutional takeover,
Why did you complete your masters in psychology? That was required.
because
That
of
would qualify you.
Lordship,
That would entitle you. That would qualify you.
yes, that degree is qualified for the post of principal.
So where do you get this? That this degree is qualified, this degree is not. Is there any list?
That as per the advice, of the institution government, I take permission to the before the authority concerned
As
and
per the advice of the government.
the without degree of the master degree of the
To show us, Mr. Das, that this degree qualifies you
Yes,
as a
sir.
principal, this does not. Advice of state. If you have gone by the advice of the
Law-
state, why do you come for the advice of the court? now?
Lordship,
Should be ready in your matter, Mr. Das. You were the petition. What happened? The writ petition was rejected.
Rejected.
authority concerned rejected on the ground that the post of principal is not a promoted post.
Show us that
Loss.
opposition. Where is that in the paper book? The
Lordship,
refusal.
page 101.
Page 130, you are actually finding. 130.
Author,
101. What is at
no, author, initial authority order, Lordship, page 101. Lordship, relevant page 102,
Hmm.
Lordship, third paragraph.
Yes, third paragraph.
There is no provision in the sponsorship order to give the promotion in the post of principal if an assistant teacher acquires the requisite qualification subsequently.
You accepted your post as an assistant teacher and you worked there as an assistant
No,
teacher.
from beginning I made a objection before the authority concerned. That was I placed before your
So you say this is not a promotion you are wanting. You are
Yes.
wanting an absorption
as a
view of the
principal.
initial government order.
Loss. On that basis, authority was rejected.
Is there any principle there at present?
No, till now,
How did the RIT code deal with it?
in the same line, Lordship. Page 109,
Same line.
where authority that post is not
Authority.
a
Let us see the order of the
109, Lordship. Lordship, page 122,
Hmm.
first paragraph, last two line.
Yes.
He should have been appointed in the post of principal in the state.
Page 122.
Yes,
First paragraph. Acha, last two. Yes.
last two line. Principal in the state school as the post therein still remain vacant.
Yes, yes, that is true.
Lordship, relevant post portion 128.
124 starts the constitution.
Yes, Lordship.
Having hard learned advocate for the body. So court held that master degree in psychology is requisite qualification.
Yes.
No difficulty on that. From a different technology. Court proceeded on a degree also.
Yes.
Was a principal school for Malta. No, court rather held in your favor that you are entitled
Yes.
as a master degree.
Thereafter 128, Lordship.
Acha, very well, 128.
Lordship, second paragraph, it is rightly pointed out, Mr. Goswami, that the post of principal is not a promotional post. As such, petitioner cannot be appointed in the post of principal in the said school, as he subsequently acquired master degree in psychology.
On the date when the takeover was done, you did not have the qualification to become a principal.
I am at the point of time I am the master degree in history.
That does not qualify you.
But Lordship, page 70, government order. Kindly see page 70, government order. Specific word, Lordship.
Existing teaching and non-teaching regular staff of the institution will be absorbed against the respective post as sanctioned herein,
Lordship.
without any qualification regarding your qualification.
No, master degree is there, but in the subject
Is
psychology.
there anything to show what is the qualification to become a principal in such places? Because the learned single judge has decided only from the perspective of your psychology master degree. What about history? I mean, no discussion is there. Did you produce anything before the learned single judge to show that master degree in any subject entitles you to become a principal in such schools?
No,
We find nothing produced from your end to show that master degree would suffice in any subject.
at the point of time, Lordship, the authority asked me asked the
Authority asked you,
the master degree in any subject.
treated you to a cup of tea. We are not interested. You show us the law, Mr. Das, that whether master degree in any subject entitles you or it disentitles you. Either way,
Lordship,
show us what are the qualifications for getting becoming a principal.
when I appointed as a principal, I already produced my after authority satisfied that my degree is there.
And it was not a government school. Might be some regards are not applicable. Private colleges, so many things are happening.
But authority take over this school on that basis, existing teaching and non-teaching regular staff on the institute will be absorbed against the respective post.
Yes, you have a point there. Let us hear Mr. Mukherjee then.
Government already the
Anything else you want to argue, Mr.?
no. On that basis, government already take whatever may be.
You have to.
everything
Have to.
loss.
Good. Yes, Mr.
What can I say? The page 72.
Yes, 72. We are going to take you there. Principal is there.
Serial number one principal. Only
Hmm.
one post. Is a not a promotional post.
No, not a promotional post.
Direct appointment.
And please come to page 70, item 1, serial number 1. Please read the two in conjunction. Page 70.
Yeah, just
That government order, your order.
existing teaching and non-teaching staff of the institution should be absorbed against the respective post as sanctioned below. Sanctioned herein and will be
Existing teaching and non-teaching regular staff of the institute. He was a teaching regular staff.
Staff.
Will be absorbed against the respective posts as sanctioned herein. Principal is sanctioned herein.
Yes.
And will be
no,
placed in
principal
the
has not been sanctioned.
this page 72. What is this then?
The 72 which one of the post was sanctioned the principal.
Therefore, it's a sanctioned post.
Sanctioned post. But
Principal was a sanctioned post
master
as per your
appointed-
geo. And it's stated here enclosure to geo. It's an enclosure to the geo.
yeah.
And in the geo you say as sanctioned herein.
Yeah.
And you make that an enclosure where principal is a sanctioned post. So therefore he had to be absorbed as a principal.
But he must have a qualification to be appointed as
That is not there anywhere. That was the premise on which you took over the institution, Mr. Mukherjee. The premise of your takeover was this government order. And separate arrangements, different arrangements are made in respect of different institutions by the state. That has been recognized by courts.
Yes.
For different institutions, for different types of categories of bodies, you may have different arrangements. State is entitled to, you have the play in the joints. But for this institution, because otherwise you might be that they would not be agreeable to your takeover.
Yes.
Might very well be. So you agreed to this. Your government order says the existing teaching and non-teaching regular staff of the institution will be absorbed against the respective posts as sanctioned herein and will be placed in the respective scales of pay. He was a regular principal teaching staff. That was one of the respective posts as sanctioned here in principle. So why shouldn't he be absorbed directly as a principal?
provided he has the requisite quality.
Where do we find that?
Kindly say page 101.
Acha, we'll come back after these 5 minutes and yes. Page 101, Mr. Mukherjee.
This is the order passed by the department.
Yes.
So this is the order of remand by the High Court.
Previously, there was a remand also.
Right here. The direction.
Ah.
Can you see page 70 first?
Page 70, yes.
Yeah.
You are taking the two together.
Yes.
70 and 101.
70 discussed in 102.
All right.
On 8 February 2006. Kindly see first recognition. Clause 1. The existing teaching and non-teaching staff in a regular staff of the institution will be absorbed against respective posts as sanctioned herein and will be placed in the respective scale of pay. Scale of pay will be allowed to the teacher, primary and pre-primary, preparatory grade as the case may be in terms of notification number 553 dated 20th April 95. Then next, very important. The organizing staff having requisite qualification and training will be absorbed in the teaching post. He was absorbed as a teaching post.
That is the organizing staff.
Organizing staff.
What does organizing staff mean?
But because this school was organized by the this particular society, then they
Organizing staff is different because you have distinguished made three categories: existing teaching and non-teaching regular staff, and separate provision for organizing staff.
petitioner before your lordship.
No, you say the organizing staff having requisite qualification and training will be absorbed in the teaching posts, meaning thereby that in the first place they were not in teaching posts.
No,
You say organizing staff having requisite qualification and training will be absorbed in the teaching posts. So organizing staff, what is organizing staff?
this at that point.
Must be the office staff or the other staff. Or organizing staff, we don't know. You have to satisfy us. What is organizing?
Then 102.
Acha, 100
101.
101, yes. What about 101?
101, in terms of the order passed by the Supreme Court, matter was considered by the department. 101, next paragraph. When a first discussion of the petitioner case is appeared, P2, the representation submitted and the petitioner written representation of hearing, the school sponsored by GO dated 8 February 2006, with effect from 1st December with 23 posts, including 1 post of principal, 7 posts of assistant teacher, but the petitioner name was approved against the post of assistant teacher, Roman 6, dated 11 May 2007, although the school already authority appointed the petitioner principal during organizing period. Organizing period before getting academic recognition of and sponsorship. The petitioner during the hearing stated that he had requisite qualification and training for approval as name is the principal, like Wahin De principal, Sathi Paschim Midnapur, and Kajol Kumar Bera principal, Bardwan and Blind Academy. He submitted that he acquired MA in psychology from Binayak Mission University in 2010, as it appears the mark sheet submitted by him. Now the petitioner claims that his name is to be approved against the post of principal, allowing him the scale of principal with effect from 1st December 2000 by modifying the order dated 11 May 2007. I've gone through the records and documents maintained by this director. It appears that the school with blind MR section was academically recognized by the Maharashtra Education Department, later renamed as Maharashtra Education and Library Services Department by memo dated 1st February 2001. The school was sponsored by the department on 8 February 2006. In the sponsoring GO, it was mentioned the organizing staff having requisite qualification and training would be absorbed in the teaching post in terms of notification dated 20th April 95. Essential requisite qualification to become a principal in MR multiple handicap school is MA or MSc in psychology, but Sri Gautam Kumar Saswar passed MA in history during the period of approval of his appointment the post of assistant teacher. There is no MR section in both the schools, namely Sathi Paschim Midnapur and Bardwan Blind Academy, Bardwan. The example which has been cited by the petitioner, Wahinde and Kajol Kumar Raja, those whose schools have requisite qualification to become principal of the respective school. So appointment of Wahine and Kajol was approved as better. There is no provision in the sponsorship order to give promotion to the post of principal assistant teacher requires a requisite qualification.
No, that is not there. That we agree with you. That the learned single judge also rightly held. That no such provision has been shown. Promotion, if on promotion, he may not be entitled.
What is the qualification of the principal? That is the page 116.
Yes, let us see.
The requisite qualifications, I will also got it, page 116.
Yes, 100.
Child judge.
What is this? This is a part of what?
Part of the order of Lord Single Judge.
Achha.
Quoting the rule.
Very good.
The requisite qualification for the post of principal, headmaster, headmistress for the school for the mentally multiple handicapped as described would be the qualification essential MA or MSc in psychology, diploma in mental health, 5-year teaching experience in a special schools, mental health care, then desirable training in education, knowledge in official administration, knowledge in Bengali, age limit 45 years, hearing and get the requisite qualification post of principal of school for blind as described ruled below. Qualification essential, honors degree or master degree, diploma and certificate training and blind from recognized tutor, 5-year teaching experience, knowledge officer, desirable, Bengali, age limit. This court finds that the educational qualifications for the post of different from category schools as prescribed with the different rules. So as per the post of the principal in the school for the DP is concerned, any graduate or master degree holds from university or candidate having degree in education for hearing impairment with 5 years teaching experience in a school for a diploma in with 7 years teaching experience in school for the D for certificate training in the with the 10 years teaching experience school for the D which is so what is the education qualification which is laid down in the post of principal in the school mentally multiple handicap is concerned a candidate having MASc psychology and diploma in mental education from National Institute of Mentally Handicapped or diploma mental education from an institute recognized by Rehabilitation Council Training Center certificate and mentally retarded multiple handicap for recognized institute. There must be a affiliated university is eligible to consider. So for the post of principal school, so the blind is concerned a candidate having honors degree or master degree or diploma certificate training in blind from a recognized institute. 5-year teaching experience at school, blind is eligible to the post of school. Since the educational qualifications prescribed in the post of principal in these 3 category schools are differently in the head rules, this could firstly find the identity of the category of schools to which these particular schools belong. Admitted the school admits blind students and mentally retarded students in the solution. Thus, there is not a school for deaf. Then again, since the school admits both blind and mentally retarded students, the schools cannot be categorized as school for the blind only. Now the other category school left a school for the mentally retarded. And particularly on the for the initial recognition, he does not have the requisite qualification for the post of principal. He was only appointed as a first staff assistant teacher. Now he wants the appointment of principal.
Is his representation annexed here anywhere?
Yes, yes, yes.
Which is the where is that? Which page?
Yes, Lordship. That was
Page 90.
Page 90, yes.
Page 90.
Yes.
May I permit to press?
Yes, Mr. Mukherjee. How he approached it, let us see.
May I permit to press?
Yes, yes, Mr. Mukherjee.
before that.
No, you take your seat, Mr. Das. We just want it from Mr.
I was
Mukherjee.
appointed as the principal of Vivekananda Lokshikha Niketan, Faridpur, Dakshin.
We'll come back to you, Mr. Das. Yes.
The said institution is to teach a student who are visually impaired and also are mentally retarded. The school authority made an application on 21st July 2000 with a prayer for academic recognition with a financial assistance along with the particulars of the schools, including a list of teaching and non-teaching staff of the institution. It will appear from the said list that I was appointed as a principal in the said school and my service accepted by the school authority as principal. The school authority by letter dated 21st July 2000 disclose the said fact, my appointment as a principal of the school and your office accepted the same as would appear from the said list. After considering the application dated 21st July 2000, the depository by GO number such and such sanctioned the academic recognition in favor of the school for 6 MR with effect from the current academic session. The said academic recognition was made after considering my candidature as the principal of the school. That after the school authority made application on 30th May 2002 to the Director of Mass Education, Government of West Bengal praying for sponsorship of the institution by the government. In the said application, list of teaching and non-teaching staff was enclosed with my name as a serial number 1 as a principal of the school, and the same was accepted by the government as well as the director. Thereafter, GO number 8 February 2006, the Joint Secretary, Government of West Bengal, sanctioned the sponsorship in the school with effect from 1st December 2005 and sanctioned 23 posts, including my post as a principal. In the said memo, 8 February 2007, 7 posts were sanctioned in the appointment of assistant teacher. Thereafter, an order was passed by the Director of Mass Education on 11th May 2007, wherein my name is shown as serial number 1. By my resignation was written as an assistant teacher. In 2007, assistant teacher. In view of the above, said order violated the order dated 8 February 2006 by accepting me, approving the post of assistant teacher instead of assistant teachers, and I violated the post of principal, keeping it as a vacant. The said order dated 11 May 2000 is relating to approval of appointment in the staff is illegal in respect of the approval of my appointment on the following grounds. That I was appointed the principal school since the establishment of the school. My name has been accepted in the time of academic recognition and sponsorship in the school as principal. After the sponsorship, the schools have been performing their duties with the seal and signature of the member secretary, and the same was accepted by all authority of the school for the purpose of smooth running of the school. It may be noted that per GO number 3rd March 2000 issued by the Joint Secretary in respect of formation of managing committee of the school, it will appear from the said memo that at 3rd March 2006, the member secretary shall be the principal teacher in charge of the institution, but there is no whisper I am accepted as a teacher in charge of the school. But there is on record that I have been acted as the principal of the school. It will not appear from the said order dated 11 May 2000 that there is a teacher in charge of the school. The school authority accepted my serving or taking service as the principal, but your authority without any reason has failed to accept my service as the principal of the school. I made a representation on 21st April 2008 and 3rd July 2000 requiring you to consider my case by approving the appointment as the principal of the school, but you have received the same on 4th July 2000, but till date no commission is made from them. The president of the managing committee later on after October 2000 requested me for clarification of the order dated by treating the as the principal of the said school, but at the same time also the communication was made to the president of the school, reply to the said letter dated 8th October 2000. I also made representation dated as member secretary of the school requesting him to approve my appointment as the principal of the school, but till date I have not received any commission from him. In the subsequent, I relied upon the approval of the principal of the school. How can they? I also relied upon the approval from the other considered case the principal of the school. Similar to circumstances of the school. Therefore, request you to justice by approving my appointment as the principal of the school with effect from 1st December 2005 to grant sale of pay of the principal, modifying the order number 11 July 2005 issued by in 15 days from the issued letter, telling which had no authority but to move the application to his control. Then, all along his control, since I've been when the recognition was granted by the government, I was the principal. I was appointed by the managing committee as the organization staff, and I should be appointed the principal. But at the time of when the government has recognized in 2006, he has already MA in history. He has no requisite qualification for the post of principal. What is the essential qualification? He must have a master degree in psychology. Because two types of schools are there. So, sorry, three types of schools. Mentally retarded, blind, three types of schools are there. And they are admitting the students, two types of students.
This is multiple handicap, where this MA in psychology is necessary. MA or MSc in psychology.
Psychology is necessary.
That the learned single judge has also considered.
Now, whether this gentleman, apparently before can be appointed as a principal of the college or school for a particular type of children in the society without having requisite qualification, because his claim is that from initial record 2006 I should be given a appointment.
He is relying only on clause 1 of page 70.
Yeah.
But you say there itself it is written that the organizing staff having requisite qualifications, that is there.
Yes. This is page 70. This is
70, yes.
It's troubling me. Page 70. The organizing staff requisite qualifications training will be.
So you said this has to be read with the first sentence.
If he has got the qualification at the time of recognition by the government, then certainly he will entitled to get the principal. But now he has acquired the qualification subsequently, whether that can be qualified for appointment of the principal, because now principal post is lying vacant for a long time because of litigation is pending. We are not in a position to fill up the post.
Mr. Mukherjee, suppose he now has the qualification. Why can't he be promoted? I mean, is there any bar?
Now we shall have to face selection process.
Yes.
because we should have advertised the post. Then the
You
application.
have to advertise and he can participate there also.
Yeah, participate. Only address can be granted by the court for the age bar, because age bar is 45 years.
Oh, he must be over that now.
Must be most probably.
3 or 4 years left from retirement.
Very well, Mr. Mukherjee. Let us come back to him. Yes, Mr. Das.
Yes,
The first sentence has to be read with the last sentence.
Lordship,
Because
kindly,
it will otherwise compromise this special needs of the children there also.
Lordship, kindly come to page
MA in
170.
history is different
No.
from MA in psychology.
Lordship, kindly see initial qualification for the principal, page 117. Judgment of the trial court, Lordship.
Yes.
Lordship, last portion, the requisite qualification for the post of principal, headmaster,
This is not blind. This is multiple handicapped.
for the blind as described in the schedule.
Blind is a different category only for the blind people. And
Yes.
this is not only for blind. This is for multiple handicap,
Yes.
which you started with. You say visually handicapped as well as mentally retarded or mentally handicapped.
Yes.
So it's multiple handicap. So therefore, only blind school, that criterion is not applicable to you, to this school.
But when
Leonard Single just discusses it at length.
loss. But when the authority take over, loss, another thing also I am showing there, loss. Page kindly come to page 72.
Yes, 72.
72 loss.
Principal post is there.
No. I on another thing, loss you are showing.
Yes.
Total sanction post 23. Loss you got it.
Mm.
Then loss page 73. Initially approved 19%. My name is 1. Gautam Kumar Saswal. 19%. Thereafter loss page 75.
Yes.
4%. 23. Total number. Before takeover, existing staff 23. As per page 70. Enter 23 was takeover. Only the post of principal to another.
Did not have
Then one
the
post is excess. One post is excess.
They undertook to absorb all the organizing staff having requisite qualification. So according to your qualification, you have been absorbed as an assistant teacher.
And another thing, Lordship, till date, no advertisement was there. If the advertisement was there,
That
my
is entirely beyond your writ petition.
my client can.
It's not a public interest litigation, or even
No,
you, that
no,
is
no.
not the cause you have espoused in your writ petition.
No, only one thing, Lordship. If the advertisement was done,
We'll
then
make it
my
clear
client-
that the advertisement should be, Mr. Mukherjee,
my
will make
client
that
can
clear
take a chance.
in our order that you will, because the principal post is lying vacant. We can fix a timeline. What will be suitable? What should you say will be a suitable timeline? 1 month, 2 months for advertising and filling up the principal post.
Maximum 3 months.
We'll give you that. But we'll not interfere. We'll just put in that writer.
No.
You can participate in that
Lordship.
advertisement.
Then Lordship, my giving liberty to
You have the liberty. We'll make it clear.
Age limit.
Oh, sorry.
Age limit must.
No, you are not. You don't have the liberty.
Age limit must be gone down, Lordship. Otherwise, I cannot.
No. Then we are not interfering.
As per my only submission, as per page 70, government
Yes.
take over whatever may be.
You have heard that, yes. The writ petitioner challenges an order passed by the learned single judge dated December 15, 2011, whereby the appellant's writ petition was dismissed. Full stop. The short backdrop of the case is that the appellant was functioning as the principal of one Vivekananda Lok Shiksha Niketan in the district of Purvo Medinipur. For sub next para, the educational qualification of the appellant was a master's degree in history. For sub next para, the said institution was subsequently considered for sponsorship by the state of West Bengal and by a government order Vide memo number 134 MEE block A stroke capital S small ECTT full stop stroke 3 apostrophe capital S apostrophe hyphen 57 by 04 dated February 8, 2006 এর page 70 তে পাবে এই memo detail dated February 8, 2006 comma the said sponsorship sanction was granted. Full stop. Next para. The petitioner, the appellant argues that the appellant, comma, since already functioning as a principal of the said school and a sanctioned post of principal was contemplated within the sanction order itself, comma, ought to have been appointed as a principal. Full stop. However, comma, he was demoted to the post of assistant teacher while the appointment list came out after the sponsorship was taken over by the state government. For the next para, learned counsel for the appellant places particular reliance on clause 1 of the government orders of Geo Capital dated February 8, 2006, which is as follows. Colon দিয়ে italics page 70 তে ওয়ানটা আমরা লাল দিয়ে দিয়েছি। Next, it is argued that in terms of the said clause, comma, the existing teaching and non-teaching regular staff of the institution were to be absorbed against their respective posts, comma, as sanctioned therein, and were to be placed in their respective scales of pay. Full stop. Enclosed to the said government order was an annexure where it was reflected that that one post of principal was also sanctioned. Full stop. Next para. However, comma, upon the appellant approaching the state authorities with the grievance that he ought to have been appointed as a principal in terms of the government order, comma, by an order dated March 23, 2011, comma, the director of mass education extension, comma, government of West Bengal refused such application on the ground that the appellant was not entitled to get promotion to the post of principal from assistant teacher merely by virtue of having subsequently acquired the educational qualification of a master's degree in psychology. Full stop. It is contended that irrespective of the MA in psychology having been acquired subsequently by the appellant, comma, by dint of the government order itself, comma, the appellant was entitled to the post of principal. Full stop. Hence, comma, it is contended that the learned single judge failed to take into consideration the impact of the said government order in dismissing the writ petition filed against the refusal of the writ petitioner's stroke appellant's prayer for being appointed as a principal. Full stop. Next para. Learned senior advocate appearing on behalf of the state controverts the arguments of the appellant and submits that the learned single judge clearly took into consideration the extant rules which, comma, for the purpose of mentally stroke multiple handicapped schools, comma, stipulates MA or MSc in psychology as a prerequisite essential qualification for appointment as principal. Full stop. Since the appellant was only a master, an MA in history at the relevant juncture of the sponsorship being taken over by the government, comma, the appellant was not entitled to be appointed as a principal, comma, although one post of principal was sanctioned from the inception. Full stop. Next para, it is submitted that the said post cannot be filled up by way of promotion, but a regular advertisement has to be issued in terms of law for the said to fill up the said post. Full stop. As such, comma, the subsequent acquisition of MA degree in psychology does not help the case of the appellant in any manner. Full stop. Next para. Learned senior counsel further submits that clause A itself stipulated that the organizing staff having requisite qualification and training would be absorbed in the teaching posts, full stop. Thus, comma, since the appellant did not have the requisite qualification for the post of principal, comma, he was rightly appointed in the post of assistant teacher. For the next para, upon a careful scrutiny of the provisions of the government order dated February 8, 2006, comma, we find substance in the contention of the state. Full stop. The first sentence of clause 1 of the said government order cannot be read in isolation, but has to be read in conjunction with the last sentence thereof, comma, in its entirety. Full stop. Next para. Whereas the first sentence of clause 1 stipulates that the existing teaching and non-teaching regular staff of the institution will be absorbed against the respective posts as sanctioned therein, comma, at the end of the said clause, it is clearly provided that the organizing staff having requisite qualification and training will be absorbed in the teaching posts. Full stop. Next para. Even in the refusal by the Director of Mass Education Extension of the request of the appellant to be appointed as a principal, comma, the director construed the expression double inverted organizing staff as the staff who were already working in the institution before the sponsorship was taken over by the state. Full stop. In the said refusal dated March 23, 2011, comma, it was recorded by the director, comma, inter alia, comma, that the petitioner apostrophe's name was approved against a post of assistant teacher, although the school authority appointed the petitioner as principal during the double inverted organizing period, double inverted close, that is, before getting academic recognition and sponsorship. Full stop. Next para. The appellant sought to draw parity with two other people, namely Ohin De, comma, principal, comma, Sathi, comma, Paschim Medinipur, and Kajol Kumar Reza, comma, principal, comma, Burdwan Blind Academy, comma, Burdwan, which was dealt with by the director in his refusal by stating that those two persons had the requisite qualification to become principals in their respective schools. Full stop. Next para. It is an admitted position that the appellant did not have the requisite qualification for the post of principal in a mentally handicapped stroke multiple handicapped school as the present school, that is the Vivekananda Lok Shiksha Niketan, comma, in terms of the eligibility criteria fixed by the extant rules, comma, which were discussed at length by the learned single judge while passing the impugned order. Full stop. Next para. We cannot also overlook the fact that the expression used in clause 1 is that the existing teaching and non-teaching regular staff of the institution will be absorbed against the double inverted the double inverted close respective posts, comma, as sanctioned therein, and will be placed in our data double inverted the respective scales of pay. Full stop. The conscious use of the expression double inverted the, comma, instead of double inverted there, their, double inverted close, clearly indicates the purport of the said government order. Full stop. If the intention and understanding of the parties was that the existing teaching and non-teaching regular staff would be absorbed in their respective posts, their title, their respective posts and scales of pay, comma, the expression double inverted there would be used instead of double inverted the. Full stop. Such couching of language of the said clause clearly indicates that that by the expression double inverted the respective posts as sanctioned herein, double inverted close, comma, the posts as sanctioned and reflected in the list annexed to the government order was to be considered in the context of the requisite qualification for such posts. First up, the said meaning is amply clarified in the last portion of clause 1 by stating that the organizing staff double inverted মধ্যে having requisite qualification and training double inverted clause would be absorbed in the teaching posts. Full stop. Hence, comma, there cannot be any manner of doubt that in order to be absorbed in the post where he was working, comma, the appellant would have to qualify for the post of principal as per the extant rules of the state. Full stop. Next para. However, comma, as discussed above, comma, since the appellant did not have such qualification at the relevant point of time, comma, we do not find any illegality in the order of the learned single judge, whereby the rejection of the petitioner's prayer for petitioner's application for being appointed as principal in the said school was refused. Full stop. Next para. However, moreover, comma, we cannot also lose sight of the fact that the educational qualification of a teacher or a principal of a school is always inextricably tied hyphen up with the requirements of the said school. Full stop. In the present case, comma, we are looking at a situation where special training has to be imparted to children who are either visually impaired or mentally challenged in some manner or the other, comma, thereby categorizing the school, characterizing the school as one for multiple handicapped, double inverted মধ্যে. Full stop. Next para. Hence, comma, keeping in context the special needs of the students of the said school, comma, since the government consciously chose MA or MSc in psychology over a master's degree in other subjects, comma, and there being a direct nexus between the said choice and the service nature of service required to be rendered in such schools, comma, we are of the opinion that the refusal of the petitioner's application for appointment as a principal without having the requisite qualification would be detrimental to the interest of the students of the school as well. Full stop. Thus, comma, from all perspectives, comma, we are of the opinion that the learned trial judge was justified in dismissing the writ petition. Full stop. However, comma, in the interest of the students of the said school, comma, who have certain special needs in society, comma, we hereby direct the state to immediately initiate the procedure for appointment of a regular principal in the vacant post in the concerned school, that is the Vivekananda Lok Shiksha Niketan. Full stop. It is expected that the entire exercise of advertising and necessary paraphernalia as well as appointment in the vacant post of principal shall be concluded as expeditiously as possible, comma, preferably by the end of February, comma, 2026. Full stop. Next para. With the above observations, comma, FMA 1092 of 2012 is dismissed on contest without any order as to costs, thereby affirming the impugned order dated December 15, 2011, passed in WP number 7727 within bracket W of 2011. Full stop. Next para. Can such and such যদি pending কিছু থাকে is আছে that's it. No order as to cost, urgency to it.
Petitioner
প্রথমে লাইনে লিখে দিই affidavit in operation filed to be
also appellant can be participate also
you don't have to
regarding
Acha, very well. It is further clarified that in the event the appellant is otherwise eligible to so participate, comma, it will be open to the appellant to participate in the advertisement and the appointment process for principal for the post of principal in the said school as per or above direction. Yes. To be initiated as per or above direction. Last. Thank you. Next.
I beg to appear on behalf of the respondent.
Yes.
With this the leave-in license of an office space. It is kind of a workspace leave-in license agreement in 2020 in 2005 for 1 year, for 11 months, 1 year. With all that, not only do the parties agree to the relationship being leave-in license expressly said,
You are the licensee or the
licensor. But all the telltale clauses of a license are there, as in use the common bathroom, you can use the office space there. Electricity, power will be backup power will be supplied by us, etc. Right to inspect whenever we want to. So after the first year, there's a renewal in 2006, 11 months. Then 2007 is the last and final renewal on 1st August 2007. There's a clause in the agreement, on all these agreements, that there'll be 3 months notice one can terminate. So
the 3 months notice termination goes in their favor. In a sense, they'll be obviously arguing that.
But
so license can be immediately terminated.
Yes, license, but then, as my lord judgment says, doesn't mean every day it can be. If there's right of protection, so does not mean giving some right of protection does not mean that license has to be terminated every terminable. Be that as it may, my lord, we don't have to go that far, because in March 2008 we give a notice of 3 months come expiry. So it's going to expire in 29 June 2008. So we write 3 months and 4 days ahead, saying that it's going to expire on on the 29th of June 2000. No, sorry, on 30th June 2018. With a reminder 1 day before that, 29th June, that please vacate it. And so on 25th of, but they don't vacate. On 25th July 2008, 1 month thereafter, we return the security deposit. Check we send with the letter, which is sent by post. The check is encashed.
They encash it?
Encashed. The check is encashed.
Well, that's not the correct position. I didn't encash.
All right. Their case, of course, is that this way. Adhika, you come next. He died. That's why I stressed on the word sent by sent by post. So their case, I don't know what is their case, because there's no statement filed. But they
check you say has been encashed. That you know from your.
That's matter of record. That's a matter of record. They are trying to argue that that we took back the check and we deposited in their account. So check and cash, no doubt, no dispute about that.
So you took back the check and you deposited
and deposited in the account. That's why I stressed on the word sent by post, not hand delivered, that they don't accept it and then they take the check back and deposit it in the account. But anyway, the money goes into the account. Now,
you wrote a check and put it in their account.
That's they kind. But
I put it in my account without my knowledge.
Without it.
But
And when the moment I came to know that it has been encashed, I returned the money at once by another check.
No.
That's my instruction.
That's
will come to that.
Yes. So it was sent by post. That's why I'm stressing on the word. Now, Lordship, the no statement filed.
No written statement filed.
No, they filed a.
No cross-examination done.
They file a Order 7 Rule 11 application, which is dismissed. From that, they file a revision.
Order 7 Rule 11 on what ground, Mr.?
That you should have gone to the Presidency Insolvency Court.
Jurisdiction.
Small causes court.
Turned down after
Turned
this
down.
court.
Turned down, filed revision, and then they abandoned the revision.
Or civilly rejected.
Civil division, they did not press it. It got dismissed for default. Thereafter, they did not participate anymore. And judgment is rather unfortunate, because it is held that they had taken back the money.
Judge might be capricious, seeing the name of the judge. Is one Mr. Capri.
Oh, So, Mr. Kapri, sorry. Yes. Would you kindly come to page 18? May I read it out the judgment?
Yes.
Third paragraph is summons served. Thereafter, it did not turn up to contest. During the hearing of the suit, one
You adduced evidence in the suit.
Yes. Chief given, no cross-examination.
Dismissed. Or on a construction of the document.
So, well, no, not dismissed. It is since there is an averment by me that I have.
There's no exclusive possession.
There's no exclusive possession to them.
You can place the judgment. Very short judgment.
May I place the judgment?
Let's start with that.
Page 18, last paragraph.
Yes.
The plaintiff's case is that the suit premises described in the schedule to the plaintiff belongs to it, and the defendant was inducted as licensee to that premises on 18th August 2005 by virtue of an agreement executed for about a year. The defendant also made a non-refundable deposit of 42,000 and also some of 42,000, further some of 42,000 as refundable interest-free deposit. The license was renewed also from time to time since its inception, and last of all of it was renewed on 1st August 2007. Thereafter, the license of the defendant was terminated by the company by two letters of 25th March and 29th June 2008, with effect from 1st July 2008. The defendant was directed by those two letters to make over the vacant and unencumbered possession of the suit premises to the plaintiff by 30th June 2008. But the defendant did not respond in compliance with these two letters. The vacant possession of the suit premises was not delivered, was not delivered to the plaintiff as alleged in the plaint, and therefore the plaintiff has been compelled to file the instant suit for recovery of khas possession of suit premises, also for recovery of damages of 39,000 for period so and so. In the instant case, the plaintiff has prayed for recovery of khas possession from the defendant. A prayer of such ilk is maintainable only when the plaintiff has not got the possession of the suit premises. But if the possession of the suit premises is already taken over by the plaintiff, the prayer for recovery of khas possession by the plaintiff appears to be no longer maintainable. Coming to the facts of the instant case, it is found that the plaintiff has already acquired possession of the suit premises. This is the averment. This is the catch. It is the averment of the plaintiff that the defendant was never in exclusive possession of the suit premises, and that the lock and key of the suit premises was always in the possession of the security guards of the plaintiff company. Paragraph 5 of the plaintiff appears to be most pertinent in this regard, and I like to produce it. Reproduce below. The defendant has never been in exclusive possession and never has had control of the suit of the demise premises. The premises was always locked by the plaintiff's security guards, and the defendant never had uninterrupted possession. The defendant also did not complain of the same. In the evidence filed under Order 18, Rule 4 of CPC by PW1, the same is reiterated by the plaintiff company. Paragraph number 5. From the averments and evidence of the plaintiff as referred to above, it is clear that the defendant was never in exclusive possession of suit premises after expiry of the term of the lease. The lease license, the term of license expires on 30th June 2008, as stated by the plaintiff company, both in the plaint and in the evidence. The refundable deposit of 42,000 was also paid to the defendant by the encashed the check on 2nd August 2008. All these are stated by the plaintiff company in the affidavit of evidence. So it is found that the defendant, by his conduct, showed his intention that he had surrendered the possession of the suit premises to the plaintiff company, and that he was not further willing to renew the term of the license anymore. Had the defendant had any intention not to surrender the possession of the suit premises in favor of the plaintiff, he would not have withdrawn the amount deposited by him. The withdrawal of the refundable amount of deposit indicates only that the defendant had an intention to put an end to the license taken by the plaintiff company. The plaintiff company has also taken over possession of the suit premises, and it is manifestly clear from the averment and evidence of the plaintiff. So the fact remains that the defendant had surrendered the possession of the suit premises to the plaintiff company, and that the plaintiff company has taken over the possession by putting lock and key to it, as goes the averment and evidence of the plaintiff company. If this be so, I feel no vestige of
Ms.
it.
Mitra, there is no cross objection to this?
No.
My lord, may I state? No.
You're not there from the beginning, you must be.
I was not here from the, my lord, may I state the background of the case?
No, let him complete. We'll come back to. We just ask you whether there is in cross objection. No cross objection.
It was-
So you're not in possession.
Yes, it was hard ex party.
That was my lord's reaction
There's been
when
a cross objection against this.
My lord,
Anyway, it's not there.
that
We
was
won't
not
permit
done.
you now.
It's not done.
Acha, let him complete. Then we'll come back.
that's why when Mr. Jointamitra is my leader, when he moved that your lordship says that you could have walked in.
You walk in. Yes. Why have you come to this
Why have
court?
you come to the court? Why have you come up in appeal? That was
Okay.
my lord's first reaction.
So Ms. Mitra's client out. She has not preferred an appeal.
Little bit of background before I come to the plaint. Thereafter, this company Nico goes into liquidation.
I had a very mischievous friend, Mr. Mitra, who a person had expired. When we went to the ceremony, the in the post box, letter box, it was written in. So he just made it out. I mean, you just can do that to them. After this judgment, if it's not challenged, I mean, I was the most innocent of my friends, obviously. So, but this, so you can just do this to them. I mean, you can just put the letter box from in to out. Why have you come to this court if you don't
And
understand?
that is the well, thereafter this company goes into liquidation. The liquidator takes
You have gone into liquidation.
Nico Corporation. Then
Yes,
it is
you did
sold.
Nico.
Yes, sold. It is purchased by the new purchaser who is substituted in place of the
That
plaintiff.
has already happened.
That's already happened by my lord. By my lord on 5th of August.
So you
That's
want to cite anything?
No, Lordship, just no judgment. Lordship, kindly just come to the averment. It is not our
Yes,
case
your
that-
averment is necessary.
Yes. Lordship kindly comes to the plaint. The plaint starts as it is the first document.
But one thing, Mr. Mitro, there is one impediment in your way. That is, even if you hold, obviously this judgment cannot be sustained in a sense. But the trial judge, learned trial judge did not take into consideration whether it's a license on merits. So we have to remand it then. That would not any to your benefit.
Lordship, it will not any to my
Then
lord
you have to
benefit.
also satisfy us on
Yes.
because
That's why I wanted to show the license agreement also.
your averment, the license agreement,
And
is
the
to-
averments and
your evidence must be in line with your.
evidence and no denial of my averment.
No, because there was no,
No
it was
statement.
expertise.
No attempt to.
Because if
Now
we
the-
remand now, then it will have
There'll
to be
be-
also expertise, again expertise, but there will be reconsideration of the evidence on record.
But Lordship, that
So
may
we
not
can
be
consider Order 14 Rule 24.
Exactly.
Very well.
But then here I would request, while the documents are very clear, remand may not be.
24, that's
Re-
right.
remand-
24 is that we have to consider.
Yes. So 24.
In between. 25, 23 and 24.
Lordship kindly
Yes.
comes to
Yes.
page 3. That is the fateful paragraph is paragraph 5.
Page 3.
Page 3. The plain
Page
starts
3 of
at page 1.
You have got a copy of the paper book, Ms. Smith?
Yes, I have.
Page 3 of that.
Page 1, the plain starts. And paragraph 4, page 3 is the leave-in license. Now from paragraph 5, the defendant has never been in exclusive possession.
But that has to be in all licensee eviction suits.
But that I have not got back possession is very
if you
clear.
said they're in exclusive possession, then the licensee suit would go.
Suit will go. Now, let you kindly see paragraph 11, where I specifically said refuse to vacate the possession.
And that is recorded in the first portion of the impugned judgment also.
I have page 5, paragraph 10, check was deposited and encashed by the defendant. Defendant agreed to vacate. Yes, up to that is correct. Liable to vacate, but then it is 11 and 13 refused to vacate. So that it is the plaint case is very clear that it is.
Yes. And now the
document. The document, Lordship, kindly comes to the leave-in license agreement. The original leave-in license agreement is at page 39.
The subsequent agreements follow the same.
Exactly the same. So I will show the original and then just the renewals for the record.
Yes.
Page 39. Agreement in bold for leave-in license.
That doesn't mean anything.
No, but parties when they agree and when there's a lawyer,
Yeah, I mean bold and block letters.
no, Lordship, there is a
You always do that.
the plaintiff is the company, the defendant is
That creates a doubt, in fact.
Well,
In bold and capital letters, that creates a doubt that it may not be so bold. But it includes his successors, Mr.
That is the word successor is there.
Kindly consider the nature and character of the leave and license agreement.
Yes, we are doing that.
Really leave and license or a tenancy?
That is what we are doing.
I'm grateful to you.
Which expression shall, unless excluded, successors in a license?
In business.
Then in business, Lordship cases include successors, executors, administrators, legal representatives, hereinafter referred to as licensee.
There is a qualification in.
Now, Lordship kindly comes, yes, that is there, but then that Lordship is.
He was a human being, I mean, natural person.
Natural person.
So therefore,
Natural person.
including this goes against you first.
Then come
We
to
find out the clauses against you.
Yes. I will
That you
show
can
all the,
answer.
it's a very short
No,
topic.
no, obviously you show all the clauses.
Last clause on that page, whereas the licensor desires to grant license in respect of its surplus space available for utilizing the office space on the second floor of the said license. Surplus space available for utilizing the office space. And then page 40, grant license for utilizing for office space. Now, clause 1, it is the standard clause, leave in license. License fee, service charges, etc. 11 months is mentioned in clause 1, 11 months, commencing from 1st October 2005. And yes, rightly pointed out, it's only for office purposes. Now, Lordship kindly comes to clause 3 you want to rely.
Yes.
The licensee shall also pay the following charges in addition to the license fee aforesaid. Service charges, 1 rupee per square. Then proportionate amount of occupier's share of municipal taxes and the commercial surcharge, rupees so and so on, every quarter aggregating to so and so. Licensee shall install a submeter at his cost for use of electricity to be supplied by licensor at his said office space, and the licensor shall raise a bill for the electricity as consumed by the licensee. Licensee and the licensee shall pay the electricity charges in accordance with the actual reading of the submeter on or before the 7th day of every month. However, the charges shall be on the basis of the present rate per tariff unit. So not his own meter, sub-meter. Then clause 4. The licensee shall further deposit a sum of 42,250 as non-refundable security deposit for the purpose of upkeep of the office space, as also an amount of 42,240 as refundable interest-free security deposit, which will be refunded by the licensor on expiry of the term of his license and getting basic vacant possession of the office space from that. So, encashing this check is also a lot of importance. On expiry and vacant possession and getting vacant possession. Now, assignment, now clause 6. Terminate the license agreement, even if it's 11 months, even then it can be terminated by 3 months notice. So it can be, so it's reduced to even lesser right. Now, the licensee shall be at liberty to make necessary painting and other interior
May I just draw attention to clause 6.
Ms. Mithu, let him complete. You'll have your chance.
I shall please once more. The license agreement could be terminated by the second party, stroke licensee, on giving 3 months prior notice to that effect to the other party licensor. He can terminate by 3 months notice. The licensee shall, yes, he can terminate. Licensee shall be at liberty to make necessary paintings and other required interior decoration for taking up its office at the office space without changing the basic nature and structure of the building, only with prior permission of the licensor. That too with prior permission. Then 8 is very important. The licensor shall provide the normal amenities and facilities for lift, service, 24 hours water supply and common toilet. So it's not a full-fledged functional unit.
It's not unknown that in tenancies also sometimes there's a common toilet. Common toilet user is given. But it's a tenancy.
But those are more on the indication of a self. It's not a self-contained unit. Like one common
but-
toilet, separate of many office
The
spaces.
license or tenancy is for the office space. The toilet may be common, right of user may be added to that.
Not
It may be an amenity of the tenancy also. I mean, that does not by
Then
itself.
second paragraph 8, in case due to power failure, if a backup power produced through a generator is required by the licensee, the same could be arranged by the licensor, subject to payment of necessary cost to be borne by licensee for the same, including installation. That also my right to give them backup power. Submeter under me, not direct. Then 9. Licensee shall permit the licensor or its duly authorized representative to enter upon the office space for inspecting the state and condition of the same at all reasonable time during the period of leave and license after giving prior notice for the same. Then 10 is a more standard clause. 11. It is agreed that on expiry of the term of each license period, the licensee may request for renewal of the arrangement for a further period of 11 months, and the licensor shall consider the same, subject to the terms and conditions that may be mutually agreed upon between the parties.
14 is very explicit. Clause 14 is
Very explicit, clause 14. And when it is a matter of record that one side is a company, other side is an
Educated person.
is an advocate.
Oh, advocate. That's on record.
And that's
Have you ever anywhere?
Avarment আছে কিনা দেখো মানে that
In their Order 7 Rule 11 application, you can find out maybe in the affidavit.
Yes. Defendant, yes. First paragraph in the plaint, page 2. Defendant is a tax consultant and an advocate and was known to some of the senior officials of the plaintiff. Paragraph 1, page 2.
Withdrawal indicates that your intention to put an end to the license taken by from the plaintiff company.
Oh, man, every page is signed as an advocate. Lordship sees that rubber stamp, my junior points out. On page 40.
Yes.
42 rubber stamp.
This was not a revenue matter. Clause 14 is your best clause.
Clause 14 is, and when parties knowingly agree to a certain term. And then, Lordship, the conduct. This doesn't continue indefinitely. After there's the renewal, page 47.
Yes. Must be similar.
Then same terms. And the final.
If there is any difference, you can point out.
No. And the final renewal is page 52. Pre-deposit amount changes by junior points out. Now page 52 is the final renewal, but so every year it is being renewed.
Main clauses remain the same.
So it's a fresh.
Let us see the last renewal and
page 52.
Notwithstanding is there. Yes. 12. Right.
Clause 14 becomes clause 12. Now, my lordship. Now, lordship kindly comes to the letter which we gave on 25th of March, page 57. You are aware that you're holding an office space of 88 square feet, second floor, renewal up to 11 months, leave and license reference. Please be informed that though were requested by the letter dated 17 March, you purportedly failed and neglected to deposit your monthly rent.
You give a 3 months notice.
3 months notice plus expiry, because 3 months notice is really his right, but we informed them 3 months in advance.
Yes.
And the failure to deposit rent, Lordship kindly sees, have failed and neglected to deposit your monthly rent within 7 days.
Monthly rent?
Monthly rent.
License fee. In advance, as per recitals of the leave and license agreement.
Yes.
And
that was a copy paste error.
And subsequent renewal agreement, so and so. Your rent for current months outstanding. In view of the above, you're called upon to hand over vacant possession on 30th June. As we do not propose to renew your leave and license agreement any further. Please treat this as a notice to vacate under clause 5. Well, normally when someone comes to finalize a leave and license case, I would say alternatively make a case of 106 also, because if it is above that, because one can't take a chance. Then page 58. This is important because in terms of our earlier letter of 25th March 2008, and duly acknowledged from your end, you are called upon to hand over vacant unencumbered possession of your respective space forthwith, as we do not propose to renew the leave and license. Please take note that your agreement expires on 30th of July. This is a reminder, on 30th July, and as such you have to hand over possession.
Mr. Mitra, what is the monthly license fee?
Lastly was 3,000.
3,000 only possession.
Last time, I will just tell you. The last one was 4,000. 3620 per month license fee. Lodge.
Nothing. Look at the rest to my case that this is a tenancy. Tenancy মধ্যে পড়তো otherwise যদি tenancy হতো. But notwithstanding anything clause Yes.
The vital letter is page 59, last page. That is the vital letter sent by post, which is the one I was stressing upon.
Yes.
So send by post, page 59. Speed post with AD and the postal receipt is there. The third paragraph, second paragraph, we again say that you are liable to vacate because and you are a trespasser because time has expired and you still continue. Then paragraph 3. Now, in terms of clause 3 of the leave and license agreement, dated 1st August, enclosed, please find a check of rupees 42,240 towards refund of full amount of your interest-free refundable security deposit. In terms of the said leave and license agreement, you are hereby called upon to forthwith vacate the space still occupied by you, failing which necessary measures to prevent such trespassing at your cost.
This was my evidence for that. Defendants are encashed the said check on 2nd August.
Now,
There's been no cross-examination, nothing on this fact. It's been recorded also in the order. There's been encashed.
Then page 13. Is the affidavit of evidence, and I am showing page 16.
Yes.
Paragraph 9. I say that the refundable security deposit of 42,240 was also returned to the defendant by a check by number so and so. And the defendant has encashed the said check on 2nd August 2008. The covering letter is enclosed. So, no, as I said, no cross-examination. And evidence given, and after that, this is the finding of the court. Now, the finding totally goes against them because the decree is neither here nor there. As a slightly more bolder landlord may have just walked in. Being a company, being a quoted company, listed, etc., etc. So they couldn't risk it. Of course, they ultimately went in liquidation. That's a different.
That's the misfortune of coming to decent people for legal advice. That's the misfortune of coming to decent people for legal advice.
So no lawyer could also say that you go and take possession forcefully.
Is it?
Well, one would not take a chance because there will be a criminal case, etc., against the directors, and who would not like directors being exposed to criminal? I mean, this is a conservative approach. Breaking into the
Good that in the original side you have the safety cocoon of the solicitor firms.
and
So many things don't infiltrate to you.
that's true, absolutely true. And there's a lawyer working there, so just breaking in means forcibly at night when he's not in office. So the entire finding here, this is not a case where the order has gone in his favor. So for that, he need not file a plea. It's an order, which is a judgment has gone against him,
Records that they're not in possession.
not in possession, and he has encashed the check. He has surrendered
That there is
possession.
some doubt probably. But you see, you say that that cannot be doubted because it's no cross-examination
and sent by post also. So taking back
there was evidence and that was accepted by
evidence.
And that he surrendered possession is also fine.
Yes, there is a finding.
There's a finding. Well, that's
No cross-examination. That's your part of it. So we'll continue with, we'll start with you, Ms. Mitra, after the recess.
My lord, one indictment at 2 p.m. a fixed matter. The very next matter is mine, my lord. My junior may ask for an adjournment.
Yes, Junior may ask, but we'll ensure that Ms. Mitra finishes quickly and we take up your matter when you are not here.
No.
Where? Which court?
Court number 3, my lord.
He'll come back before you finish. Yes.
But for a second before my revered senior starts, but if your lordship just has a look at page 61 of the paper book, just to show that the acknowledgement due by which that letter was sent along with page 60.
60.
60.
0.
Well,
Please have a look at the right hand corner. Your lordship will find it was
Yes,
received on 29th of July 2008, and there's a recording of fact that on 2nd of August 2008, I'm just showing the proximity also, it was actually encashed.
yes, yes.
May I be first allow me to place the little background of this case.
Yes.
My lord, the suit was filed as leave-in license before the City Civil Court, Calcutta.
Correct.
Now, I took an objection that if I am a licensee and it's coming under the leave-in license, therefore City Civil Court has no jurisdiction. It is the absolute jurisdiction of the Small Cause Court, President Small Cause Court. My petition was rejected, application was rejected. I preferred a revision before the Honorable High Court. Now, the Honorable High Court admitted that and granted a stay of all further proceedings of the suit. Now, unfortunately, it was not appearing for long in the list. The suit was stayed, but I missed the list. It suddenly appeared in the list, and it was dismissed for default, and the stay was vacated. Coming to know of this, I have filed, this is already pending in the court, that for restoration of that application. Now, thereafter, without giving me any notice, the plaintiff went to the City Civil Court, brought the matter in the list, and got it heard ex parte. So I didn't have the opportunity to file any written statement or objection to them. But having said that, your lordship has, my first point is this. If it's a leave-in license, one has to go to the Small Cause Court, Calcutta. President Small Cause Court, Calcutta. So this court has no jurisdiction, but still that is not decided. I will not be on that, but I will only, I know your lordship has gone through the leave-in license agreement. I will only point out certain things once again for my own satisfaction. Well, at page 39, whether these clauses goes with the leave-in license, because license is absolutely a personal matter, allowing the licensee to stay as long as the licensor wishes. Licensee has no right over the property, no exclusive possession of the property. And it is both evident in the pleadings and in the evidence that I am, their case is that I am not in exclusive possession. Even the key of the door, lock and key, is with the landlord. So therefore, no question of handing over the possession. And the learned trial judge is absolutely right on this point. Now, on this regard to that, before I place it, that I accepted the check, it is not a fact. They send me, yes, they send me this, but only a letter. Check was not in this envelope. They deposited the check of their own, and it got encashed automatically. Coming to know of that, I returned, but I could not place all these things on evidence because it was ex parte totally. Now I come to page 39. Well, 2,500 between Eco Corporation Limited to Hare Street, Calcutta 1, hereinafter referred to as the licensor, which expression shall, unless excluded or repugnant to the subject, be deemed to mean includes its successor in business and assignees, whether this goes with the license agreement or it is binding even upon the successor. Then, my lord, clause 2. License fee shall be, the licensee shall pay to the licensor a sum of rupees 3,520 per month as license fee on or before 7th of each and every English calendar month. Then C, the licensee shall install a submeter at his cost, use electricity to be supplied by the licensor. So I was even allowed to install a meter, maybe a sub-meter, but a meter, like electricity meter. Then, clause 6, the licensee has alone got the power to terminate the license agreement. It speaks volume, I think. And then 7, the licensee shall be at liberty to make necessary painting and other required interior decoration. I will spend my money, take sub-meter, decorate the building, and only for 11 months. For taking up her its own office at the same space without changing the basic nature and structure of the building, only with the prior permission of the licensor. Then, my lord, your lordship will kindly come to page 57, paragraph 2. Please be informed that though you were by letter number such and such, copy and close, you have purportedly failed and neglected to deposit your monthly rent, not license fee.
Twice used.
So,
Twice, again in the 2 sentences after that.
yes.
Your rent for the current month.
Rent. And therefore, my lord, whether I am a tenant or a licensee, in my humble submission, and my lord, I could not produce the document before the trial court because it's got ex parte. I am depositing the rent with the rent controller. And the rent controller, by his learned rent controller, by his order, has accepted me as a tenant. And then my learned friend will show you the document when the company went for liquidation, the original company, the transferor, the company which was in liquidation. And the liquidator took over the possession and handed over the possession to the present landlord. Specifically stated with the tenancies. Therefore, I have very small submission to make. First, if it is a case under license, leave and license, the proper forum is Small Causes Court, President Small Causes Court, Calcutta, and not the City Civil Court. And my second point is this: I am not a licensee, I am a tenant. Yes, I am liable to be evicted, ejected, but as per the Premises Tenancy Act. These are my small submission. My learned wants to show you some documents. It is his personal case.
No, even then, you show us. He's represented by counsel, please no.
So next matter.
Next matter. There are 2 matters. 7 and 8.
Why 2 matters? 2 premises?
Portions of the.
Yes, Mr. Datta. It was a common judgment. But the judgment must be common.
Mostly type copy and paste.
Achha.
See common.
Cited.
Two separate judgments. And
Language is identical.
yes.
There is the petitioner, the plaintiff wanted to file a suit for declaring him as a tenant. Huh? Reported judgment copy. I straight away come to.
Yeah, 2005 Calcutta 295.
Yes, I straight away come to paragraph 21.
Yes.
The next question is whether the alleged agreement of license was really a license or a lease. In this connection, we may profitably refer to the following text laid down by the Supreme Court in the case of Associated Hotels of India Limited versus R.N. Kapoor, reported in such and such. To ascertain whether a document creates a license or lease, the substance of the document must be preferred to the form. The real test is the intention of the parties, whether they intended to create a lease or a license. If the document creates an interest in the property, it is a lease, but if it only permits another to make use of the property of which the legal possession continues with the owner, it is a license. And if under the document a party gets exclusive possession of the property, prima facie he is considered to be a tenant, but circumstances will be established which negative the intention of to create a lease. The next para. We further find that the alleged agreement of license of the year dated 2003, exclusive possession has been given in favor of the plaintiff. The plaintiff was even permitted to install a new electric meter, as in the present case, and in its name, and also permitted to make an arrangement for the security of the office of the plaintiff. The defendant number one retained no control over the property in dispute. Over and above, after the expiry of the period mentioned therein, that said license was again renewed on the same terms. It is needless to mention that the alleged license was not recoverable earlier, even for non-payment of the occupation charges, and was binding upon the heirs, executor, or even the assignees of the owner. The general rule relating to the license is that a license comes to an end on the death of the licensor or transfer of the property by the licensor, and such license is not binding upon either his heirs or assigns. The fact that by this agreement the defendant number one wanted to bind his heirs and assign itself indicates that the intention of the parties was to create an interest in the property involved. The moment such fact is established, the inevitable conclusion that emerges out is that the agreement was real and agreement for tenancy. Well, these are my submissions.
Thank you. Yes.
Next matter, Lord.
Yes. Yes.
Next matter, the paper book.
Is there any material difference in the facts?
Yes. One. I am just showing one point. Page number 61 and 62. The signatory of Otis Bose, Assistant Manager Legal. Kindly see, it is visible that there are signatures not by the same person. Kindly see, page number 61 and 62. Signature is not the same. That means there is some manipulation. Some other person is putting the signature. It is apparent. It's not the same person. When the landlord refused to accept the rent, we made an application before the rent controller. Rent controller accepted the rent, and since 2008 we are depositing rent. What happened in 2008? They refused to renew the agreement. Whatever may be the reason, I am not on that. The point is this: March 2009, the fire occurred in the premises. They disconnected electricity and destroyed our office premises.
These are not on record, Mr. Dutt.
No, that is on record. I'm showing that before showing this, I just giving the brief facts. And when you approach before the rent controller considering the previous order 2008, the rent control challan and all agreement accepted, you are a prima facie prove your tenancy and allowed us to restoration of electricity application, that they have appeared and opposed that you are not the tenant, you are a trespasser, you have no locus, everything, but that has been overturned and allowed our petition. That was challenged before this court. That they have given liberty to file appeal court is there, tribunal. This because by this time the appeal forum is there, the liberty given, but they didn't challenge the order. That order has reaches its finality. Section 27, restoration of electricity.
Then next application was 36 for repairing application. When they again appeared and they again same objection, the rent controller, considering the previous order, hold no, I have already hold that this is the tenancy, prima facie proved their tenancy and allowed the repairing application. Then they filed an application for review. That review was allowed. My application was dismissed. I prepared application before the tribunal. Tribunal allowed my application and restored the original order. Then challenging this, before this court dismissed the writ petition. That is for dismissed for default. But receipt is finality. Then
regarding the section 27, the registration they filed first, they preferred
before this court, liberty granted, but no appeal was filed.
no appeal.
No appeal was filed. But in respect 36, firstly, our application was allowed.
Important. Last
Review stand, then I prepared appeal. That appeal was allowed. The challenging that before the High Court. High Court has that didn't appear. The dismissed for default. Reaches finality that order. Then they have challenged the appeal of the previous order. Then that against that 2 appeal was filed, and that was allowed. And again come before your lordships. Item number 83 of today's list. The WPLRT. In the meantime, 2017, these are all previous facts. 2017, the company went into liquidation. There are 3 persons. When we entered into the premises 2005, there are only 2 tenants. Today, at about 12 tenants on the same premises. 3 out of 12 moved before the NCLT. NCLT passed on order. That is most important for adjudicating this point, this case. That is I am reading out his application, CAN application 2, page number 83.
That CAN is still pending.
CAN disposed of, but it is a part and parcel of the CAN application. It is required to be adjudicated because
CAN was for what relief?
They filed CAN for addition of the party. For addition of the party.
Addition of whom?
By the new purchaser. Substitution.
But the corporate entity remains the same.
No, corporate entity gone. Corporate entity gone. Thereafter, liquidator came into 2017, and the present applicant
Nico
came into 2019.
Nico Corporation.
Now the Nico Corporation went into liquidation, 2017.
What is the new name of the company?
Now, that is liquidation going on. Winding up. Winding up process is going on. No new company. All assets is going to sell.
No. Mr. Mitra said that
22 Rule 10 transferred to an individual. Or 22 Rule 10 has been allowed, recording devolution of interest from Nico Corporation to.
But the records have not been corrected. What is the new name of?
No, it has been done. I'm told.
Paper book is not reflective of that.
I'm told that your lordship dated only the cause title to be corrected. The cause title in both the appeals.
Yes. Very well. Yes.
Page number 83 of the CAN application. Kindly come.
Yes.
Annex A, page number 83.
Yes.
This is an application order of the National Company Law Tribunal, Calcutta bench. Application under section 60, subsection 5, Nico Corporation Limited, then versus Supreme Legal Services Tax Consultant, Samrat Mukherjee,
But there was no corporate resolution in this.
No, there was no resolution. It was it went into liquidation sale. Many people bought different parts of
this part was brought by this person.
By this person.
Yes.
Vinod Kumar Kothari was appointed as a liquidator. He taken over charge of the premises in 2017, October 10, 2017. Then we raised an objection before the NCLT. The property cannot be sold. Kindly come to page number 85 directly. These 3 applications being numbered such and such, raised common question of law and facts and are thus being disposed of by a common order. This tribunal, while dealing with the MA number such and such, on May 7, 2019, passed the following orders. Miss application number such and such, as well as miss application of such and such, has come to for consideration on this day, which has been filed individually challenging the order of sale of Nico House in liquidation, heard the learned liquidator and the applicants who appeared in person. Upon hearing the argument perusal of the records, prima facie, I am satisfied the applicants have established an arguable case. The liquidator has submitted that the agreement for sale was already executed and conveyance deed is to be executed within 4 months upon fulfillment of terms and conditions in the agreement by the buyer. Accordingly, the liquidator.
One second. এই একটু আস্তে দীপঙ্কর কি হচ্ছে এটা কি এই গল্প করার জায়গা নেই পাশে কি কথা বলে Yes, please continue, sir.
Accordingly, the liquidator is hereby directed not to proceed with the execution of the conveyance deed until the disposal of the application. In the meanwhile, liquidator is directed to file a reply affidavit in miscase number such and such within 7 days of serving copy of the reply affidavit to the respective applicants. Applications are directed to file a rejoinder, if any, within 7 days of the receipt of the reply of affidavit by serving copy of the liquidator. The above said direction is not a bar in collecting the rent for the tenants who has challenged the sale of the building. The liquidator is directed to collect the rent, if any payable, by the applicants in application such as such and kept in the separate account to be maintained by the liquidator. Applicants are directed to remit the rent to the account of to be maintained by the liquidator without any failure on their part. Registry is directed to number any pending application, if any, filed in the CP number and then list it along with the CP number on 18 June 2019. The tribunal, while dealing with the application for such and such on 13th May 2019, passed the following orders. In I number such and such, this is an intervening application filed by Mr. Tapos Dotto, who is also praised this application for hearing in the absence of the liquidator and to pass an ad interim order of restraining the liquidator not to carry on any construction in the building wherein he is tenant under him. Though notice of motion of this application was seen served on the liquidator, no notice of hearing was this application today was served to the liquidator. This application was permitted to move on mentioning by the applicant. It is alleged that the purchaser is undergoing construction in the building without building permit, and since the bidding process initiated by the liquidator is under challenge on order of status quo is to be passed or otherwise the prayer of the application become infructuous. Like application have been considered by this bench on 7th May 2019, and this bench has already directed not to proceed with the execution of conveyance as the agreement for sale has already been
It's the
entered
relevant portion, Mr. Datta, because these applications were dismissed as we find. We find that all these applications were dismissed.
but there is certain observation.
So what's the observations
Yes,
directly?
yes, kind enough.
Only the relevant observation.
Paragraph number 8. Page number 88, paragraph 4. In the
Yes.
running page, that you can. That is, I am reading out this can. In the background of two orders passed by the tribunal, arguments are today on behalf of the applicant, liquidator, and the proposed buyer of this application are being dealt with disposed of common order. The applicant such and such submit that this is one of the partners such and such. The specific applicant in this is the manner portion of the second floor negotiates another co-tenant and advocate without any public notice. The specific objection of the applicant in this application is the manner in which a portion of the second floor of the Nico house has been sold to another co-tenant and advocate without any public notice or prior information or without giving any similar offer to the applicant or other tenant on the same floor. Paragraph 6. It is further submitted by the applicant that it is not clarified as to how Messrs. Narolia Financial Advisors Limited had earlier taken part in the auction sale of the property and was the highest bidder of the offer price of rupees 37.50 CR along with another PP surplus agencies limited having its office in the same building, and that the respondent has made private agreement by executing the agreement for sale of for a lesser price at rupees 28.25 CR. It is stated by that Mrs. Narolia Financial Advisors Limited is a trading in real estate.
That is the relevant portion, Mr. Datta. Still, you don't find any relevant portion. You did not read the entire application, the order.
Kindly come to paragraph 13.
Please don't fish out for relevance. Just
so
show us
show
us the relevant portion.
I am showing. Look,
what is relevant in this suit?
Paragraph 31 is relevant. Paragraph 31. You can please play paragraph 31.
Kindly come to paragraph 23, page number 94. It is submitted. Submitted means the liquidator it is submitted that the sale of Nico House has not in any manner interfered with the right of the occupation of the applicant. The sale has been made as in where is basis, and there is no variation in the right of the applicant. Then there is a right of the applicant. The respondent has further submitted. I am skipping it out. Kindly come to next page number 99, paragraph 29. It would also be seen that there were two bidders in the auction of a lot A, for which the reserve price was of rupees 27.45 crores and the highest bid was 28.45. The highest bidder deposited the full purchase consideration, and possession was also handed over to the consortium of purchase, pursuant to which the agreement for sale was executed between the liquidator and a representative of consortium. And in confirmation thereof, each of the purchasers signed the confirmation and statement which form the part of the affidavit. The sale of the property in no way affect the rights of the three applicants who are stated to be tenant and occupants of their respective portion in the said plot A. That was the submission of the liquidator before the NCLT. When the applicant purchased the property, she was fully aware that that admission has been made by the liquidator in the NCLT as a tenant.
What is a tenant?
As a tenant, the admission was there before the NCLT as a tenant. Dispute before the Nico Corporation.
Tenant and or occupant.
And or occupant, not trespassers or unauthorized occupant.
Occupant is also.
All right. I have not. But whatever may be, whatever the point was, the liquidator, Nico Corporation stand was that they are the trespassers. The leave and license is expired. You are nowhere over here. That was the stand of the Nico Corporation.
The licensee can come within and or occupants.
Yes, obviously. Even a trespassers is usually occupant. Until unless by due process of law
is not an admission by the and admission of liquidator cannot bind them. One. Secondly, this is not an admission that you are a tenant.
Obviously, because they have stated.
Obviously, you say obviously it is not.
No, when the liquidator submitted before the NCLT, we are not disturbing their position.
Tenants and or occupants.
Then
and whatever are your rights, those are protected. By the sale, by virtue of the sale, per se, your rights won't go. Obviously, how can your rights go?
The liquidator actually recovered position from the two tenants.
Subject to your rights of possession.
Only two, Nico Engineering Services and Nico Corporation Limited.
That does not debar the purchaser from execution against you, eviction against you.
But in due process of the law.
Definitely.
In due process of the law.
Absolutely. This is due process of law. They filed the suit. Has been decreed.
No, the suit was actually the wrong jurisdiction. That will come.
That's a different point.
I will come.
So why are you placing these orders? I mean, these do not.
No, my point is
conclusively say anything.
When a tribunal, two tribunal, and three tribunals already held, considering the.
Do any of the tribunals, Mr. Datta, you know better than us, have jurisdiction to
decide the status of a person? That's true.
You make the question and you give the answer also.
That's true. But when it is decided,
yes.
I cite the judgment when prima facie prove a status of a person. In the very latest judgment of the Supreme Court and the interpretation of Section 6 of the Premises Tenancy Act, contrary to any contract means what does it mean? I will just come. And this paragraph I will just place. Paragraph 32. The next question raised by the applicant is to the effect. There is no sanctioned building plan of the building under the sale, and the whole building should be demolished as it cannot be stalled as per the law is again untenable. The judgment relied upon by the applicants are not applicable to the facts of the case. The present building is stated to have been constructed in the year 1890 and must have been constructed with some approval of the sanction from the nominated or competent authority. That is not correct. I will show. The already 4th floor to 8th floor is demolition order is passed.
Yes.
And I show that judgment.
How are these relevant, Mr. Datta? We won't go, don't take us to these unnecessary. These are not relevant for the present adjudication at all.
The applicant have no right to raise.
The applications were dismissed and the sale was affirmed. Their sale was confirmed. So they have a right. So let us not waste time on these. Whatever the NCLT found. That was for the purpose of that liquidation process.
Kindly come to my
we note your argument that there it was recorded that tenant or occupant and your rights are protected. These two things are germane in this order.
From this order.
Very well. What else?
Now kindly come to APDPT in opposition. of this can.
This application has been decided, Mr. Dotto. Why should we go into all this?
5 minutes, kindly allow 5 minutes.
No, not a question of time. You'll get your time, whatever you need. But what is the necessity of going into that affidavit in opposition? What are you trying to show us? Tell me that.
Ultimately, I think ultimately I will be able to convince you.
No, what are you trying to convince us on? That is what we are asking. We'll be convinced or not, we'll decide. But what is the point?
They have the applicant purchased the property through e-auction as per the sale confirmation of the
Yes.
NCLT. That order I have challenged before the NCLT.
Yes. But your
that was due to time bar, that was rejected, and I have filed SLP that is pending before the Supreme Court.
then
That is
that order remains.
that means if the ultimately the sale e-auction process is set aside.
As of today, it has not been.
No, that's true. That's
So
true.
it stands.
At the same time, I have filed a suit for declaration and kindly come to page number 12 of my opposition. What is the issue framed by the civil court? By the same court, city civil court.
We cannot go into that. Sorry. In a different suit. That's in a different suit.
Different suit, and the question of that e-auction process.
Suit between?
Suit between the petitioner and hearing the respondent against the corporation as well as the Nico Corporation Limited.
For what?
For cancellation of e-auction process, declaration of the building plan is.
Unless that is decreed, we cannot look into that, and that has not been brought on record. We cannot.
No, I have brought on record whatever decision your lordship, that your lordships.
That is not under order for 2027. So that we cannot look into those.
All right. Now.
And even if a suit is pending, that does not make any material difference.
All right.
When this decree was passed, Mr. Dotto,
kindly come to your lordship's order. When I have specifically raised objection, the application on 2 grounds is not maintainable. Your lordship allowed it.
Which application?
That can 2. That application. Can 2 substitution. Your lordship allowed that application. It does not debar me to point out certain mistake.
In our order?
Yes.
It debars you because it's binding on us also.
No.
Unless challenged.
No. That is a review
not
provision.
Because it's our
that
order.
Is a review provision.
Any order.
That is a review provision is there. I can file SLP also. But I will indicate.
We cannot revisit any order of this court passed by us, passed by you, passed by Mr. Banerjee, passed by XYZ. If it's an order of this court, it's binding on us. This is not a review application which you are hearing, so we cannot reopen any order.
I'll now I will.
No, Mr. Just because we had passed that order, we don't have any ownership of that order. If it has been passed, not challenged, no review pending today, then we cannot look into that order. Reopen that order.
Then I am leaving.
They've been added, Mr.
All right. I am leaving your lordships. All right.
What are the main points? Any other point? You are going to cite some judgment. Latest judgment of the Supreme Court, you said 12. কিন্তু শোনার পরে কথাটা
that application was barred by limitation 137. That was my point. That point your lordship has not been adjudicated.
What is this? Brief notes. We did not direct you to file any notes. This is notes in
judgment I have referred in the judgment. I have kindly come to directly the second.
But then don't file the written notes. You have not asked for it. Give us the judgment only. We won't keep on record anything which you did not direct.
Then allow me. Otherwise, I have to cut out and I have to play separately.
No, you don't have a right to file a written notes of arguments. You have a right to cite a judgment. Written notes only if the judge wants, you have to file. We are hearing you on your verbal arguments, and that is sufficient for us. You please cite your judgment. No written notes without our permission.
Then
written notes is not a pleading.
Then I will remove it, and I'll
remove it right now and hand over the judgment.
I'm handing over the judgment.
কাঁচিটা দিন নাকি আমার তো কেটে দিলেন এখন তো বুঝে দিয়ে রিডিং নোটসে বলেন কোনো ডাইরেক্ট কোনো কিছু সম্পূর্ণ নতুন কথা বলবেন এটা মুখে আর বুঝে তো শুনছো
বিষয় যেগুলো কাটো
এইগুলো খুব শর্ট প্র্যাকটিস শুদ্ধ জাজমেন্ট
yes I am just giving handing over the judgment. এটাকে একটু সেলাই করতে হবে। ওকে সেলাই করে নিতে হবে।
এটা কি খোলার?
কিভাবে
এই জামা কাপড় খুলে লোককে পাঠিয়ে দেওয়ার মতো। Please ask your clerk to It's not the way. You don't have a clerk even, Mr. Datta.
Yes, yes.
Ask him to stitch this.
Then matter.
Do it right now. We'll look into the judgment. Definitely you have a right to cite a judgment. And you will definitely cite it. Call your clerk and ask him to stitch it.
সেলাই করে তো বিষয়। Not one day without going through the
Cite a
brief
no,
notes, without going to the brief
Please
notes, only
cite a judgment.
judgment be taken into account.
Judgment we definitely will.
I-
We have to. You have a right to cite a judgment.
But without considering the brief notes, you just kindly see the
We
judgment.
will do that. Let it be handed over to us. We don't want to keep on record anything which will act as a time bomb, which you did not ask for. Our records are sacrosanct, Mr. Datta. Nothing can be introduced there without our permission. Just introducing a brief written notes of arguments which are not argued.
I am citing 3 judgments on the point.
Cite any judgment, number of judgments you like, but don't introduce any piece of paper captioned as brief notes of arguments on which you have not argued. The first point you saw, Article 137 of the Limitation Act. You have never argued that. Why are you introducing that paper?
137 already in supplementary APTP, your lordship didn't consider it when I have argued in
Then why are you introducing that as brief written notes of arguments? You are not arguing that before us, and you are introducing that in the records.
I have
But
very
you have
much,
a brief written notes of arguments.
I have very much argued in the
You are senior enough to know that this is not done. Thank God that we looked into it.
137 point limitation I have very much mentioned in the supplementary affidavit. Your
What
lord,
supplemented affidavit?
in the can I have
Have you till now argued before us 137? And is 137 applicable to a suit?
Yes.
In this suit?
Yes.
How? You have not yet argued that. Why are you putting it in a brief?
I have argued, your lordship didn't take in consideration.
Today you have never argued 137.
No, I have not argued.
You have not argued 137. Sorry.
One by one. I am just one by one.
137 applies to which sort of suit, Mr. Datta?
137 basically
is it applicable to a suit?
Yes, yes.
It is applicable to a suit. Limitation একটা দাও তো। Shortcut is used. Yes, Mr. Datta, read out 137 for us. Then read out how is it applicable to a suit.
They file an application.
Read out 137, please.
They file an application.
Please read out 137. Applicable to a suit.
Any application. Any other.
So how is an application a suit? How is 137 even applicable to a suit?
Any other application or for which no period of limitation is provided elsewhere in this division, the period is 3
Therefore, it's applicable to an application, not a suit.
I am talking about.
You are not talking about application. We asked you thrice. Is 137 applicable to a suit?
No,
you said
no,
yes,
sorry,
it is
sorry,
applicable.
sorry.
Yes, it is applicable.
No.
And thrice, yes, it is applicable.
sorry.
It is not.
Can two.
Mr. Datta, don't argue. Don't put in a written notes of arguments something which you have not argued. This is sharp practice. I'm very sorry to say. You're senior enough. I thought I would not comment on this. But since you insisted thrice that 137 applies to a suit, and you have argued that before us, which you have not throughout the proceeding today, you are introducing that in your brief written notes of arguments. You should have taken the guidance of your learned senior there before doing it.
They have filed.
This would never have happened. Now, one limitation একটা নিয়ে নাও 137 suit apply করে.
The application they have filed, that is order 22 rule 10. That is applicable.
That is no longer res integra.
But that has not been taken into
No.
consideration. Kindly.
You cannot reopen an order which has been passed by the court. That's an order of the court that has attained finality. No review, no challenge. You're repeatedly arguing on that. Ms. Mito, you are not involved at all. Please take your seat. We are not addressing you at all. But a sharp practice is a sharp practice, will be a sharp practice. And you are going to introduce that in your written notes of arguments. And you expect us to pass an order in your favor on the basis of that written note. Mr. Datta, we know this very well. You said you will cite a judgment. In that judgment, there were annexed certain documents. Those documents are captioned as brief written notes of arguments. Where you put in an argument on 137, you have not argued 137 throughout this day. And when you challenge our order before a superior court, if it goes against you, the first thing you will take the ground is that written notes of arguments have not been considered. We don't know these practices, Mr. Dotto. We are naive children, suckling babies. We have also been here for some time. We have been that side, this side. We know very well what is going on in your mind. And much better than you understand. Don't put in things without our permission in the name of citing a judgment. You are going to introduce certain arguments, brief notes of arguments, which you have not argued before us. And which you have specifically precluded from arguing. Because that's an order of the court passed by us, X, Y, Z. We repeat this. That's an order of the court that's binding on us, even if it's our own judgment. So what? You cannot reopen that chapter in an appeal against the decree of the trial court. That's a settled proposition of law. Why are you repeatedly trying to introduce that in your judgment? Cite a judgment. If you want to cite a judgment, please cite a judgment. Don't introduce any single paper beyond that.
I will cite this. The only
What is the citation you are going to rely on? What is the reference?
2021 8 SCC 812, 2021 17 SCC 284, and 2018 1 SCC 271. This is on the point of 137. The application under any provision of the CPC will attract 137 when there is no specific time limit is provided. The application can.
All these judgments are on that.
One judgment is parent judgment and subsequent.
Parent and children, all these judgments are on the same point.
On the same point.
How is it relevant in this appeal?
The CAN 2 is not maintainable.
CAN 2 has been allowed, Mr. Dotto.
If your lordship allows.
We have allowed CAN 2. That order has not been challenged before a superior forum. No review is pending against that. We cannot reopen that issue.
All right. I have on that point. I only just cite 2001 SCC 666.
On what point?
That point. The court can rectify its own mistake because High Court is a court of record under Article 2000.
That you can cite. What is the citation?
2001 SCC 666. That is M.M. Thomas versus State of Kerala, where it is stated the High Court is a court of record under Article 215. The court can correct its own mistake.
Please read that paragraph, relevant paragraph. Under what circumstances?
The judgment.
Cite that only.
Yes, yes.
And read out this paragraph which narrates the circumstances when that can be done.
I am just reading out. Paragraph 40.
Don't have copies.
ওগুলো হলো রেডি হয়েছে
only this judgment.
I am reading out, but
cite only this judgment. Hand over only.
No, because I have brief notes of I have taken away. Only the judgment I have.
Only 2001-6. The others on 137 we cannot entertain.
All right.
ওটা ফেরত দিয়ে দিন পুরোটা.
The High Court as a court of record.
2021.
Yes.
Cite the copies of the judgments.
From this, your lordship can take into otherwise.
Not sort out judgments. You cite only that judgment. Which copies? You have clubbed all.
No, kindly see into.
Mark করবেন না দেখে ফেরত দিয়ে দেন. Yes. Paragraph
14. High Court as a court of record.
আপনি mark করুন.
Lordship got it.
Wait.
এটা 102.
সব পরে. Yes. Para 14.
14. High Court as a court of record, as envisaged in Article 215 of the Constitution, must have inherent power to correct the records. A court of record envelops all such powers whose acts and proceedings are to be enrolled in perpetual, memorial, and testimony. A court of record is undoubtedly a superior court which is itself competent to determine the scope of its jurisdiction. The High Court as a court of record has a duty to itself to keep all the records correctly and to in accordance with the law. Hence, if any apparent error is noticed by the High Court in respect of any order passed by it, the High Court has not only power but a duty to correct it. The High Court's power in that regards in its plenary in Naresh Sridhar versus State of Maharashtra, a 9-judge bench of this court has recognized the aforesaid superior status of the High Court as a court of plenary jurisdiction, being a court of record. My duty only to brought your lordship's notice. Your lordship.
You've done your duty, take this.
Yes,
back.
yes, yes.
Sorry.
I wanted to cite some other judgment.
Cite.
That the applicant did not acquire any title. That was the point. And on that point, I want to cite two judgments, 2016, 12 SCC 534.
Copies.
Yes, and 2019, 20 SCC.
Copies, Mr. Datto.
Yes, yes.
This is also on the same point.
No, this is different. This is different.
Title, how is that question of title relevant here?
That is the derivative title. He is not the original owner. Tenant cannot raise the title of the owner. It is the
Did you
settlement.
raise any objection as to a title at any point of? Didn't even find your written statement. But it's a question of you raising objection to a title. You never raised any objection to a title. Why are you citing this judgment unnecessarily?
Applicant has been implemented over here as a.
In a first appeal, for the first time, you did not file a defense. The suit was decreed ex parte.
Yes.
You never took out any ordinary rule 13 or because it was, you did not appear. You did not take out any ordinary rule 13 also. And how can you take that objection for the first time in the first appeal?
That point has to be taken into because it directly came before the appeal.
You never took that point. The appellate court cannot look into that for the first time. The tenant challenging the derivative title of the landlord.
It directly came because
It's not in your pleadings, Mr. Datto. You have no pleadings in the trial court. How can you look beyond the pleadings, which is not there? New arguments on facts are being made by you. This is not a pure question of law. Whether the present person has got derivative title or not. You have never raised that objection in the trial court. How can we look into that which is not in the pleadings?
All right. All right. All right.
Derivative title you are challenging, that will note and will turn it down on the ground which you just now said.
And regarding the jurisdiction is concerned, a small cause court.
Yes.
I want to cite one judgment, 1995,
Right.
2 SCC.
2 SCC?
2 SCC, 1995, 2 SCC.
Yes.
665.
Please give a copy.
Current running page number 62.
Any particular paragraph?
No, my lord, that entire judgment on that issue.
Achha. What is the issue?
Issue was that the small cause court has the exclusive jurisdiction in case of leave and license. If the eviction suit has to file, only the small cause court. Because there are three that arose in the Bombay. The Bombay was original site jurisdiction, Calcutta High Court, similar provision.
Yes.
So on that point, when I raised the order 7 rule 11 before the court, this court has no jurisdiction. That application was rejected. Challenging that, I moved before the revision before this court, and considering these judgments, permanent stay was granted. But
what was the logic of the trial court which rejected your application under order 7 rule 11?
There is no specific reason. I have the jurisdiction. I have the jurisdiction.
Where is that order? Is that a part of the paper?
No, part of the. But that is I have mentioned the matter that restoration application will come along with the CO. But that has to be also decided.
I have a copy of that, if your lordship permits it.
It's part of the LC.
Must be a part of the LCR
Yes,
because
it is. my lord.
we'll get it in the records, but
Yes, my lord, but
to
just
cut
for
short
the
the
sake
matter,
of, yes, my lord, for the convenience of it.
Mr. Dattu, you have a copy of this order?
No, my lord.
Give him a copy.
I have.
This judgment about
This judgment ठीक section 19 थोड़े थोड़े पूरे exclusion देखिए.
But the learned trial judge rightly said, Mr. Dattu, that section 19 of the Presidency Small Causes Code to Act is there. 19D debars a suit for recovery of immovable property. 19D says that you cannot file a suit for recovery of immovable property before a small causes court.
Section 41. 41
41
is the exclusive jurisdiction.
Have you got a copy of the Presidency Small
Yes,
Causes?
yes.
Just hand it over,
Yes.
please. Yes. আমাদের আছে প্রেসিডেন্সি স্মল কজ কোড আনি নি
না এটার মধ্যে নেই
কাউকে
আরেকটা আছে কোথায় দেখো
যে গল্প করছিল তোমার সাথে তাকে দিয়ে আনি না
I have, my lord. দিয়ে দিয়েছি আপনি.
ওর মধ্যে আছে ইয়েস
Small Causes Code Act. What do you handle?
President small cause code.
It has been handed. One copy has been handed.
Small cause code, sir.
Has been handed over.
Oh.
Come to 41, Mr. Dattu.
Yes.
Yes.
Summons against persons occupying property without leave, and in case of leave and license. When any person has at possession of any immovable property situated within the local limits of the small cause court jurisdiction and of which the annual value of rent does not exceed 10,000 rupees as the tenant or by permission or another person or some persons through whom such other person claims and such tenancy or permission has determined or been withdrawn and such tenant or occupier or any person holding under or by assignment from him hereinafter called the occupant refuses to deliver up such property in compliance with a request made to him in this behalf by such other person hereinafter called the applicant may apply to small cause court for a summon against the occupant calling upon him to show cause on the day therein appointed why he should not be compelled to deliver up that property.
That is a summons. Come to 44, that 43. That would be your.
If the occupant does not appear at the time of appointed and show cause to the contrary, the applicant shall, if the small cause court is satisfied that he is entitled to apply under section 41, be entitled to an order addressed to the bailiff to the court directing him to give possession of the property to the applicant on such day as the court thinks fit to name in the such order. Considering this judgment,
this is a special provision, a special ecosystem provided for a summary procedure sort of,
yes,
that where there will be a summons and if the summons are not answered or the occupant does not appear at the time appointed and show cause, applicant shall be entitled to an order addressed to a bailiff directing him to give possession. Here, a regular suit has not been barred here, whereas a regular suit has been barred in
the judgment of the Supreme Court. The regular.
Actually, let us see that judgment.
That is the judgment. Even in subsequently, there are 2-3 judgments of our court.
Mr. Dattu, let us come to that judgment.
Yes. paragraph 1 to 11 to 13 of this judgment. The suit was filed before the civil court.
But the question posed is different, Mr. Datta. Para 1. Please come to para 1 and read the question which fell for consideration. A short question arises for consideration. Please read that paragraph for us.
Whether the suit filed by the plaintiff claiming the right to possess the suit premises as a licensee against defendant alleged licensor who is said to be threatening to disturb the possession of the plaintiff licensee without following due process of law is cognizable by the Court of Small Cause Bombay as per the section 41 of the specific Small Cause Code.
Therefore, it's an injunction application by the licensee.
Licensee.
But the licensee is a plaintiff, files
the
a suit
landlord
for
was a defendant.
injunction restraining the landlord.
Yes.
It's the other way around. His is an eviction suit by the licensor against the licensee, which is barred under 19D. So the question which came up before the Supreme Court, whether a licensee can maintain a suit for declaration and, or at least injunction against his licensor, protecting his possession. That definitely can be filed before a small causes court. There is no bar.
Because there is
But 19D bars the other way around. The licensor can find an eviction suit against the licensee in the small causes court. So this is on an entirely different footing.
I am reading out the section 9. Suit in which the court has no jurisdiction. The small cause court shall have no jurisdiction in a suit for recovery of
Section? Which section?
I am reading out section 9D. Small cause court shall have
9 or 19?
19. Sorry, 19. 19D. The small cause court shall have no jurisdiction in a suit for recovery of immovable property. But section
this property is movable. The office space moves.
Section 41 and 19D, that is the there is a confusion between these two provisions. And that is a decision of the coordinate bench.
Right there. Where is the decision of the coordinate bench?
No, that is not ready with me. That is not ready.
If that is not with you, don't cite it then.
All right. Another point, Milord, the
yes,
two judgment. One is AIA 2005, Cal 295. That is already cited. Oyon Chatterjee versus Future.
Ms. Mitra has cited?
Yes, yes,
that definitely. That will take into consideration.
Yes.
That has already been cited.
Now the next point, the WBTT Act, Section 6 will be applicable when a persons for recovery of possession file an application. The provision of the Premises Tenancy Act.
If it is not a license, definitely. If it is not a license, that's why we checked the rent, the license fee.
Kindly.
Yes, we have seen 6,000.
Notwithstanding anything, content,
Sir, Dattu, we agree with you.
quantity.
If it's not a license, if it's a tenancy, it is governed by the premises tenancy. And the trappings of the Act will apply.
Presentation of the suit, 9th June 2009, On the same very day, jurisdiction has been changed up to 60,000 small cause court and above 60,000 city civil court. They have filed the suit before the civil court, assuming that it is continuing. But on the same very day, the jurisdiction has been changed.
Jurisdiction of?
Courts. Pecuniary jurisdiction.
Of which court?
Small cause court. Kindly see. Correct the order with the achar. Small premises tenancy.
দিলেন তো আপনি? Yes. This is the Premises Tenancy Act?
Yes, yes. Kindly come to Schedule 4, page number 73. I do not know which number will be there. Schedule 4, West Bengal Premises Tenancy Act.
Yes.
In case of value of a suit exceeds 10 lakh rupees to the High Court, Calcutta, in case of where the premises are situated on land wholly within the original civil jurisdiction of the High Court at Calcutta, in case the value of the suits exceeds 10 lakh rupees to the High Court at Calcutta, in case the value of the suit does not exceed 10 lakh rupees but exceeds 60,000 rupees, City Civil Court established under Section 3 of the City Civil Courts Act, in any other suit to the Chief Judge of the Court of Small Causes constituted under Presidency Small Cause Courts Act 1882 in the town of Kolkata, who may try suit himself or may transfer the suit for trial to any other judge of the said court who shall try the
That
suit
is for Premises Tenancy Act suits.
Yes, 9/6/2009.
This is an eviction of licensee suit.
Now the question is, if they want to eviction of licensee, he has to go to the premises tenancy, small cause courts. Otherwise, that judgment, the Section 6 will attract in any contract, if there is a contract.
Then where is the question of Schedule 4 being attracted? Even Section 6 notice has not been given by them.
Yes, yes. Without notice.
Then why are you relying on Section? The entire Act applies then.
Yes, yes.
Section 6 tappings applies, everything comes in.
Absolutely correct.
That's why you ask the rental or the license fee.
Yes.
That is below value. So it comes within premises tenancy if it is not a license.
Yes.
You are relying on Schedule 4, the suit is not maintainable without a Section 6 notice.
Yes, absolutely correct. And on that point, I just...
And then they have to file the suit under that Act and on the ground specified in that Act.
Absolutely.
Not just like that. If I give a notice and TP Act won't operate then.
Very recent judgment on that point, 2014.
On what point?
On that point.
On that there are several that's.
If there is an agreement between the two parties, whatever the nature of the agreement, leave and license, tenancy, whatever may be, the landlord wants to recover the possession, they has to apply before the 6. That is the interpretation of the...
You require a judgment for that?
Yes, on judgment.
We don't require a judgment for
that. All right.
If Premises Tenancy Act applies, the suit is not maintainable at all in the present form.
Yes. Then your lordship...
Nothing in the suit applies. But the question is whether it's a license or a lease.
That point is decided by the coordinator Justice Bhaskar Bhattacharjee. That is Owen Chatterjee's case.
Yes.
That the legal errors and everything.
So that is the only judgment which requires to be looked into.
I have lot of...
And that is very relevant also.
Yes. I have disturbed so many things. I do not want
to... You have not at all disturbed us, Mr. Dotto. But the difficulty is you are fully entitled to argue your case, but not do something which is beyond the permissible limit.
I am sorry. I am very much sorry for this.
Two things we did not permit you. One is that we did not permit you to reopen an order, not because it's passed by us. We are not magic persons. But because that order has not been challenged before a superior forum or by UEFA review. And even our own orders, despite our dislike for our own orders, those are binding on us in law. That is the one thing we did not permit you. The second thing, in the name of judgment, you could not insert a written note of argument, which you have not argued. And where you have argued, if it was a good written notes of argument, still we could have considered. But you rely on Article 137 for a suit. And that is not acceptable.
Can 2. I have applied for can 2.
Can 2 you cannot do. Let us pass our judgment. We will keep it reserved. Yes, you want to any reply?
Of course, the interlocutory judgment, Justice, the division bench, Owen Chatterjee, from.
But even then, the principle of law had
But
been
then from
considered.
that, it went to Supreme Court. Supreme Court did not set aside the perjury part, but certain observations have been made, maybe of some relevance, or
Yes.
that this was at the motion stage, the court should not have gone into so much, and this should be uninfluenced. That those observations are there at paragraph 15 onwards, page 7.
Oh, so those are prima facie in nature. You give a copy of this to Mr.
It happened. Oh, I kept it for. So, am a successor, it is subsequently, there's a subsequent clause 14, which later clause specifically says so.
No, that argument is always there. Clause 14 argument.
Clause 14 will answer
Clause 14 of your document.
Yes, that is not, such a clause is not.
But that argument is there, yes. That's your strongest argument in this.
That's strongest. Lordship doesn't want to see your own judgment, I could guess.
Definitely not.
That's why he's saying, show my Lord's judgment. I know.
Should have known better. On what point?
On this successor. On this successor, that will also, that's not an absolute taboo to a license.
So that you could have cited, but not in reply.
After your Lordship notice clause 14, I thought that may not be necessary to cite, because that is. Presidency small causes. Presidency.
But one thing, Mr. Mitro, although in that particular matter, this judgment, these findings might not be conclusive, but as a ratio of law, isn't this a precedent?
Yes, associated is a precedent, of course.
No, Ayan Chatterjee.
Yes, Ayan Chatterjee relies upon associated. That is in para 21.
Associated is a precedent.
Yes,
Otherwise.
so exclusive.
That has been reiterated basically.
Paragraph 22. We further find
yes.
that in the alleged agreement for license of the year 2003, exclusive possession had been given in favor of the plaintiff. No evidence, no pleading.
No, only para 21 is associated, right? Associated is.
The plaintiff was even, see para 22. So factually so different.
22 I've seen.
That permitted to install new electric meter. Here they were having a sub-meter from mine to read their connection. Was given exclusive possession. Permitted to install new electric meter. Permitted to take arrangements for the security of the office. The defendant number 1 retained no control of the property in dispute. So those are the factual part here. Yeah, after all, I have the advantage of no written statement, no evidence from them. So why not take advantage of that? But I am legally entitled to that. And also, Lordship, the Presidency Small Causes Court Act, there is a section which ousts the civil cause jurisdiction. That is section 18, which is only for landlord tenant. The 18th, no? 18 na? This is 18th subsection 2. এটা কি দেখাচ্ছে 18.2 কোথায় পেলাম আমারটা মেইনটা দাও হ্যাঁ
exactly 2 is the answer to Mr. Datta's citation of that.
Yes.
The schedule of the Premises Act. Notwithstanding anything in 19 or 1 of this section, subject to provisions of such and such, small cause shall have jurisdiction to try all suits and proceedings for eviction of a tenant under chapter 3 of the Act as a civil court of ordinary origin.
So, only of a tenant.
Yes.
See, if it was the tenant, then I fall on many accounts. I don't have to on many accounts.
Then a suit goes. If it's a tenancy, if you hold that it's a tenancy, then as Mr. Datta argues, section 6 would be applicable without a notice or without any ground made out under the 97 Act. You won't be entitled to a decree.
Even the last occurrence of the land tribunal,
Yes.
observe the tenancy, our status has to be decided by the civil court. That is item number 83. It would be better to club together, otherwise after tomorrow if it is.
No, but it's better to
otherwise
club that judgment.
Because otherwise contradictory view cannot be, because that WPLT should.
There it has been held that title has to be decided by civil suit.
No, that observation of the tribunal is this, our status has to be decided by the civil court.
Isn't that right? You have challenged that.
Yes, that have
Then your application should be clubbed with a club.
There are other points is there. That one of the point is this.
Title always has to be decided by the civil court, Mr.
That's true.
Ask Ms. Mitro and let her argue this. If she argues, we'll accept.
That's true. That's true.
If she argues, we'll accept that a tribunal can decide the title of the status of parties.
Tribunal cannot decide.
Let her argue, we'll accept. We are telling you. Ms. Mitro has to argue this.
The tribunal is an adjudicatory body. Right. The civil court.
Let her argue that tribunal can decide the title of parties and we'll accept it as sacrosanct. That will be law.
Civil court.
So we are concluding our. We only took one judgment in reply, Ms. Mitro, because this is on that judgment you have cited. So that was challenging the Supreme Court. But here we have a little bit of, doubt, because here Supreme Court held that those findings will not be conclusive at the final hearing of that suit. But as a proposition of law, we accept that your judgment. We will accept that judgment. On facts, Mr. Mitra has distinguished, that we will also take note of. Thank you very much. So, hearing is concluded. The matter is reserved for judgment. The appeals are reserved for judgment. Who the appeals? Reserved for judgment. সব এইভাবেই পাঠিয়ে দেবে, কারণ কেটে যাবে।
হ্যাঁ দিচ্ছি। এই দেখুন বুঝো।
My note, please.
Pardon?
I'm leaving the court.
Yes. Next.
Take you that your lordship has given so patient.
So what are you saying? You command that respect. Yes.
Your Lordship, I'm appearing on behalf of Mr. Chatterjee.
Mr. Chatterjee is the client.
No, Mr. Shantanu Chatterjee, my learned senior. I'm seeking an adjournment. Lordship,
Refuse. Move your matter. What is your brief?
Dear Lordship.
In this court, only if seniors ask for adjournment on the ground of juniors, that is allowed. Juniors are not permitted to seek adjournments on the seniors ground. You have to move the matter. What is the matter about?
Your Lordship, I shall try my level best, Your Lordship.
Absolutely. That is what we want. I can want to শুধু আমাদের কাছে রয়েছে কেন?
It's a tender matter where
Yes, tender
the
matter.
petitioner.
Have you served a notice on the other side?
I have not taken any such instructions, Your Lordship, but as far as my instructions in this regard, the other side, one Miss Manali Ali has not been present for a very long time, and therefore this matter has not been effectively heard till date. The appeal.
You open the appeal. What is the matter about?
Firstly, Your Lordship, the appeal. I would like
the writ petitioner before the trial court, before the writ court.
Pardon, Lordship.
You have challenged an order passed in a writ petition.
Yes, Lordship.
You are the writ petitioner there.
Yes, Lordship. Yes.
What are you handing over?
This is a Lordship certified copy of the impugned judgment.
File it.
Yes, since we filed it within 24 hours.
Leave of court, yes.
Yes.
Copy ওখানে দেওয়া আছে, yes, certificate copy. Yes. Please proceed.
Your Lordship, the petitioner is a government contractor who supplies materials to hospitals, reputed for a very long amount of time. He has been doing this. The dispute starts from the year 2019, where in a tender, the petitioner emerges as the successful bidder.
What is your name?
My name is Srijan Chakravarti.
Srijan Chakraborty. Very well. Yes. Yes. Please continue, Mr. Chakraborty.
Yes. So,
So you are the highest bidder.
yes, yes, Lordship, it was awarded to me. The
Awarded to you.
yes, Lordship. The
Then-
tender was awarded to me, and I did the work, but I was not paid for the same.
Right.
Yes. If your Lordship, I mean, I was awarded that contract. Then there was extension of time, and in due course of time, the work was completed, but I was not paid for the same. Subsequently, Lordship, after that, there has been basically we are challenging in the NIT, which is issued by the respondents. Time and time again, your Lordship, there is a discriminatory clause number 11 in that, which I
Clause 11 in what?
in the NIT, notice inviting.
NIT, you said you were awarded the tender, awarded the contract.
Yes, Lordship.
After that, another fresh tender was issued.
Yes, Lordship. This is actually, Lordship, this is a matter of 4 tenders. 4 tenders where in okay. So, Lordship, in the first tender, we the work was executed, but we were not paid for the same. And subsequently, Lordship, there were other tenders which were issued, but what happened, Lordship, is that they keep on including this clause 11 where they can deny or reject the bid on any ground whatsoever. If your Lordship is having the NIT, then I would like to point out that clause.
Mr. Chatterjee, you can take over. Yes. What about service of notice to the other side?
Also, in all the occasion, my lord, Mrs. Manali Ali used to appear for the state
Yes,
tender.
he said that.
And my lord,
Somebody else also appeared probably.
and within 24,
Amrita Pajamullik. Pajamoulik.
my lord,
Not Manali Ali.
my lord, so desires
Only one order records the name of, yes. Once Mr. Somrat Sen with Ms. Manali Ali, then Amrita Pajamoulik for the state, they have been appearing. Well, so what is this matter? Mr. Chakraborty says that tender was awarded to you.
my lord, initial, my lord, I used to,
Previous tender.
work was done, payment not made. My lord, subsequently, a tender was issued, my lord, but work was not given under the tender, my lord. No work was given to me,
All right.
my lord. After that, my lord, I have been called for a hearing, my lord. They they rejected my candidature. I already replied against the same, my lord. And after that, my lord, I have been called for an hearing, my lord. On the same very date, they are also given me a fresh tender in my favor.
Fresh tender means fresh contract.
Fresh contract, my lord. Against which, my lord, I have not been given any work, my lord. Subsequently, my lord, there are 4 tenders they issued, my lord. And I found, my lord, in all the tender, there is one section, the clause 11, my lord, by virtue of which they can, any time, my lord, they can oust me, my lord, without giving me any reason, my lord.
Here we see from the order of the learned single judge that you had only challenged clause 11 of the tender, which says the undersigned, that means the employer, I mean the tender issuing authority, reserves the right to accept or reject or cancelling or adding or reducing or deferring any tender or a part of the tender without assigning any reason thereof.
Yes, my lord.
So that was upheld by the learned single judge.
Yes, my lord.
It is one of the plausible views, Mr. Chatterjee, because there are, there are certain judgments which say that, a line of judgments, in fact, which says that the employer is the master of the, tender clauses. What the employer wants, he has a play in the joints, sort of thing. So why should he interfere in an
Subject to there's arbitrariness. If my lord do not find this arbitrary, my lord, that's different issue, my lord. My lord, we consider Mahabir Auto versus Indian Oil, 1990.
But this clause is common in all tenders, all government tenders.
So my humble submission.
This will have a wide ramification. Several other tenders will.
Yes, my lord. So
all over the
this will
country, the
continue, my lord.
tenders will be. We also have to think about the consequences.
This will continue, my lord.
Mr. Chatterjee, it is the exercise of the tender clause which is to be tested by a court of law. How it is exercised, but not the clause itself. A tenderer can very well put his own clauses. If you don't agree, then don't participate.
So
but you have a point in saying that
previously I participate, I face the consequences.
Similar tender you have participated previously.
Yes.
How can you reopen now? Challenge, turn back and
No,
challenge.
I was
Similar clause.
Similar clause.
Same different tender, similar clause. You participated there.
Yes.
You got the work.
I got the work.
Then how
Same
can you
day,
again?
and I got the work. So, but
How can you turn back and challenge a similar
when
clause?
I have been out from my when they did not give my payment, and after
Then
that,
you cannot turn back and challenge the tender clause.
look,
After you
I'm
accepted the
subsequent-
tender, you participated.
I'm not
You
challenging.
got the work, did the work. You ask for your money. You make a
I
money
asked for-
claim.
I asked for my money, my lord. But so far as that tender, I did not challenge those tenders. I challenged the subsequent
But a
tenders.
similar clause,
Similar
previous
clause.
tenders containing similar clause, you participated and you had not challenged, and you had taken the benefit of similar those tenders. How can you resile back and challenge a similar clause in the new tender? You have participated in previous tenders and got the work
Got the work.
in tenders having the self-same clause. So you cannot now turn back. You don't have the locus standi to now resile from that position and now challenge the a similar clause in a different tender.
To that extent, my lord, I cannot.
So this is one of the plausible views, Mr. Chatterjee. We won't interfere here. We'll record your submission. The ambit of the present appeal is very short. First up next. Yes, he wants to add something.
My lord, he wants to add, my lord, the RTI reply, my lord, where they have already mentioned, my lord, in terms of such and such section, we are not supposed to give you the reason, my lord, why you are rejecting the.
So then that is an additional reason in favor of this clause. Let us see that. Let us see that. Where is that? Which page?
Ninth October
দুটো তো
2025,
আগে
45.
participant একই কোশ্চেন ছিল, তারপরে পরেরটা নতুন করে চ্যালেঞ্জ করছে সেই একই কোশ্চেন।
My lord, page 45.
Section 188, এটা তো নেই।
There's no such section, my lord. Kindly appreciate 9-10-2020, page 45. Vide your application under RTI Act 2005, bearing number reference.
This is neither here nor there, does not help you.
Yes, my lord. The information sought by you, vide your letter such as serial number 1 to 5 may not be disclosed under section 1, para 8 of RTI Act.
Sorry, Mr. Chatterjee and Mr. Chakraborty. You argued well. Mr. Chakraborty also started very well. The ambit of the present appeal is short. Full stop. Please take your seats, both of you. It's very short. Full stop. The learned single judge, comma, in a learned single judge, comma, by the impugned order dated July 27, 2021, comma, dismissed a writ petition of the present appellant. Full stop. The scope of challenge in the writ petition was that the writ petitioner stroke appellant, comma, being a prospect, you participated in this tender? The one which you challenged? No.
No.
Being a prospective bidder in a tender process floated by the respondent authorities, comma, challenged clause 11 in the tender document, which stipulates that the tender issuing authority reserves the right to accept or reject or cancelling or adding or reducing or deferring DEFERRING any tender or part of the tender without assigning any reason thereof. Full stop. The learned single judge found no arbitrariness in the said clause and accordingly dismissed the writ petition. Full stop. Next parallel, counsel Mr. Chakraborty, comma, led by Mr. Chatterjee, comma, appearing for the appellant, comma, submits before the court that the very language of the said tender clause is couched in arbitrariness, inasmuch as a blanket power has been vested in the tender issuing authority to reject even the highest bidder in a tender process without assigning any reason thereof. It is contended that the same violates basic tenets of natural justice. Next para. Upon hearing learned counsel for the appellant, comma, it transpires that the appellant had participated in previous tenders floated by the self-same authority having a similar clause as the one impugned at present. Next para. Thus, comma, the appellant, thus, comma, it does not now lie in the mouth of the appellant to resile from such position, and having enjoyed the fruits of previous tenders containing a similar clause by getting work orders and participating in the tender processes, cannot now be permitted to challenge the self-same clause in a different tender document. Full stop. Next para. That apart, it is the exercise of the clause that can be examined by a court of law for testing the arbitrariness in such exercise, and not the clause itself, since the contents of a tender document and the terms of a tender come within the exclusive domain of the employer stroke tender issuing authority, which has a play in the joints to determine the criteria and yardsticks for assessing a bidder. Full stop. Next para. There may be several underlying, subtle and implicit reasons why a tender may be rejected despite being financially the highest bid, which it is for the employer stroke tender issuing authority to assess and not for the court to impose upon the employer. Full stop. The learned single judge, the learned single judge observed that the court saw no arbitrariness or illegality in stipulating such power or reserving such right by the state authority, since it is essentially the specialized department of the government that can determine the suitability of a tenderer for the job sought to be performed and as required by the state. Full stop. The learned single judge also observed that the clause is in line with the dicta of the Honorable Supreme Court, that even the highest or most eligible tenderer is not automatically entitled to be awarded the contract in question. Full stop. Next para. As such, we also do not find any inherent flaw or violation of natural justice merely by incorporation of the impugned clause in the tender document in question. Full stop. Accordingly, since the learned single judge accepted one of the plausible views in the facts of the case, we are not inclined to interfere, particularly within the limited constraints of an intra-court appeal. Accordingly, what is this? MAT 717 of 2021 is dismissed without any order as to costs, thereby affirming the impugned order dated July 27, 2021, passed in WPA 11891 of 2021. Full stop. Can 1 of 2021 is accordingly disposed of as well.
In the meantime, the pending payment we released.
No order as to cost. That is beyond the scope of the writ petition, Mr. Chatterjee. If you want to challenge that, you challenge it before an appropriate forum. এইটা ফেরত দিয়ে প্রথম লাইনে একটা অ্যাড করে নিত, the certified copy of the impugned order filed by learned counsel for the appellant today be kept on record. আর স্টেটের জায়গায় রেসপন্ডের জায়গায় নান অ্যাপিয়ার্স নান করে দিও, একটা লিখে দিও নান।
Grateful, my lord.
Thank you.
My lord, in item number 10, my lord, Mohammed Sarojan is appearing on behalf of the appellant, my lord. Lord, he is suffering viral fever. One day accommodation.
I am appearing
The prayer of the appellant, the matter is adjourned for the day. Viral fever. On the prayer of the appellant, the matter is adjourned for the day. We have adjourned it for a day, Ms. Sengupta. Please give your name, not his name.
I am for the respondent in this matter.
11 call course? Yes, 11. You are for the respondent.
For the respondent.
Respondent is consistently appeal. Yes. Oh, you have come. Good. We are going to dismiss your appeal otherwise. On the last occasion, you did not appear. That's why. Yes, what is the matter?
My lord, I'm late by. My lord, land, my lord, of in the Koshba Industrial Estate, my lord, 3 kathas land
Please repeat.
in the
A land.
Koshba Industrial Estate, my lord,
Right.
3 kathas land was leased out to my client for a period of 99 years. Now, let subsequently my lord, on the ground that I have not utilized the land in the manner in which it was, for the purpose in which it was leased out to me, my lord, it was terminated. Now, my lord, challenging that order, my lord, there were several.
Yes.
There were several writ petitions were filed, and finally, my lord, by the impugned order, my lord, you will find that order, my lord, at my lord, page 115. My lord,
We are following the memorandum, so you can refer to the internal pages.
my lord, the memorandum only, my lord, this is the impugned order passed by the single judge of this.
Yes.
My lord, the parent order challenging which the writ petition was filed, my lord, that your lordship will find, because it will indicate, my lord, the entire history of the case, my lord. So if I can place it before your lordship, my lord.
Page
115, my lord.
115
of the injunction applications.
Yes. Respected sir.
281, my lord, Matt, Can 1 of 2022.
281 Can 1.
Yes, my lord. Page
The half this letter. Page 115.
115,
One-
144. But that is
Oh,
144.
my
not
lord, I think
115.
144, my lord.
144.
This was the previous, under 144, my lord.
3 sets of paginations. Yes, 144. Thank you.
My lord, may I just place it, my lord?
Yes.
In pursuance of the order dated 9th December 2021, passed by Honorable High Court, presided over by Honorable Justice Rajashekhar Manta in WPA number such and such in the matter of my lord, my client's name and WBSIDC Limited, the Honorable Court directed the petitioner to approach WBSIDC Limited with a comprehensive representation, and the appropriate authority shall give a personal hearing to the petitioner, consider his representation and dispose of the same in accordance with law. The petitioner submitted her comprehensive representation on 15 December 2021. The matter was fixed for hearing on 14th of January 2022 and 24th January 2022. The petitioner was duly intimated to represent her case. The petitioner was personally present on the dates of hearing and submitted written argument in support of her case. Produce the written argument submitted by the petitioner on 14th January, the writ petition representation, and the documents in the file. No, my lord. It appears from the record that plot number such and such, measuring about 3 kathas, was allotted to MS Compressor Valves and Plate Service by an indenture of lease dated 24th May 1995 for 99 years, from 24th May 1995 to 23rd June 2094. The plan was sanctioned by the executive engineer WPSIDCL on 22nd August 1995. Revised plan was sanctioned on 24th of November 1997. Since the unit was found to be non-functioning in violation of clause 2G of the lease deed dated 24th May 95, the prescribed authority under the West Bengal Government Premises Tenancy Regulation Act 1976, in exercise of powers under Section 3 thereof, terminated the tenancy on 30th March 1999 and called upon her to deliver vacant possession within 1 month from the date of service of the notice.
You have to start something on that, the project on that.
Yes, my lord.
Within 3 years or 2 years?
Within 3 years.
2 or 3?
Within 6 months.
Within 6 months.
6 months.
Yes.
The allottee made a representation with a letter dated 16th April seeking withdrawal of eviction notice. It appears that the notice was not withdrawn. Challenging the said notice, the allottee filed a writ petition being WP such and such. The said writ petition was initially admitted. Now, my lord, I am just skipping these next because there were several indications. Now, my lord, my argument.
There are several repetitions are there.
That's-
Discussion has been given. So many chances have been given that are important.
Yes, my lord. And there were also
Then-
talks
then-
of negotiation. That's why, my lord, I'm not reading the page 2, my lord. Page 2, last paragraph. What was my contention all along?
So you had preferred 2 or 3 writ petitions.
My lord,
Several
writ
letters have been
petition.
passed. The director
was-
has been given to consider. We have considered, given opportunity, proposal has been given. Yes.
Why several opportunities given? Once
No, my lord, for
admitted.
amicable settlement. For amicable settlement also, my lord.
Passed an order, times to give an amicable settlement. Also, in the court has asked us to give a proposal so that he can survive.
But did not
Then
fructify.
he didn't,
My lord,
After
the-
that, yes, the petitioner in a
the
written order.
petitioner in her written argument challenged the resumption notice and contended that when the eviction proceeding was initiated, the land in question did not contain any structure and it was a bare land on the date of eviction proceeding. The incidence of such tenancy cannot be governed by the provisions of West Bengal Government Premises Tenancy Regulation Act 1976. And such tenancy will be guided by West Bengal Public Land Eviction of Unauthorized Occupants Act 1962. In these connections, she relied upon a decision reported in 2020 SCC Online, West Bengal Small Industries Development Corporation Limited versus MS Soma Promoters Private Limited and others, and the decision of the division bench reported in 2015 1 CHN, against which the matter travelled to the Honorable Supreme Court. It appears from the judgment delivered by the Honorable Supreme Court that it did not approve the judgment and order of the division bench of the Honorable High Court. The Honorable Court in no uncertain held in para 23 thereof that the West Bengal Small Industries Development Corporation Limited is a government undertaking and comes within section 2B of the West Bengal Government Premises Tenancy Regulation Act 1976. As regards applicability of the Act, the Honorable Supreme Court held in the said judgment that if the bare land is let out by the government undertaking and it continues to be bare land as on the date of initiation of eviction proceedings, the incidence of such tenancy cannot be governed by the provisions of the Act, and such a tenant cannot be evicted by taking aid of the provisions of the Act. The Honorable Supreme Court further held that the material date is the date of initiation of the eviction proceedings. The Honorable Supreme Court further in para 30 of the said judgment held that had the respondent in the said appeal put up the construction on the plots of land leased to it, and if the eviction is sought under section 3 of the Act for violations of some other clauses of the lease deed, or upon satisfaction of the conditions mentioned in subsection 1 and 2 of section 3, the proceedings would have been maintainable. The question, therefore, is whether the land was a bare land or the land contained a structure as on the date of initiation of the eviction proceeding, that is 30th March 1999. From the document on record, it is clear that the structure existed on the leasehold property as on the date of initiation of the eviction proceedings. This fact is corroborated by the letter of the petitioner dated 1st July 1997 and 16th April 1999. Well, the order of termination was passed on 30th of March 1999. So, well, the second letter that they are referring to, 16th April 1999, is if there is any letter, that is after the order that has been passed. What they are trying to establish that the construction, from these letters, it suggests that the construction was started prior to that. I am therefore inclined to hold.
Proceeding here was initiated under the PP Act, the Public Premises Eviction of Unauthorized 71 Act.
No, West Bengal Government Premises Tenancy Regulation Act. 76 Act.
But this authority holds that initiation of eviction proceeding under 76 is made.
Interpreting ballot, the Honorable Supreme Court's judgment ballot, I am handing over the judgment ballot.
No, Supreme Court judgment says that if there is a bare land, then 76 Act applies.
So I say that, well,
if there is a bare land, then that act doesn't apply. If there is a construction at the initiation of the proceedings, then 76 Act apply, and the provisions of the Act about the eviction will apply.
All right.
There is also a rider to that, on which date the proceeding was initiated and on which date the construction.
Yes. You say that they rely on a subsequent token, but letter of 1st July 97 is also considered.
1st July document, I do not have that document
was
with me, but
in the hearing.
1st July document.
It's your challenge. You have to show us.
I say that I have not annexed that. I could not annex, but I have in my possession. I have not.
Therefore, I don't have any chance to refer this document.
No, but
and in the trial court also, there is no affidavits. There was no direction of any affidavit. Only says that since there were, the negotiation didn't fail. It is a speculative litigations, and accordingly, my petition was dismissed.
Your ground was primarily you never said that you had started this your project within 6 months. That was never.
But now it has started. It is running.
Now is that not a consideration? But if you did not start, it's only the act under which the proceeding.
I say, that the act under which, the termination notice was issued, that was not in accordance with law. It should have
challenged the notice before the writ court.
The notice. From the very first instance.
They have not yet started proceeding in pursuance of that.
Proceeding started.
Subsequently started.
Petition filed, chance given, and thereafter, they have a court.
Now, what is the situation? What is the?
You have taken possession of the premises.
Final order was passed in the proceeding.
Eviction proceedings have been processed and taken possession by police help.
So these have been rendered infructuous.
We
now, if you prefer a challenge against that order, final order, you take this ground also, will give you liberty.
No, I have not. My client has not been served with any such notice that.
I have
got a copy final order.
But I don't have any copy of the final order, but I have taken instructions. But it has been position has been taken.
Bring a copy of the final order.
Well, I'm just taking.
Yes.
টেন্ডারও ফ্লোট করে দিয়েছেন?
Yes, my lord, this is the order. You will also call it taking the position. Let's a copy picture. You will kindly see this.
8th August 2025. But it's a very recent.
Yes, it has been stated here also in this order.
My lord, last page is the, my lord,
Yes, yes, page, kindly come to page one. What the pagination is?
No, it's actually, well,
147. The last paragraph, since the eviction proceedings have attained finality.
there was no, my lord, this was, my lord, in an interim period when, my lord, we have filed a writ petition. This honorable court directed not to take any further steps, provided, my lord, the negotiation settles. Now, my lord, this negotiation, now what they are my lord, supplying me today, my lord, that they have taken possession.
No, this is the final order.
not,
But this is the final.
That challenge this or the notice.
No, my lord, this order, my lord, this order
Order
of
was challenged.
this order of 22nd of February 2023.
Have attained finality. There is no intervening facts even subsequent.
My lord,
So this is
just,
passed under the 1976 Act.
this is passed under the 76 Act.
Anyway, even if person is taken, you are intended to argue that this order is bad. If this order goes, then the person will also be reverted back to you, following the principle of 144 CPC.
So, my lord, that was now, my lord, this was my grievance in the writ petition also, that this act will not apply following the Honorable Supreme Court's judgment.
Finding of the authority is that there was a structure there.
My lord, I admit that there is a structure. So, my lord,
Supreme Court judgment applies.
no, my lord, if you,
paragraph 29 and 30, you will also kindly see the Supreme Court judges for promoter.
Where is the
That
judge?
clears everything. But my learned
Well, I'm just
today I don't have any copy. Paragraph 29 and 30 of the judgment.
my lord,
Don't show here, show there. They have not handed over.
সুপ্রিম কোর্টের জাজমেন্টটা না, এটা তো এখানকার সুপ্রিম কোর্টে গেছিল, সুপ্রিম কোর্টের জাজমেন্ট দেখো। I have, মানে today I don't have, I have my copy.
No, this 2020 online.
Yes, it's Supreme Court judgment. My lord, I'm
29 and 30 লসি
my lord, prior, দেখছেন না, আমার কাছে আরেকটা আমি দিয়ে দিচ্ছি। My lord, kindly see from paragraph 15, 16, 17.
These are the arguments.
Then, my 22, my lord. In the present case, the premises in question are not owned by the government. It is owned by the appellant corporation, which is a government company incorporated. Therefore, the first question for consideration. And finally, my lord, paragraph 27.
Building or a part of it has to be there.
The point for paragraph 27, your
Yes,
lordship,
yes.
the point for consideration before us is when neither a building nor a part of the building nor a heart nor a part of the heart nor a seat in a room is let out to a tenant, but only bare land is let out to a tenant, well, as in my case, can such tenancy be regarded as relating to government premises to attract the provisions of the Act? The expression includes is used in two places of the definition of premises in section 2C, and the expression includes, which was used for the second time in the said definition without any doubt.
If it's bare land, then this act does not apply.
Well,
If it's bare land, then
yes, my lord,
76 Act does not
my
apply.
submission before lordship is that the leased out property is a bare land. My lord, now after that, my lord, I have constructed it. Now they are saying that since the construction is within the time frame as has been indicated in the judgment, they also admit that leasing out a bare land, this act.
So they say when the eviction proceeding was initiated, there was already a
Construction is there.
construction was there.
Well, then also, my lord, subject to correction, my lord, this paragraph 27 supports me.
No. Let's because when will the act be applicable, Mr. Shur? The act is the act comes under the scanner whenever a proceeding is initiated. When a proceeding is initiated, only then the question arises: the proceeding will be under which act? Before that, there is no applicability of any act. Applicability of the act is in respect of a proceeding only, of an eviction proceeding only. If an eviction proceeding is filed, then on that date, whichever act is prevalent, that will be taken into consideration. Now, it is construed that this eviction proceeding was initiated on 30th March 1999, although that was even prior to the eviction proceeding initiation, because that was the first notice, but let us construe that to be there.
That is not the actual section 3.1 notice, that is the final.
So 3.1 notice. If that was a 3.1 notice under this act, that is the initiation of the proceeding. If that be so, then the specific finding is that there was a structure on that date. And two letters are relied on. Have you got the copy of the 1st July letter?
Today I don't have, my lord.
Tomorrow you will have.
Well, I shall try. My lord, the old Mamla, I shall try to give me 7 days time. I shall produce all these.
After so much hearing, we
No, no,
went about. Well, how did the learned single judge deal with this? Let us
My
see.
lord, that your lordship will find in the memo of appeal.
My lord, before that, my lord, I want to cite my 2-3 judge pay.
Yes, we'll come to you.
Reference,
First, let him complete.
No. Will be.
My lord, 28th August 2020.
20th August or February?
20th February, my lord. The issue was, my lord, all along the same, my lord, which act will prevail, but here, my lord, the learned single judge has.
You have not raised that point before.
My lord, we could not, because your lordship kindly sees, there were these negotiations failed, and his lordship probably was on the view that there were several repetitions previously. These questions were raised.
But this point was not raised. It is not reflected.
I have annexed the writ petition, my lord, in the injunction application.
Petition, many things may be there, but if you don't argue at the time of hearing, then how can we take note of that? Because the learned single judge's order does not reflect any argument on that by Mr. Mukherjee. It has to be argued.
My lord, if your lordship kindly sees, my lord,
Because here it is a mixed question in the sense that it depends on whether there is a structure or not, right? So that will determine the applicability of the statute as per the Supreme Court judgment also, whether there is a structure or not. So that's a mixed question. So you had to raise the point.
My lord, if your lordship kindly sees, my subject to page 2, third paragraph, this court cannot enter into the same as it would amount to testing the disputed questions of facts arising out of the impugned order, which the writ court
is regarding
my lord,
manufacturing activity prior to 6 months.
Whether we have started the
yes, that is regarding that. That's actually a question of fact. Disputed question of writ court should not interfere. I mean, this is one of the plausible views, at least.
But in my writ petition, my lord, these grounds were there, my lord. And there was no affidavits were also called for, so that we can.
But the finding of the first forum is that there were documents, letters of the petitioner, your letter, dated 1st of July and 16th of April, to show that a structure existed on the leasehold property. Might be during the settlement you had stated that you had already started construction or something like that.
Let constructions we have started, we admit it.
Then there was a structure on the date of initiation of the eviction proceeding.
That, my lord, the date of initiation, that is on the date of the grant of lease.
Yes.
On the date of initiation of the eviction proceeding, the structure was there, my lord. This is an admitted position. But
that is what will determine the statute.
But on the date of grant of lease, whether there was any structure or not, my lord, that is the subject matter to be, my lord, to be decided. My lord.
Have you got a copy of that Act, 1976 Act? It has been quoted here. Let us just see.
My lord, I have only one.
Premises in itself. This is the premises tenancy act you have.
No.
7.
তাহলে
Volume
বলতে হবে,
7.
আমি দেখিনি
7, it is there.
This is 17. Volume 17.
না, 7
7 volume is it is there.
ভুল করেছি।
By now we know the definition of premises in the premises tenancy act. And we must also know the definition of this government. এটা না, এটা ফেরত দিয়ে দিন। এখানে একটা ডেফিনিশন আছে, দিয়েছে দেখুন। দেখুন থেকে দেখি টার্ম বেরোবে। tenancy held by tenant. দেখুন, টার্মিনেশন অফ টেনেন্সি হচ্ছে এভরি টেনেন্সি হেল্ড বাই এ টেনেন্ট in respect of a government premises shall stand terminated upon the expiry of the period referred the notice to quit. As on the date of notice to quit, এটা government premises should have expired. জাজমেন্ট হ্যাঁ, কিন্তু সুপ্রিম কোর্টের জাজমেন্টটা কি তাই বলছে কি ডেট? when the eviction proceeding was initiated, সেটা দেখছি। ওই দিন ছিল না স্ট্রাকচার, সেই জন্য বলে যে একটা কিন্তু এটা আউট বাই দ্য গভর্নমেন্টের ডেটটা দেখতে। হ্যাঁ, কিন্তু এটা তো মানে এটা ভুল আছে। কন্টিনিউস টু বি বেয়ার ল্যান্ড অ্যাজ ইন দ্য ডেট। ভুল হচ্ছে। Material date is the date. Mr. Mukherjee, apparently the contention, the bone of contention is very limited.
Very limited to the point, Lord, that my
Date of initiation of the proceeding, or
from the date when the lease is granted, Lord, is
Or the
that
date.
governing, Lord, the law that will apply.
but Supreme Court, this judgment which Mr. Sood has,
That, Lord, Sona Industries.
that is against you,
Yes, Lord,
because
that,
para 30 clearly says the material date is the date of
but
initiation.
there is also contradiction in that judgment. The previous paragraph.
This
That
paragraph
matter-
itself, I mean, this paragraph starts with thus when the eviction proceedings were initiated, admittedly the land in question did not contain the structure. Then if the bare land is let out by the government undertaking, but it continues to be a bare land, that is.
That is.
But which paragraph is contradictory? You see?
Lord, in fact, your Lordship read that.
But that
portion
says
is-
if we also thought initially that this was contradictory, but it continues. The sentence says if the bare land is let out by the government undertaking and it continues to be a bare land on the date of initiation
But
of
that
eviction.
is exactly where, Lord, it is cutting through my case. It continues to be. But here, Lord, it was at the inception, bare land
and
constructed.
Right.
At the time of eviction, it became a premises within the meaning of the act.
Mr. Mukherjee, the difficulty is the bit we have to see, because the language of section 3 is what we have to look at of this act, which has been quoted by the Supreme Court in this judgment actually. So the language of section 3, do you have a copy of the judgment?
Yes, I do
Yes.
have.
So section 3 quoted in para 19,
Lordship.
it says every tenancy held by a tenant in respect of a government premises
Lordship.
shall stand terminated upon the expiry of the period referred to in a notice to quit served upon such tenants in the prescribed manner. So the
Lordship.
date of the notice to quit is what has to be looked into,
Lordship.
not the date when it was let out. Because when I issue the notice to quit, I am the government. If I issue the notice to quit, on that date, whether it is a premises on government premises. Why the
Because,
what is
Lord,
your contrary argument?
Yes. Now, Lord, so far when a bare land is converted into a premises to attract the provisions of this statute, Lord, it contemplates that the premises must be owned by, Lord, the government, not by the private entity pursuant to, Lord, the clauses in the contract. I mean the lease.
This was a lease, not a
I mean the lease, Lord. That's the reason.
ownership of the government was retained.
No,
And
so
there
far
was a
as the
clause
land
under
is concerned, it is there. But so far as the structure is concerned, whether it can be said to be a government premises.
But 2G in the agreement clearly permits. Therefore, I mean,
That,
structure
that
is
again, Lord, we go back, Lord, to the Transfer of Property Act, the permission granted by the lessor, Lord, to construct. Now, after I raise the construction, whether, Lord, the premises that I draw there, then it becomes
the
a
copy
not
of
a
the-
government
copy of
premise.
the lease has been annexed here. Yes, witnesses. We have come to witnesses. There are 3 paginations by Mr. Shur. Probably one by Mr. Shur, one by your clerk, and one by the little boy who lives down the lane.
But I'm so sorry about that.
Page 65.
Page 65.
It's 65 again. Yes. We have come to 2G, in fact. 2G is the difficult clause in everything.
In everything. Now that, Lord,
For
it is
the
getting
tenant.
settled for some.
To start manufacturing.
Now, first, your Lordship will kindly have a look into, Lord, the schedule of the property. The schedule.
That should be.
But that is at page
Must be bare.
75.
Yes. Land.
Land.
Obviously, it was
So
given to you.
here,
for industry.
Lord, what it is contemplated that you have to. There is a particular purpose for this.
Yes.
Grant.
You want to. You have to build up an industry on that, and
yes,
for that purpose, it is given.
Yes. And now, Lord, they are applying, Lord, the provisions of, Lord, the premises. Government Premises Tenancy Act. Whether it should be the 62 Act, the land. The West Bengal government does have another provision
Yes.
for the bare land, that is 62.
62 Act. Where is the clause, default clause, that if you don't start?
Yes. That
Default clause is at page 69 and 72.
To start manufacture within 12 months, G. Clause G, page 69.
That is the clause whereby you have to start. But what is the default clause? If you don't start, then
72, page 72, you'll also kindly come.
72.
If it is non-used, my lord, then if it is, we start to see if it is, land is non-used or construction is left without for 6 months. Stop for 6 months. Then, my lord, the clause will apply. The big paragraph.
Not used.
If the demise premises is not used by the lessee for the purpose for which it was being demised within 12 months from the date of the presence.
It becomes into order. Or it's continuing so many hours. Yes, it shall be lawful for the lessor.
Yes.
At any time to determine the lease and re-enter upon demise premises. They are entitled to take back possession as per this clause.
That
if
is
you don't
not
start.
a condition of the grant of the lease.
Condition of the grant of the lease regarding a vacant land.
Regarding
at that point of time, it was a vacant land, no doubt on that. Now this, but now they want to exercise this clause by taking recourse to, because due process of law has to be followed. Therefore, whatever law is applicable on that date, on the date of initiation of the eviction notice, why shouldn't that be followed? Why
Because
should we relate with, because on that date it is no longer a bare land. So how can 62 Act
But also it is not a government premises in that sense, because the built up property is not belonging to me according to the lease contract.
Does it? Otherwise, they wouldn't have any option to take it back.
Yes, under the land, 62 Act.
No, they cannot take the land by.
No, the proceeding has.
It's not like a carpet that they take it out.
Not that. I mean the proceeding. The proceeding has to be.
They have to take the property along with the land, Mr. Mukherjee.
I understand.
They cannot take the land away from
all that I say, Lord, that they are entitled to compensate me for the structure because they are enriched. As of today, suppose I am in breach.
You will be unjustly enriched. You took a lease.
No, they are.
You did not make any.
But they took the
comments in
premium.
industry on that.
They took the premium.
Oh, premium was.
Entire premium has been paid in advance.
Since 95, but the government land has been given to the small industry.
Yes, they are not starting. Yes.
Not started,
What can be
and
done?
my lord, it was taken back
For
on,
people like you, we are suffering. The state is suffering.
and it's taken back
And you're
on
defending your client.
in 2000.
There's no industry, nothing. Don't you understand that
I
for
understand.
this, you are also responsible. You have to pay compensation to the state coffers also.
Ideally, I should.
No, but this is one of the plausible views, because by application of the principle laid down in by Supreme Court in this judgment. Now, because Supreme Court clearly says that the material date is the date of initiation of the eviction proceeding. As on that date, this property fulfilled the conditions of the definition of premises under this.
If your lordship kindly have a look into termination of tenancy section 19 in the judgment that has been quoted.
Yes. Yes.
Every tenancy held by a tenant in respect of a government premise shall stand terminated.
This is para 19.
Yes, in the para 19, the section 3 of the act is quoted. Terminated.
Yes, yes, yes. Please read.
Every tenancy held by a tenant in respect of a government premises shall stand terminated upon expiry of the period referred to in a notice to quit served upon such tenant in the prescribed manner. 2. A tenancy in respect of a government premises shall stand automatically terminated without any notice to quit where the tenant has violated the terms of the lease. This lease means not the lease with the government premises.
Yes, you
Then
have a point there.
subsequently built a house or acquired by purchase, gift, a house or an apartment either on his own name or in the name of any member of his family within reasonable distance from the government premises. This is not if there is an alternate accommodation. The apartment will have the same meaning. The family will have such and such reasonable distance. So this all points out, Lord, that when a government premises is let out, this act is applicable. This act is not applicable, my lord, in case where the bare land has been let out and subsequently built upon at the expense of, my lord, the lessee. And now they want to take it back with the accretion on the land without, my lord, compensating, my lord, the lessee.
The language is every tenancy held by a tenant in respect of a government premises. So the tenancy at the juncture of the tenancy, it is to be seen what it is given in respect of a.
And in 21, Lord, of that judgment, the definitions are given. Government premises means any premises which is owned by the state government or by the government undertaking, but does not include the official residence of any person authorized to occupy.
That is different.
Official residence.
This is not official residence
No,
of.
all that I mean to say is that, Lord, the purpose of this statute is, Lord, to get back, Lord, in a faster manner a government premises.
Yes.
Which means any building or hut and include part of a building or hut sit.
How do you overcome this judgment?
You
understand? Now we understand what you are saying. The language of section 3 is every tenancy held by a tenant in respect of a government premises. The moment you say that.
And C also, premises means.
C also, yes. No, C.
2C. That paragraph 21, 2C. Premises means any building or hut or includes.
Oh, that is there, yes, obviously. So
evidently, Lord, this particular
premises means any building or hut. It has to contain a hut. That has been held by the Supreme Court also. Premises means this.
Yes.
But every tenancy held by a tenant in respect of a government premises means it. But it can have two meanings also, Mr. Mukherjee, if you construe. Because every tenancy held by a tenant in respect of a government premises. Now, held by a tenant, when is it held? On the date of turn, this is because every tenancy held by a tenant in respect of a government premises shall stand terminated upon the expiry of the period referred to in the notice to quit, not in the on the expiry of the period referred to in the lease deed. If that was so, then it would be at the inception.
What
on the date of the notice may be it may be one of the possible interpretations that the date of the notice is the cutoff point, because on the date of the notice, that tenancy has to be held by a tenant in respect of a government premises. So on the date when the notice is issued, it says every tenancy held by a tenant in respect of a government premises. If it falls within the definition of a government premises, we are taking the date of the notice for the time being. The tenancy is held by in respect of a government premises on that date, on the date of the notice. It has become, by definition, it has become a government premises on the date of the notice. So if it is held by you it shall stand terminated upon the express. So the date of the notice may be one of the considerations, Mr. Maybe one of the plausible interpretations.
But I bow down to your lordship.
Your interpretation is definitely one of the valid interpretations.
Why I say this, Lord, if your lordship kindly comes to 2C, that is at paragraph 21.
2C, yes.
The premises means any building or hut and includes part of a building or hut and a seat in a room let separately. The letting out means here, my lord, that there must be a building or my lord, a hut or whatever that is there.
At that point of time.
That therefore it relates back to my lord the date of grant of lease. And the purpose of not this two Act 76 and 62 is not absolutely different. Two different situations have been contemplated
But
in
the
enacting.
judgment is very clear.
The judgment is not that is where it is not really, and I am before your lordship on that because we are very candid.
You have to be before different lordships for that. Not these lordships.
But if your lordship is convinced about Lord the interpretation that I am not trying to make,
what can we do?
But I'll just
circulate our judgments upwards.
No, Lord, I'll just
we'll pass a judgment and circulate it upwards. You can do that if you see.
But if your lordships are convinced that the interpretation given by the Supreme Court ex facie, Lord, it is contrary to the statutory, Lord. I am showing before your lordship, Lord, what the statute
you are in
says.
our position and you are convinced, what would you do? What could you do, rather?
I understand, Lord.
Seat as be ready at the point of ওটাতে আগেরটাতে প্যারা 93টায় দুটো ইন্টারপ্রিটেশন পসিবল বাট যে মুহূর্তে প্রবল যেটা দেখালো যে মুহূর্তে আপনি প্যারা 21টা 2 তে চলে যাচ্ছেন 2C দুটো রেড টুগেদার একটা ইন্টারপ্রিটেশন হতে পারে আমরা ডাউট এক্সপ্রেস করেও তো কিছু করতে আমি বড় যে ডাউট এক্সপ্রেস করতে পারি ডাউট ঘুরিয়ে ঘাড়িয়ে এক্সপ্রেস করলাম যেটা তো পারবে না. Yes, what do you say?
But yes, another,
let them finish then.
Very. But I was just beseeching your lordship, Lord, to have a look into Lord the contents of paragraph 24 onwards. That is, Lord, what it fell from your lordship was also Lord a point which was raised before the Supreme Court, or paragraph 20.
And turned down.
The turning down is that, Lord, your lordship will kindly see whether Lord paragraph 27 what it means.
Yes, 2A, exactly. That 2A, yeah, 25, extra 2C. And we are to go
25, and thereafter paragraph 27.
That conjointly with the definition. No, up to this, the Supreme Court holds had to be.
Yes, at the contradiction now
conjointly with 2A, not with 3. It should have been read conjointly with 3 also.
Lordship.
And rather 3 should have been read conjointly with 2C.
Lordship.
That argument was not made actually. Your present argument was. If completely implanting premises and obviously 2C. 25 is obvious. And in fact,
paragraph 27, last few sentences.
Yes. Last sentence. Now, therefore, we have no hesitation told that if the bare land is let out by the government.
And then comes, Lord, at paragraph 30, Lord, something which is not borne by, Lord, the previous logic that was, Lord, the court was pursuing.
Yes, you're right. You're right. Initially, I was wrong. 2C changes the complexion. I did not look at 2C. I looked only blindly at 3. But 2C changes the complexion definitely. And it was held to change the complexion in para 27 also.
And 27, that the last few lines.
Suddenly there was a distraction sort of.
Very clear on, Lord, that ratio portion.
There was some distraction in between. although it was in a negative sense, there was no structure in this case.
Yes, and thereafter, my lord, in paragraph 30, my lord, the Supreme Court says
That's
that he,
when the eviction proceedings were initiated, the land in question did not contain any structure. It would be squarely against it if it was a case where structure was then built and then. But this does not clarify the situation. There no structure all along. So probably the Supreme Court could reconcile between this and para
and
27.
para 30 is, my lord, where it goes directly contrary to what it was trying to say.
This sentence is very, damaging to your case.
Well,
If the bare
paragraph
land-
30 last
30, the second sentence also, if the
Yes.
bare land is let out by the government undertaking, two conditions, and it continues to be a bare land as on the date of initiation of eviction process, apparently not borne out by section 2C.
Yes.
The incidence of such tenancy cannot be, because 3 never gives any new definition. 3 says every tenancy held by a tenant in respect of a government premises shall stand terminated. So in the first place, it had to be a tenancy held in respect of a government premises, which is defined in 2C to say that let out.
Lordship. And the
You are
effect
right,
of it
you are right.
is, my lord, that they're taking my property without compensating Article 300A.
No, they are still entitled to evict you under. But
Well, even if they are entitled to evict me,
Mr.
not
Mukherjee-
so far as not the eviction from the premises without not compensating me, whether that is permissible under this act or not.
no, different aspect.
Because they are taking help of the fact that, Lord, this act presumes that the government premises is
the contract between you entitles them. This is a commercial contract. You are an industrial unit. Contract permits them to get back possession. They're doing it in due process of law.
True.
Now, what is the due process of law? That is to be, now, Mr. Mukherjee, but there will be then a conundrum, because 62 Act will also not be applicable, because as of today the land is not bare.
But that is the reason, Lord, Lord, even the Supreme Court said that if not the initiation of, Lord, this leasing out was in respect of a vacant land, but that act which applies at that point of time will apply. If there is a change of, Lord, the nature, accretions are made, that doesn't, Lord, change the nature of the tenancy to that of a government premises. If the premises was there at the inception, yes, 76
Do you
Act.
have a copy of the 62 Act by any chance? No?
Sorry, Lord, I
So do you
apologize.
have a
Lord.
copy of this?
But that is in respect of the land, I can tell you, Lordship. This
Yes,
is
because
in
that would
government
not be
premises.
applicable now. That is not regarding any government tenancy. Eviction of public land, eviction of authorized public land, eviction of
Unauthorized Occupants Act 1962.
So it has to be a land. There is no concept of tenancy there, like Public Premises Act.
Suppose a
71
squatter or roadside squatter.
That is the counterpart of 71 Act.
71. Yes, but 71 Act, Lord, it not only contemplates, Lord, the land and structure both, and here, Lord, there are two.
That is the difference.
Yes.
Premises and land. The rest of the name of the SIT is also same. And we are both conversant with the 71 Act because of the port matters. Both of us were on the panel at different times, and so we got pundits on that. But the language is same.
Language is same. Lord, your Lordship may kindly.
So therefore, they cannot apply that act now.
No, here the land definition, your Lordship kindly sees.
But that does not contemplate a tenancy or lease. That has to be a land on the date the proceeding is initiated. Oh, acha, land includes buildings and other things. Oh.
But আরেকটা বার করে দাও পাসওয়ার্ড লাগে না মুখটা দেখাই দিতে
না এটা হচ্ছে এই পাবলিক ল্যান্ড এভিকশন করা But then what would be the distinction with the 71 Act, Mr. Mukherjee? The 71 Act pure premises. And
the
here
71
land
Act,
public premises eviction of another.
Land and premises both. But because there,
but this also has the same definition, then which act would apply?
But I say, not in this particular, if it belongs to the central government, 71 Act. If it belongs to the state government, 62 Act.
This is a counterpart of that.
Yes.
Right. You have a point there. And what else? Apart from this applicability of this act, then the proceeding goes.
Otherwise, my lord, there is a resumption, my lord, a notice which was given, my lord, on August 2025.
You have not started the construction. Why should technicalities come in
No,
the
it
way?
is constructed, three-storied building, na?
Subsequently, not within 12 months. Under the contract, they are entitled to eviction. Premises. এইটা হচ্ছে এই জায়গাটা হচ্ছে প্রেমিসেস জায়গায় ল্যান্ড হচ্ছে 62, এখানটা শুধু ল্যান্ড আর এটা হচ্ছে 62, আর বাকিটা একটার নামটা একই। আপনি লিখে একটা ইয়েও পাঠিয়ে দিন।
আর একটা কপি দেন না তো কেন একটা উনি দিলেন ও আচ্ছা আচ্ছা আপনার কাছে একটা কপি আছে
দুটো দিয়েছেন
ও আচ্ছা your lordship will kindly turn to lord the third page of the lord the three-page document handed over but only to answer your lordship lord whether there is a construction or not and what were there.
Yes.
So at the time of resumption lord they made an inventory. Even the bare minimum inventory lord speaks of the fact that what were contained there.
G+2. But that was made later on. Not within 12 months.
No, that may not be. It was, but within the extended time.
They extended the time.
Yes. Approved plan is there. They have extended it.
Direct affidavits. All the documents should come on record. Cannot. This is not such a matter that we should decide. There was no direction for affidavits ever.
No, this is the first time hearing.
But you have already taken possession, you were saying.
I've already taken possession.
You have got the documents. How soon can you file your affidavits?
But let them not lord give it on lord to some other person.
Otherwise, well, they have taken the possession. They have taken the land for several years. They couldn't construct as per the.
No, today if they lord.
As per the.
If you create a third party.
Yes, that is.
As per the document, as per the lease deed. Well, they have your your lordship's judgment is there, but rewrite the contract is well, they have taken the.
No, my judgment is not ready. Court cannot rewrite the contract.
But the contract is there, my lord. We can take possession if you don't construct. So there is no question of whether either you shall give compensation or not. So such and such. Your lordship kindly see your lordship.
But under which act? You resorted to a particular statute. Therefore, you admit tacitly, not even tacitly, openly, that you have to evict them by due process of law despite this clause.
Whether the applicability of act is there, 3-1 notice is given.
If the act is not applicable,
you have given them.
If the act is not, you have admitted by giving a notice that some statute has to be followed by you. You cannot just evict them.
Supreme Court judgment clearly says that para 30 that if the construction is there at the time of initiation of the proceedings, this act applies. Therefore, the application of the act.
It is couched in a negative language. It says initially it says that the point of letting out, and then it says that even if at the time of filing of the eviction, giving of the eviction notice, there is no construction, then it won't come. It's in a negative way.
The ultimate paragraph is 30. Supreme Court is clear.
30 Supreme Court says that if there is no construction at the inception and
if there is a construction on the date of the initiation, well, we have given them notice, take back your property, give us land, but we have given them enough time.
You cannot reconcile sections 2 and 3 despite the Supreme Court judgment. The judgment is there.
For repetitions, all the repetitions, court has given them chance to go and negotiate. They went to us. We have given them proposal. At that time,
when did you take this person? You took this person in
2025, 8th August.
August.
Whether
now we are in November. December. We have December started. So for 4 months you have not parted with.
The question is this: in a government property, when it is vacated, it is as per the government decision. You have to give it to the other.
Have you given an advertisement or given a notice inviting?
I don't have, but maybe it has been given because immediately we have to put it on the in the website list as vacant land.
And Mr. Mukherjee, another thing, this is a public property. I mean, this is an industrial estate. Granting an injunction has been deprecated by the
money they want. My client is willing to.
We have given. I'm giving to a lordship.
That exercise is over because thrice it was undertaken.
Justice Sanjeev Banerjee has given them.
Thrice. So Justice Sanjeev Banerjee appeal.
Thereafter, Justice Mantha has given them opportunity. They have went us. We have given them enough.
First, let them pay your fees and Mr. Shoot's fees, then they because thrice this has failed. So we never know what happened previously.
Your
We have
lordship will
given
kindly hear
technical-
the appeal, my lord, any day, my lord. I think the documents which are before your lordship will be sufficient until unless my learned friend says that something more to be added.
Documents are not there because
Which document is not
Lagre.
tell us?
so two letters are there, whether they at the time.
17th, yes, 17th. That is very relevant.
That is very relevant document.
Please bring those letters. Come back
Well, problem is
next
this,
Monday.
It's a old file at that initiation. Well, I have to search the old file. Is very the old file is
Old file matter is appearing in the list for
tender.
quite some time.
Well, before
Matter is
that,
appearing in
well,
the list
before
for
that,
quite.
before that, my lord, the order has been passed. The record order has been passed. They have to
No,
immediately.
this matter is appearing in our list for long.
I know that.
Some months.
I know that, but after
It should have been prepared by now, taken instruction. Matter is appearing in the list. You are not.
I have to collect the documents.
Collect the documents tomorrow.
Tomorrow,
Ask your officers to come tomorrow and bring the
tomorrow,
documents.
but it is not.
Day after tomorrow.
Yes, give us at least 7 days time. I cannot give. Well, the question is this, but I shall file an affidavit annexing those documents. But question is this, but question of passing an interim order is very difficult.
Very well. Come back on December. We are not directing affidavits. Come back on 9th December. We'll after a week we'll decide the matter.
As your lordship.
Because that is the next. Every Tuesday we'll take up these matters first.
As your lordship. I saw.
We are not making it part-hard, Mr. Mukherjee, because again, if the bench changes for some reason, we are in difficulty. This will appear under the same heading. So we'll take these matters up on Tuesdays.
But in the meantime, let them not do, my lord, something. Kindly
That
take
will
it
also have done something public property, Mr. Mukherjee. We are also hesitant to pass any interim order. Either we set aside this or interim order. During hearing, it transpires that several documents, particularly 2 letters which were referred to in the order of the first authority, are necessary for a complete adjudication of the proceeding. Accordingly, learned counsel for the parties are requested to take instruction and furnish copies of all relevant documents at the on the returnable date upon exchanging copies with each other. Please, whatever documents you rely on, either party, please exchange copies between yourselves.
And I request my lord, this is their letter. I think they have the office copy.
Do you think they'll produce that letter? Seriously think that. That is the premise of the impugned order.
No, that letter that we have started construction.
Yes, they'll produce that. They'll never produce that. You produce that. Your authority relied on it. Whatever if they want to rely on other documents, please exchange documents before producing.
I shall try.
Mr. Mukherjee, you also exchange documents. Whatever
it is already exchanged, but it is in the application.
Very well. The matter shall next be listed on December 9, 2025 under the same.
Okay.
Please take this back also. You put it in a compilation and exchange with them and file it together.
No. Maybe at 2 o'clock.
Let it be in the list, Mr. Mukherjee. If you are in difficulty, we'll consider on that day. Maybe the other bench will not sit. If you want, we can fix it at 10:30 sharp.
Nowadays, I am better performing, blood.
I don't believe it.
Trying to improve.
Instead of 11:20, maybe 11:05.
Now 10:45.
10:45 is early morning for you.
Great.
Please try to gather whatever documents. Next. Oh, 4:24.
My lord, I appear for the
Yes.
appellant. My lord, this is a mutation in respect of a Salt Lake property.
Right.
My lord, mutation has been.
Go for the other side.
I am appearing for the
You have been sitting since the morning.
No, the only thing on account of spondylitis, I cannot move my. Yes.
Please take your seat and argue.
Yeah, let my junior argue this.
Oh, yes. Definitely.
Help us leave.
She is no longer a junior. So she has a right, in her own right, she can argue, lead others. Yes,
My lord, the impugned order against which this writ petition was made, my lord, is at page 119. My lord, may I place the order?
Yes.
This matter has been taken up pursuant to an order passed by Honorable Justice Pinaki Chandra Ghosh in WP number such and such. In his order dated 18 March 2008, Honorable Justice directed the respondent number 2, that is the Principal Secretary, Urban Development Department, such and such the writ petition by passing a reasoned order after giving an opportunity of hearing to the petitioner within 6 weeks from the date of communication of this order. I'll straight away come to the next paragraph. On the aforesaid date, Sri A.K. Roy Chaudhary and Srimati S. Roy Chaudhary learned counsels appeared on behalf of Srimati Gayatri Devi Gupta. They stated that Sri Sushil Chandra Chattopadhyay was recorded lessee of the plot number 121 in Block AE, Sector 1, Salt Lake. Sri Chattopadhyay died on 3rd September 2005, and before his death, he executed a will on 6th July 2005, bequeathing his right title and interest in the said property in favor of Gayatri Devi Gupta. The said will has been duly probated in PLA number 10 of 2006 by an order of the Honorable High Court at Calcutta. Thereafter, Sri Dinesh Kumar Goyal, executor of the will, and Srimati Gayatri Devi Gupta, being the beneficiary, submitted a prayer on 28th June 2007 for mutation of the property in her name and in place of late Sushil Chandra Chattopadhyay. Thereafter, communication was sent by the Learned Council on 27 December 2007 for recording the probated name of Srimati Gayatri Devi Gupta, which has not been done so far. They requested that mutation may be done in favor of Srimati Gayatri Devi Gupta in terms of the will. Learned Council showed the original probated order of the Honorable High Court. I have perused the record. It appears that the plot number 121 in Block AE was leased out to Sri Anil Kumar Banerjee by a registered deed executed in his favor on 25th June 1972. Possession of the demised land was handed over on 13th May 75. Thereafter, on the strength of a registered deed of transfer, the plot was mutated in the name of Sushil Chandra Chattopadhyay in December 1976. Though as per clause 26A of the lease deed, the lessee was to construct a building on the demised land within a span of 3 years from the date of possession, no action was taken by him for construction of the building and the land remained vacant. Notice to remedy the breach was first issued in 1991, but no action was taken by the lessee for the construction of the building. Thereafter, notice was again sent to the lessee to remedy the breach on 19 September 2005. My lord marks the date because the lessee already expired on 3rd September 2005.
Yes.
3rd September 2005. But there was
What had expired on 3rd September?
the person who has given the will, executed the will in favor of Gayatri Devi Gupta.
It was given
The recorded lessee of the
this was given to a deceased person.
Notice was issued to a deceased person. Issued. But there was no response to the same. Thereafter, notice was sent asking the lessee, that is the deceased lessee,
Yes,
to appear on 12th October 2006. But again, there was no response. Thereafter, on consideration of the matter, it was decided that the government to cancel the allotment under clause 4 of the lease deed and to resume the plot wide order number such and such dated 15 January 2007. Therefore, the matter as the matter stands, the plot number such and such Salt Lake stands resumed by the government due to violation of the lease terms. Consequently, the plot no longer belongs to the lessee. In view of the fact, plot number 121, for which the allotment has been cancelled and which stands resumed by the government and no longer belongs to the lessee, the mutation of the plot in favor of Srimati Gayatri Devi Gupta cannot be considered. My lord, let me place, my lord, the judgment and order against which I am before this.
Ms. Rashid will continue next Tuesday because we take up these matters on Tuesdays.
My lord, before my lord rises,
Yes.
I think, my lord, I should place this order, my lord. When the matter was moved,
Yes.
my lord had directed them to file the affidavit in opposition by disclosing whether the notice under clause 4 has actually been served.
They have not filed any affidavit.
No, they have not filed any.
Draw adverse inference. Just give a notice to them. We will request your learned junior to give a
Yes,
notice to. In
I
the
should.
meantime,
I should.
at the although the hearing is commenced, it cannot be concluded due to paucity of time today. The next para, learned senior counsel appearing for the appellant submits that despite a previous direction of this court, the respondent has not filed any affidavit in opposition to the Any affidavit in opposition disclosing the relevant documents. Full stop. Next para. Be that as it may, comma, the learned advocate on record for the appellant is requested to serve a notice on her counterpart appearing for the respondents, indicating that the matter shall next be listed under the same heading on December 9, 2025. Full stop. It is made clear that in the event none appears for the respondents on the returnable date, when the matter is next called on for hearing, comma, and or no affidavit is filed on behalf of the respondents by upon service of prior copy to the appellant, comma, the matter may be proceeded with ex parte in the absence of the respondent and decided accordingly.
My lord, one humble prayer. The interim order was till the next date of hearing, my
The
lord.
interim order granted earlier is extended till disposal of the appeal.
I'm giving to lordship.
Application.
My lord, the application, my lord, there is no indication, but my application is pending. Affidavits were directed to be filed in the
Till
application.
disposal of the application. I will decide the application along with the appeal on the next.